Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. Good morning, my lovely peeps. Oh, my court junkies. Good morning. Good morning. I hope this finds you well. I'm here. I've been here, but I'm not awake yet. I haven't had my coffee. My machine overfilled it again. Good morning, Toxic. Good morning, C. Morales and Cat. Karate Cat Mom and oh, sunny day. It's not a sunny day today, y'all. It is not sunny day today. It is blistering cold out there. It is a balmy 18 degrees here where I live and getting warmer. It was at one point 14 degrees. Today we will get above freezing for about an hour or two, and then we are back down, and we'll be back down into the low 15s and 14s. Wind chill factor feels like 0. Guess what, y'all? It's cold in this state. I feel sorry for everybody living north. Heading to doctor's appointment for my... I'll be praying that goes well. That was Banji? That was you, Toxic? Holy snipe! How is he? I knew that one of RA's mod's husband, but I didn't know that was you. Oh, thank you, Jesus, even more so. But thank you, Jesus, he's alive. Was he injured? I hope not. Would love to interview him. But must be a very terrifying and horrible experience. And my prayers go out to him and to you. I know that this must have been something very traumatic, and that it's going to take some time for y'all to get over. Oh, I bet. I bet. Oh my gosh. Prayers to everyone. Oh my Lord. We never know what's going to happen in our days. I know. I am channeling EDB today. I've got the Law Nerd, one of my favorite cups. Oh, I'm sure he wouldn't. And then the Law Nerd t-shirt, sweatshirt. I don't own any really sweatshirts other than this one. Toxic. He needs to talk to a professional about it. He's probably got PTSD. He needs to deal with that trauma when he's ready. But OMG, prayers. We probably watched him get off the plane. I was watching it. But I'm in Temple, Texas. It's 17. Looks like the clouds are setting in on the ground. Well, darling, it's cold. It's warming up. We got down to 14. We have wind gusts up to 35 miles an hour, which is making it wind chill of 0. Well, Toxic, prayers. And thank you, Jesus, for keeping everybody safe on that plane. And that was one hell of a pilot. I know there wasn't a whole lot he can do, but there was a whole lot he could have done that made it worse. And he was wise enough to not do some of that stuff. So, I don't know if please understand, I respect everyone's faith. I respect everyone's beliefs, but I will say a big thank you, Jesus. That's how I believe. Toxic. Oh my gosh. Wow. Well, love you, girlfriend. We're here for you as always. Y'all take the time you need to heal, take care of him and you and your foot, and just know that we're all here for you. And my mind's trying to wrap around this. But thank you, Jesus, he's okay. Yeah, prayers for everyone involved. We had a really eventful, crazy day yesterday. We started off with the Karen Reed trial, okay? Good morning, Penny. We started off with the Karen Reed trial, and it was weird, to say the least. Let me get to my descriptions because I kept notes. I thought I did. Oh, shoot, they didn't save. No, the separate one. Maybe it was only Karen Reed trial side. But we had a lot happen. We had the Karen Reed motion. That started us off. There it is. They had a motion for records. Both sides did finally agree on that motion for records. They said that both parties would have the papers or whatever dealt with by March 1st. Order to schedule, scheduling order to amend was what that was. Then they had paper 483, motion to compel production of sound copy for video custody, motion for, prohibix, I can't say that word. Then they had a motion, for paper 489 to defend the audios. You got that right, Toxic. Oh my gosh, boy, do you have that right. 400 paper 490 motion for 14 and 17 for independent testing and analysis in the driveway of the parents and Karen Reed's Lexus. They were Rule 14. I need to edit that. They want to be able, they being the prosecution, wants to go over to the Karen Reed family's home and do an investigation and reconstruction, I guess, or something on the driveway because that's where they picked up her Lexus. Paper 493, the defense motion to reconsider reciprocal discovery order. Paper 495, motion to compel discovery. The court went into recess. Then they suspended the day to return on February 25th at 11 a.m. It was suspended because of this. I'm going to reshare it because we are waiting for the trial to begin.
Chronology, I think Your Honor should be aware of. If I could add that right now.
Did she say 11?
Less than a minute. The chronology is just
Let me back that up just to make sure I understand.
to engage. The original materials are still protected. This was a change in position about whether a party could engage.
And
On February 11th, we filed the motion to exclude.
And it hurts the defense. Why? Because now they're going to have to pay them to be an expert witness. And they can no longer say,
Mr. Jackson.
okay, yeah, how this information is received by the jury.
The 13th, the defense provided us the emails that I read, February 13th, 2025.
The defense provided,
oh
snap.
Defense, February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it?
These have been kind enough in the past to allow. So for that reason, I'm going to suspend today so that when we meet again to address the
Here we go. I want to hear
Y'all.
why we're suspending today. Pause that briefly.
may have profound
Oh, shoot. This may not be good. I'm nervous for this now. The judge was pissed. y'all.
Attorney General's office. This video.
I'm trying to figure out where we had the conflict. I'm trying to find it.
On page 2812 and 2813 of June 10, 2024.
wow. He's throwing a lot of shade.
Now, having some familiarity with the federal government, seemed to me, based on my limited experience, there was much more to the story. So I called
Here we go.
the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed the TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been for the last.
So this is about. Sorry, this is. I got sound going off on both sides of my head. This is about the defense being able to, if I understand it right, it's the defense being able to. Why am I hearing all this echoing? Oh, that's why. Being able to, the defense, I didn't realize I had 3 windows open and my voice was on all 3. That's kind of creepy. So the defense is fighting to be able to cross-examine the witnesses and catch them in, catch them lying. And so they're not wanting to give over all of their evidence and concerning to the cross-examination for impeachment. Now, there are some laws that state basically that the defense does not have to turn over all evidence concerning impeachment, because you want to be able to catch the person on the stand being inaccurate or lying. Prosecution wants everything so they can preempt the defense. The prosecution witnesses. This happened with Jennifer McCabe because Jennifer McCabe, the defense believes that somebody was watching the trial or listening and watching, either through the internet or in person, was watching the trial and preempted the witness about Jennifer McCabe, about her going over to another person's home. I forget who it is right off the top of my head. And her being able to adjust her testimony to account for that when the question was not asked about that. So this is very much splitting hairs, but something happened and I want to see if we can find
Trial,
out
reading the
what.
transcripts, I only have a flavor for the last trial.
That's
So there is
our-
email correspondence between the defense,
not our problem.
not only the federal government, but the ARCA witnesses. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the
Talking
phone with me
about
this
ARCA
morning.
right
Pursuant
now.
to our conversation, please feel free to forward an engagement letter to this email address.
That's
I will
right.
get that countersigned and returned to you forthwith, along with your retainer as required. Commonwealth,
We're
as I
getting to that.
understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: Hi, Alan. Subsequent to our conversation on Wednesday,
Here's
the
where we
U.S.
get
Attorney's
into the
Office
crash
asked me to
daddy.
pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and Commonwealth should have an even playing field.
Oh.
Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
So do it again, Sam.
Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get it.
So Brennan is accusing the defense of having inappropriate communications about testimony. And he said that did I hear that right? That this information was not provided to the prosecution by the defense, but by the feds.
As much information as I can. We then are provided an
Whoa.
outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated.
That's
It's not dated.
Whoa, this is
The
bad. y'all.
TUI request is a recent February response, but they send random documents. There's no real accounting.
This
Now,
is huge.
I'm not saying that undermines the conclusions of ARCA or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over
It sure
a
does.
lot less in this case than this. Another comment. Would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians.
It is
Pretty
annoying.
important stuff in this case.
Good morning, Todd.
And then he comments, if you don't want me to say this, that's fine. That's fine. Shh, don't tell them.
This does not look
Have you
good.
qualified as an expert in
This-
court before? Yes,
Look.
I realized my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question, my fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up.
It is
And
now.
then a bill from ARCA to the defense for $23,925. That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts.
How much you want to bet he
Illusions
wins
and
this
shields
one?
and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the
Then why
Commonwealth,
do you
like
care?
the defense, is entitled
We'll see
to
that.
discovery. So if they can produce the
You want
discovery,
to talk to
I
jury?
welcome ARCA.
All right, I'm going to take a recess before the response.
All rise, please.
Whoa, potty break, stretch break. Auntie Bev is very pissed off right now. Auntie Bev is not a happy woman. Auntie Bev is smart to have taken her break. Very much so. I want to hear what she says when she comes back because I want to hear word for word. And then we'll talk more about it. He is and he isn't. There are rules, and the prosecution may have nailed the defense on breaking the
All
rule.
right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel.
Oh, shoot.
So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you.
Okay. So, Auntie Bev is gravely concerned for the defense or the defense lawyers. This is huge. I'm not a lawyer. I can't tell you how this may affect them. I am kind of researching it, but from what I understand, that is inappropriate. That number one, this communication happened, and number two, that this communication not only happened, but was not turned over to the prosecution by the defense team, but instead by the feds. This is huge. Sometimes it could be something in innocence, something, you're contacting a witness that you are going to be having on the stand. You have a right to talk about that testimony. That's not the problem. I think a large problem is they did not turn over the evidence to the defense, prosecution. The defense did not turn the evidence over to the prosecution. It was given to them by the feds. Yeah. Yep. That's a no bueno. And I think Bev is taking the right step. I don't agree with her a lot of times, but given time for the defense to mount to his defense of this action and what had happened and this communication. It's horrible. Well, that's right. Oh, thank you. I was going to talk about that. I'm not awake yet. I only got 5 hours sleep. Then, after all this was said and done, Brennan misspoke and it wasn't from the feds, it was from the defense, gave him the emails. So there's a lot going on here that I can't break down for you, but I will say this. I truly don't think Jackson would do anything, I agree with you 100%, to ruin his reputation or to lose his license or get sanctioned. But I think that Auntie Bev is really mad and taking a break, and she's smart with that. It's crazy. I don't know. I don't know. We have this trial here that started. We also have the Cemetery trial. I am hoping that this trial will be a little bit faster moving. 6 degrees tomorrow morning. 2 hours ago, it felt like it was 6 degrees in Kerrville. Sorry. 6 degrees, and just west of us was 0. We have a bunch of local San Antonio stuff hitting the news. We have a man who's accused of shooting, trying to unalive 3 San Antonio police officers in 23, finally coming to plead. Okay, the day 13 of the Cemetery will start at 11. Well, it is currently 18 here, but with the wind being that of above 35-mile-an-hour gust of wind, it feels like 0. Yep. I'll be honest, I ended up sleeping here at the shop last night. We do have a bed here. Because I was worried about it being so cold and we have to go across a bridge and to get here, even though it's only a mile or something from my home. And I was afraid I wouldn't get awake. I wouldn't wake up. Unfortunately for me, I have, I had gone to sleep last night at about midnight, and I was a little anxious because I knew I had to be here early. And so I go to sleep at about midnight, and then my dog at 1:30 wakes me up to go potty. Waste of my nighttime meds, that's for sure. Decides while she's going potty that it is cold and brisk and she's feeling frisky and got the zoomies. So I'm standing at the door trying to get her in without waking up the neighbors. And she is doing massive zoomies in the yard. And I'm like, you've got to be kidding me. This dog is doing zoomies in the yard at 1:30 in the morning. I'm exhausted. All I want to do is go to sleep. And I go back to bed and I couldn't go to sleep. That sucked. Haven't we all had nights like that? I could not go back to sleep. So what did I do? I came back to the shop because I realized the weather was going to get really dicey. And not to knock our weather people, but it is not uncommon for with the humidity as high, I mean, the temperatures as low as they were, and the humidity being a little bit on the higher side. It's not that we're going to get any rain, but the bridge goes over water, which is humidity, which means ice. So I then decided to come here, and I did, and I'm glad I did. And now we are here. Okay, we are still waiting for that trial. Toxic Orchid announced here that her husband was on that flight in um Toronto that turned upside down. Toxic is the owner of Discord, which we absolutely adore, and she's a mod over here, and she's a mod over at another channel, and I had no idea yesterday that her husband was on that flight. She said he's not hurt, but he has whiplash and he's traumatized. I would say he would be. Yeah, I'm with you. I don't mind driving in snow, but ice is another problem. Snow doesn't scare me. Ice is what we get. And when we get snow, it's usually ice, a little snow, then it warms up enough for it to become ice. Then it gets cold, we get a little snow. So, what I call a snow ice sandwich. So, I don't mess around when we get that icy conditions. It is not safe. But as a first responder, I've been out in that way too many times. But anyway, back to Toxic. So, Toxic recently had foot surgery. She's been healing from that. She is on her way to her foot doctor. And then, by the way, I'm not sharing anything she hasn't shared publicly. But today she shared with us that he kind of jokingly said maybe I wish he would I could interview him. But she said, and I know he's pretty shaken up. And so I would never try to re-traumatize him anymore. I suggested that he go see a counselor and get some PTSD trauma counseling because that experience is a doozy and very traumatizing. So I will not be playing any more film footage of that airplane. I'm sure she's seen plenty of it, but you never know how close to home these incidents can affect you. And, here I'm in Texas, and here we have a connection to a survivor of that crash. So, no more playing of that video. I don't want to re-traumatize her or him, but please keep them in your prayers as they walk through these difficult times. There were plenty of people that I keep. There's a lot of things that pilot could have done wrong to make that crash work. There's not much anything worse. Oops, sorry about that. There's not much anything else he could have done to save that airplane in those conditions. So with that, um, kudos to the pilots for keeping them from getting worse, keeping things from getting worse. Oh, I gotta go do Discord. I didn't do Discord this morning. Y'all, we do have a Discord, and I hope that y'all will go and visit said Discord. I gotta get my son to open up the shop. So, because of the weather, we are not opening our shop until 10 o'clock in the morning. Yay! He gets another hour to sleep. And then we watch what was that trial? The ASAP verdict. And y'all, that was insane. He dove over the bar to get to his family when he was found not guilty. I could not believe what was going on. That was insane. And he was found not guilty. What was really more insane was the fact that when he was found not guilty, he went for an interview and the news media all but pulverized him, trying to get to him and pulverized each other. It was crazy. Just a crazy day. So that is where we are. I am all caught up on everything. Oh no, wait a minute. So we went from the Karen Reed trial to this trial. This trial yesterday was a ton of information on a ton of information on the sorry guys, I am trying to set up my all my little windows that I need to set up. There we go. So with the murder trial, Rose Petal murder trial, um, they had a phone expert up on the stand most of the day, and this poor guy was put through the ringer, but he testified a lot to the fact that there was a lot of encrypted communications on the phones. They use WhatsApp, which is an encrypted app, and sometimes they can get the information off of it, sometimes they cannot. And then what they do get off of it is usually jumbled, and that is true. Um, that there are several apps that are encryption apps that people put on phones. Most of the time, people only do that when they're doing something they shouldn't be, whether it's an affair or inappropriate relationship or committing a crime. So, I'm gonna start that this morning. So we listened for hours about encryption and about how the phone when the video of I'm sorry, that's not this trial. That was a Cimatilli trial. We watched so much yesterday. In the Cimatilli trial, we're talking about the phones and that. So they were up with the expert all day long. Um, and she was coming out of Target on her cell phone. They were able to they were able to verify that her phone was connected to the IP address of the security camera system that is located in the garage of their home. That is a direct link. That was not her being able to hop off a Wi-Fi to connect. It was a direct connect from her phone. So she was watching the security cameras system in her home. Another reason why they know that was happening was because the amount of data usage coincides with watching a movie or video or live streaming. Now, in this case, we are going into now. There was a lot of nothing. We had a lot of breaks. We had a lot of sidebars. I don't even think we had not even a full hour of testimony yesterday in this case. The jury was sent home because there was a lot of legalese that needed to be dealt with in this case. So we did not get very far at all in this case. So yesterday it was Karen Reed, a little bit of this case, a lot of the Cimatilli trial, and then the ASAP, whatever his name is. I'm sorry, I don't remember, Rocky or something like that. Jury verdict of not guilty. Now we are all caught up. We do not have sound in the courtroom yet. Yeah, well, you know what? I gotta be honest, there's a lot of plane crashes that's happening out there that were happening before we got all this. Social media has made it easier for people to know about them, and it also depends on how well the companies and the powers that be keep things quiet. We don't have that luxury anymore. As you could tell, a lot of the people that were on that plane, as soon as the plane flipped, started recording on their phones. So now we are able to see a lot more than we have been used to seeing in the past. Oh, I'm sorry. I'm getting my feet up. I'm getting comfortable. Hopefully, we will have a decent day of trial.
May I please the court here on the defense call Zach Hughes?
They're calling the defendant.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please be seated. Please state your name for the record.
Zachary David Hughes.
Zach, how old are you?
I'm 32 years old.
Are you married?
No.
Do you have any brothers or sisters?
We may be going to jury
Yes, I do.
duty on this today.
Tell this jury about your brothers and sisters.
I have 5 brothers and sisters. One is my biological brother, Eli, and the rest are my adopted siblings.
At one point,
Love how you
have
don't
6
describe them.
siblings.
Yes, I did.
Talk about that in a minute. Where were you born?
I was born in San Luis Obispo, California.
Did you grow up in the entirety of your childhood in California?
No, I did not.
From California, where did you and your family move?
We moved to Southwest Virginia when I was 11.
While you were still living in California, did you discover that you had an aptitude for music?
Yes, I did.
What, if anything, did your mom or dad do by way of an instrument to help you learn how to play music?
When I was maybe 4 or 5, my dad found an old Gulbranson upright piano at a yard sale, and he bought it for, I think, $300 and rolled it down the street to our house. So I had an instrument to tinker on when I was young, even before I started piano lessons.
Describe, just in general to this jury, what was your, while you were in California and early on in Virginia, what was your home life like? What was it like to grow up in your house?
Siba, thank you so
I had a great
much.
childhood.
June, you
I
were
have
just
great
gifted
parents.
a membership.
They
Oh, Siba, you
they
just got
raised my
extra entries
biological brother and
into
I
the
before we adopted
giveaway.
in a Christian household. They taught us good values, the importance of good morals and service to others, and they supported me in every way imaginable, and I'm very grateful for them.
And Zach, you may want to back up just a little bit from the microphone. I think we're getting just a little bit.
Okay.
Yeah, that's a little bit better. Thanks.
Which means I'm coming along.
Describe for the jury, you talked about your Christian values in the household. Describe for the jury sort of the, early on at least,
Don't
the
use
connection between
Christianity to
your parents
qualify you as
supporting
a
you,
good
playing
person.
music, and
I don't like it when they use Christianity to qualify someone a good person. You can call yourself a Christian, etc., and be a bad person. Hello, Angela. Yay! Thank you for showing up.
Yeah, originally when I was 9, my parents started me on piano lessons. Our pastor's daughter taught piano lessons, and my dad wanted me to play hymns and family devotions.
you testified earlier that you and your family moved to Virginia. Tell this jury where you and your family moved in Virginia.
It was a town called Abingdon. It's right next to Bristol, Virginia, which is known for the NASCAR Speedway.
Whoa, Bristol, Virginia, national. Dude, get your crap right. Bristol Speedway is in Bristol, Tennessee. The NASCAR racetrack is not in Bristol, Virginia. How do I know? I was freaking born in Bristol, Tennessee. Oh, congratulations for being a member for a whole month. We appreciate you.
What your family's residence was like. Where did you live, and sort of describe that dynamic?
We moved to a small 3.5-acre farm. My parents liked the idea of raising some farm animals and giving my brother and I the opportunity to do physical work on a farm, and just the opportunity to be close to nature and grow up understanding the value of hard work.
In 2005, did your family grow beyond just you and your brother and your parents?
Yes.
Describe for the jury how your family grew in 2005.
The church we were a part of at a time really encouraged adoption, especially for families or couples who weren't able to have kids at that point in their life or at all. And as a result of this belief in the church that it was good to adopt, there were emails that would be passed around occasionally. And there was an email that was passed around with a photo of 5 Russian siblings who were up for adoption in Russia. And my family saw these photos, and our heart really went out to these kids. At first, we thought they were all boys because their heads were all shaven for lice, and they were all wearing sort of the same kind of clothes, hand-me-downs. But they were 3 girls and 2 boys. And after a lot of prayer and thought and discussion about it, we decided we wanted to adopt these kids because essentially if we didn't, who would?
So, just
Make
briefly,
an order
let's talk
of
about these
yourself.
kids. How old was the oldest child at the time your parents adopted them?
She was 10.
What was her name?
Her Russian name was Yelena, but we gave all the kids American names. So her name was Grace when we adopted her.
So Grace was 10.
Of course,
How
it
old
would
was
be
the
great.
youngest?
18 months.
We're going to come back to them in just a little bit. At some point, did you and your family move to South Carolina from Virginia?
Yes, sir.
Yes.
How old were you when your family moved to South Carolina from Virginia?
I believe I was either 15 or 16.
Where did you and your family move in South Carolina?
Raleigh.
We moved to Travelers Rest in Greenville County.
During this time, describe for the jury what is going on in your music progression, your life as a musician, and how you're progressing.
Good morning.
Like I said, I started piano at 9, and when we moved to Virginia, I became increasingly more interested and motivated in it. So by the time I was 14, 15, I was practicing on average 6 to 8 hours a day. We were homeschooled, so this allowed me to do this. And by the time we had moved to Travelers Rest, I was very convinced that I wanted to pursue music as a career.
You testified you were practicing a lot. During this time, did your father do anything to provide the rest of the family some peace while you were practicing so much?
Yes, I like to practice late into the night and into the early morning hours. So my dad actually built me a soundproofed room out in the garage so I could do this without waking the neighbors.
So as your musical capabilities improved and increased, while you were in high school, did you participate in any music festivals, specifically regional music festivals?
Yes, many.
Did you ever win a prestigious regional music festival?
Yes, several.
Describe to the jury what opportunity you were given in connection with the South Carolina Philharmonic Orchestra.
In 2011, I participated in a high school piano festival in Columbia, South Carolina at the University of South Carolina called the Southeastern Piano Festival. And part of this festival, there was an international concerto competition A concerto is a piece for a solo instrument and orchestra. So in this case, solo piano with orchestra. And that was the Arthur Fraser International Piano Competition. And I was awarded first prize. And part of first prize was the opportunity at a later date to perform a full concerto with the South Carolina Philharmonic. And maybe a year later, we did Beethoven's Emperor Concerto.
You testified about.
I have to say, for someone like him, now I was that way. I was kind of like him when I was in high school. In sixth grade, you start learning your instrument. I was in the Centennial Youth Symphonies and Orchestra by the time I got out at seventh grade. I was in it for several years, and it is a very prestigious thing as a musician to be able to play in a philharmonic or symphony or orchestra, in which I was able to do as well. This is very prestigious. He is very proud of that fact. But dude, that doesn't mean you didn't do this. They're really painting him up to be this prodigy. I knew a woman who was married to one of the Europeans' best pianists of all time. She was right below him in skill. They got married, had a child, and she unalived the child, and she was in a psych ward at the state hospital where I worked. So, good for you. I'm glad you had all those wonderful experiences, but that doesn't mean you didn't do that.
High school and your.
I gotta crack the door in here. It is getting
Your
way
progression as a musician in high school. I want to talk about college. When it came to go for you to go to college, where did you apply to go to college?
I applied to 5 different conservatories in the country.
Were you accepted to any of those conservatories?
I was accepted to 3.
Where did you decide to go to college?
I went to the Juilliard School in Manhattan.
That's huge.
The year you applied, what percentage of applicants were granted admission to Juilliard?
I believe it was 7.2%.
Very low
And
percent.
you were one of those musicians.
Yes.
When you were accepted, what, if any, inducements or incentives did Juilliard give you to attend their institution?
They offered me a generous financial aid package and a merit-based scholarship.
When did you begin your education at the Juilliard School?
I matriculated in the fall of 2011.
I want to talk about what you did while you were there. While you were at Juilliard, did you have an opportunity to participate in an international music festival?
Yes, I did.
Please tell the jury about that.
There is an international music student.
Okay. Who wants to make a bet that they show a clip of him playing? How much do you want to bet that they show a clip of him playing? Well, we don't bet for real, but you know what I mean. Put a thumbs up if they're going to show it. Put a thumbs down if you don't think they will.
Festival in Kyoto, Japan, which is called I think the Rome Music Foundation sets it up. And they try to get music students from all over the world, from different countries. So they get a sampling of different countries, and they have a relationship with Juilliard. So an email was sent out to the student body asking if anyone wanted to participate, and I was selected to represent the states in Kyoto for this
Who
festival.
wanted to participate?
And so how many students from around the world participated in this festival?
Maybe 15 to 20.
And how many from America were selected to participate?
One.
One.
And that was just you.
Yes.
Out of how many applicants?
Did you graduate from the Juilliard School?
Yes, I did.
When did you graduate?
In May of 2015.
And what was the degree you obtained upon graduation?
A bachelor's of music and piano performance.
just briefly describe to the jury after you graduated, what did you do in the music field for employment immediately upon graduation?
I did what a lot of conservatory graduates do who decide not to immediately pursue a higher degree. I did a lot of freelancing. I did some solo gigs playing concerts. I did some accompanying. I taught some students. And I even took on some work in restaurants to supplement my income.
At some point, were you given the opportunity to be on staff with the Knoxville Symphony?
Yes, I was.
Thank you. Hello, it's
When
Rick.
did you receive, or when was that opportunity given to you?
I heard about the audition that I heard that a spot had opened up for principal keyboardist in the Knoxville Symphony, and I heard about it 3 days beforehand. So last minute, I learned a bunch of excerpts and auditioned, and I was fortunate enough to get the job in 2017.
You talked about the principal pianist. Tell the jury what the principal pianist, what that title means and what your function
That's a big deal.
is.
It is a principal keyboardist, so it's basically any instrument part in the orchestra that has a keyboard I would be playing. So it could be piano, harpsichord, synthesizer, celesta.
When did you
It was the
begin
number one
your
pianist.
employment as the principal pianist for the Knoxville Symphony?
In 2017.
When did your employment end with the Knoxville Symphony?
In 2018.
What did you decide to do in 2018 that required you to leave the orchestra? Or the symphony, rather.
I decided to enlist with the Marine Corps.
What?
So you're
A pianist. A Juilliard pianist. Number one tool of trade is your hands. How or why would you risk permanent injury to your hands to enlist in the military? Why would you risk that? What? That wasn't on my bingo card today.
a classically trained pianist. You have an opportunity with a symphony to perform with them, which is regular employment, and you decide to leave that and go serve your country in the Marine Corps. Is that correct?
Yes.
Describe to the jury why you decided to leave your job with the symphony to serve your country in the Marine Corps.
Since about my sophomore year of college, it has been something I've been thinking about, military service. And obviously there's a window of time that you're able to do that in as you get older, you hit age limits and so forth. And it had just always been something I was interested in, the service of others, service to others aspect of it. I felt like, in a sense, I owed a debt to my country and to do some military service. And I also wanted the opportunity to experience a difficult training environment. And
I don't believe
I
that.
figured the Marines they had a reputation of being the hardest. So that's the branch I decided to go for.
What, if any, attributes of your childhood or the home environment as you grew up, what, if any, of those attributes played into your desire to join the Marine Corps?
I think the way my parents had always instilled in us a good work ethic and an important sense of just a moral duty to others, it seemed like a very good opportunity for me to further develop some of these things in myself.
You testified that initially you enlisted in the Marine Corps. Ultimately, did your journey continue as an enlisted person in the Marine Corps?
No.
Why not? Tell this jury.
I was speaking with my recruiter, and they ask you a lot of questions, just trying to figure out who you are and what aptitude you might have for different aspects of the service you're going for. And he found out that I had a college degree, which meant, unbeknownst to me, that I was eligible for officer candidates. Found that out, they tried to funnel me into, it's a different recruiting program, but they got me in touch with the officer selection officer and encouraged me to go the officer route.
During the selection process for officer candidate school, were you living in Tennessee at the time?
Yes, I was.
And briefly, if you would describe for the jury during that period in Tennessee what the process was that was used for officer candidate school or OCS for selection.
It's a little different than recruiting. You have to go through a pretty rigorous selection process to even be invited to OCS. So you spend a lot of time with your OSO or your officer selection officer. And it's their job to essentially train you up and get you ready so that you can pass the review board to get an invitation. So when I was living in Tennessee, I was doing a lot of training with him preparing for this.
In Tennessee at the time, was there a board that also was tasked with reviewing applications for OCS?
Yes, there was.
And the
Sir, yes, sir.
the cycle where you participated or your application was evaluated, do you know how many applicants the board authorized to go forward with OCS during that cycle?
One.
Was that your application?
Yes, it was.
He's always.
Let's talk about OCS. At the time you began your journey in the Marine Corps, did Marine Corps personnel try to push you to a different area than you wanted to go to?
Of course they did.
Yes, they did.
Describe to this jury what they asked you to do or what they wanted you to do.
As a recruiter, there are different boxes that I think you get bonuses in a certain sense if you can check, and one of those is the Marine Corps band. So when they found out I have
There you go.
a background as a pianist, they really tried to get me to join the Marine Corps band.
And when they asked you to join the Marine Corps band, what did you say?
I declined. That wasn't the reason I wanted to join. I wanted to experience a different side of life, and I was interested in infantry.
What?
Let's talk about OCS. During officer candidate school and your time there, were there metrics that were used by OCS personnel to evaluate physical fitness?
Yes.
Describe to the jury what those metrics were.
There's something called the PFT, the physical fitness test, and it consists of 3 areas. It's pull-ups to failure, maximum crunches under 2 minutes, and a 3-mile timed run.
What's a perfect score on that?
You can get a maximum of 100 in each of the 3 areas, so a perfect score would be 300.
And you got
What was your
what?
score?
Perfect score?
294.
Holy crap.
Ultimately, were you able to complete
Overachiever
officer
what?
candidate school?
Am I being mean?
No, I was not.
Why were you not able to complete officer candidate school?
I was dropped after the 3rd week of officer candidate school due to level 3 stress fractures in both of my tibias,
So you had broken legs.
more or less.
At the time you were forced to leave officer candidate school, what percentage of the class were you in?
I was in the top 3%.
Do you remember how many members were in your OCS class at this time?
It was more than 400.
When you left OCS, how did you leave it with the Marine Corps?
The CEO of Quantico, which is where Marine Corps OCS is at, asked me to return. He essentially told me to go home, heal, retrain, and come back.
Did you do that?
And we'll talk about this more, but ultimately, did you return?
No, I did not.
At this time,
Because
do
you were
consider
accused of a
yourself
crime?
a United States Marine?
No, I do not.
Why?
That's a title you have to earn, and since I haven't completed my training, I did not earn it.
After you suffered the fractures in your legs, where did you go to rehabilitate and to heal?
I went back to Traveler's Rest where my family is, and I stayed with them while I was healing.
And just to put a time on this, is this approximately 2019? Is that right?
This is late January of 2019.
So he couldn't commit this
So
crime.
now you're living with your family in Travelers Rest here in Greenville County.
We may get another.
While you were living with your family and rehabilitating your legs, were you presented with an opportunity to play music?
Yes, I was.
Describe to the jury what that opportunity was.
Through a series of mutual acquaintances, a woman by the name of Jeanette Wynn sent me an email and asked me if I would be willing to play an inaugural concert for their church. They had just received a gift of a very fine piano, and they wanted to have this concert sort of as a thank you to the donor and to show the congregation what it sounded like.
And so you were asked to perform using the gift of the piano that the church had received. Is that correct?
Yes.
What was your response to that invitation?
At first, I was inclined to say no because I was about 6 months out of practice. But the more I thought about it, it seemed like it would be a good thing to do while my legs were healing, so I accepted.
Describe to the jury, when did you play the inaugural concert on the piano, on that particular piano?
I believe it was in June of 2019.
Were you to be paid for the performance?
Yes, I was.
Describe to the jury what the arrangement for the payment would be.
It was a flat fee honorarium for this one concert.
And was the concert well received?
Yes, it was.
I want to talk about just briefly. You mentioned Jeanette Wynn in your introduction to the Wynn family. You first met Jeanette Wynn and other members of the Wynn family in what year? Was it 2019?
In 2019, yes.
And over time, did you develop a friendship with the Wynn family?
Yes, I did.
While you developed this friendship, did you share with the Wynn family a long aspiration you had held in the music context?
Yes, I did.
Tell this jury what that aspiration was.
Growing up, Beethoven had always been my favorite composer and something of a personal hero. And in 2020, that was going to be the 250th birthday for him. So I had this dream that I really kind of put on the back burner when I was intending to go through OCS. Well, this dream of playing all 32 of his piano sonatas in a series of concerts. And
That's an
in passing, I
ambitious
shared this
dream.
with the Winds.
And when you shared that aspiration you had with the Winds, what was the reaction of the Winds and their church members?
They were very enthusiastic about the idea.
And so their support of your dream, what effect did that have on your decision to go back to the United States Marine Corps?
Playing all of these sonatas is not something you can really just decide to do. You need a venue to present them at, so you need external support. And when I realized how enthusiastic the Winds and their church congregation were about this, I realized that there was actually a real way to do this. So it presented me with a very difficult decision, whether to go back to OCS or whether to do this passion project of mine that I didn't think I was going to ever be able to do. And I eventually chose to do the Beethoven sonatas.
Let's talk about this project. You said 32 Beethoven sonatas.
Yes.
How many pages of music comprises the 32 sonatas?
It's over 600 pages.
if you played those from beginning to end, how long would it take to get through all 32 sonatas?
It depends how fast you go, but roughly 11 to 12 hours.
To your knowledge, how many people have been able to accomplish this endeavor?
I don't know the exact number. It's not many. It's something, probably only a dozen or two pianists have ever recorded. As to how many pianists have actually done it, I don't know if there's a record of that.
So let's talk about what you did to prepare. We're in 2019. When was the first concert on this project? When was that? When were you to perform that concert? When was that scheduled?
In January of 2020.
Where was that going to be? Where was that performance going to take place?
At the Winds Church.
To prepare for this inaugural concert, where were you living?
At first, I was living with my family, and at a certain point, the Winds extended an invitation to me to live with them because they had a piano that I could practice on, and I think they wanted to hear me practice.
So let's talk about January of 2020. Did you have your inaugural concert for this project in January 2020?
Yes.
And where did you perform this concert?
At the Winds Church.
Were you to be compensated for this concert series?
The concerts were donation-based, and the church and I had agreed to split the proceeds 50-50.
Did you perform that concert in January of 2020?
Yes, I did.
How was it received?
Very well.
What percentage of the project, meaning how many sonatas, did you perform in the first concert?
I played 3 sonatas in the first concert.
When was the next concert?
In February of 2020.
How many sonatas did you perform in the second concert?
I think 2.
When was the third concert?
In March of 2020.
How many sonatas did you perform in the March concert?
I believe 3.
Were you able to perform a fourth concert in April of 2020?
No, I wasn't.
Why not?
COVID had happened, which was making public gatherings impossible at the time.
So up until April of 2020, if you had to guess, what percentage of the project were you able to complete in those 3 performances?
Maybe a fifth to a quarter.
All right. During this time, were you working anywhere else to make a little extra money?
Yes, prior I had been working at Gianna downtown serving, and at some point I started working there again after COVID had happened. And I also took on some work with my dad, painting houses and laying brick.
So when the pandemic hit, did that put a complete end to your music performances?
For the time being, yes.
At some point, did you decide to perform outside during the pandemic?
Yes, I did.
What instrument did you use to conduct performances outside?
I saved up some money and bought what was the best electronic keyboard on the market at the time. And I needed something portable. And I also wanted something that would do justice to the pieces I was trying to play. So it was a Roland DeVie piano.
Where did you, or how did you get the money to pay for the piano?
Through working with my dad.
So after you got the piano, did you begin to play music on the streets of downtown Greenville?
Yes, I applied for a performer's permit for public spaces, and then I started Several times a week, taking my keyboard downtown and playing these sonatas at various spots in downtown Greenville.
When did you start performing in downtown Greenville?
It would have been sometime in the summer of 2020.
Where were some of your most frequent locations where you perform music in downtown Greenville?
Probably the most frequent was right in front of Spill the Beans at the entrance to Falls Park, where the fountain is.
I want to talk about an evening in August of 2020 while you were performing outside Spill the Beans. While you were performing, did anyone make contact with you and introduce himself to you?
Yes,
Who was that?
that was John Mello.
Was John Mello by himself, or was anyone with him?
He was with his daughter, Aida Mello.
How old?
He's coming across to me as a very talented person, but his ego needs to get in check. Just saying.
Best you can recall, how old was Aida at the time?
She was 8.
Tell this jury about the interaction you had with John Mello when he first introduced himself when you were in front of Spill Beans.
I didn't know who he was, but he came up and said he was a musician and asked if I'd be willing to take a request. He said his daughter's favorite piece was Claire de Lune, and I know that piece really well. It's a favorite piece of mine, so I played it for her.
What, if anything, did you observe about Aida while you were playing Claire de Lune?
Like I said, she was 8, so she was pretty young. I had taught a lot of kids before, so I had experience with kids that age and their attention spans, which tend to be very short. So I was really impressed. I could see her out of the corner of my eye, and she was just enraptured from start to finish. She wasn't running around. She wasn't on a device. She was just completely caught up in the music, and that made a big impression on me.
After you played John Mello's request, before he left, what, if anything, did he give you?
He gave me a business card.
Did you use it to make contact with him after that first meeting?
Yes, I sent him an email.
Why did you follow up and begin to communicate with John Mello after that first meeting?
I got the impression from a few things he said and from the card that he was in the rock and roll world, which that's something I had never had much contact with as a classical musician. And he seemed like a great conversationalist. He was charismatic and outgoing, and I thought it'd be interesting to get coffee with him at some point.
And did you meet with John again after that night in August of 2020?
Yes, I did.
I want to talk about the period between the time you met John and Aida Mello in August of 2020 until the beginning of October of 2020. During that period of time, how many times did you physically meet with John Mello?
Maybe 6 or 7 times.
When you met with him, was he by himself or was with Aida with him?
With one exception, Aida was always with him.
Tell the jury what the activities you and John and Aida would do together in that period.
We'd get coffee a few times. I saw them and Aida spontaneously because I was performing and they walked out like the first time. We got pizza once. We went to an art gallery, things like that.
Tell the jury what your impressions were of Aida as you got to know her in the late summer, early fall of 2020.
They were extremely positive. She's a really special kid. She was definitely mature beyond her years, like I talked about. She could hold a conversation with adults. She looked you in the eye. She seemed really cultured, like she had a lot of exposure to different places. She traveled like almost as much as I had. She was always telling me about it to clearly love her. And I was convinced that she was a happy, healthy kid and he was a great father.
Let's fast forward to beginning of October of 2020. When is your birthday?
I don't know. I'm gonna call him.
October 2nd.
On your birthday, October the 2nd, 2020, how did you celebrate your birthday?
I'll be right back,
At this
y'all.
point, Aida had visitation with her mother, Christina Parcell. So this was the one time I saw John where she wasn't with him. And John wanted to show me some of his favorite taco stands out on White Horse Road. So we celebrated my birthday together and went to a couple bars, had dinner, ended up getting tacos at the end of the night.
At the beginning of the night, what was John's mood?
Very festive.
By the end of the night, had his mood changed?
Yes, it had.
Describe what his mood was at the end of the night.
Towards the end, at one of these taco stands, he became very pensive and even distraught. And he started to tell me about really grave concerns he had about his daughter, specifically when his daughter was with her mother, Christina Parcell. And he essentially said that whenever Aida's mother had visitation, he just never could rest easy until he got Aida back. And that he just didn't trust her, and he thought that she wasn't responsible and that she might even hurt her at some point. And I mean, frankly, it kind of, I mean, the mood of the evening took a big dip because of this. It was clear that he just was terrified about the danger his daughter was in, and this made a big impression on me.
So when you were with John on your birthday,
I need to let you know that the young man that I had on a show is going to come here. He's going to be learning to do what I do. So you'll be seeing me talking to somebody. It's okay. The sound is off for a reason. I'm going to teach somebody to do what I do. And black always always have lint rollers around if you wear black. Okay. You just won't hear me, but you will see and hear them
October 2nd,
when he gets there.
Where were Aida and Christina Parcell?
I believe they were on a road trip to see family, maybe in Alabama or somewhere farther down south.
When was she due back to Greenville?
I believe the next day or in the next couple of days.
When she returned, where were Aida and John going to go?
They were going to go to Italy.
Did John tell you that?
Yes.
When John told you that he and Aida were going to go to Italy, what did you think about that? What was your reaction to that?
I thought it was great. I knew at this point that John's parents were Italian, and Aida, I thought, stood to gain a great cultural experience from it. And I just thought if I had had the opportunity to travel and live in Italy when I was 8, I would have jumped at that. So I was really excited for both of them.
Did they go to Italy?
Yes.
So in October, John and Aida Mello go to Italy. Tell this jury what you're doing in October, November of 2020, musically and otherwise.
At this point, musically, I was still performing on the streets of Greenville, and I was also talking with someone who curated a museum of historic instruments downtown, the Sigel Music Museum. This man was Tom Strange, and we were discussing the possibility of revamping the Beethoven project I had been planning to do that got cut short by COVID by essentially doing the concert series again throughout 2021, but this time recording them so that we wouldn't have to deal with the issue of gatherings with COVID going on.
And did you and Tom Strange solidify a plan for resurrecting the Beethoven project?
Yes, we did.
Just generally speaking, describe for the jury sort of the intensity of the schedule, the intensity of the lead up to that project.
Yeah, so as a classical musician, at least, just because you've played a piece doesn't mean that like you know it forever and you're never going to forget it, and it's never going to cost you any more work. It would be like you may have run a marathon once before in your life, but if you haven't trained for a year, it's not going to be easy for you if you go and try to do it again. So I was going to have to relearn all of this repertoire because I had only been playing certain of the sonatas downtown. And with the recording schedule, I was going to be meeting with him. There was going to be other people and other equipment involved. So essentially, I was going to have to commit to a schedule where we'd meet more or less once a week to record one sonata a week throughout 2021 and stick to that schedule. So it was going to be strenuous and a lot of work, and I knew this going into it.
And when was the first recording set to occur on the project with Tom Strange?
I think around January 2021.
And beginning in January, how many performances on the project? What was the time frame on the remaining performances on the project?
Again, it was roughly one a week. These sonatas are not all the same length. Some are short as like 12 minutes. Others, one lasts about 45 minutes. So depending on the piece, we were allocating enough time for me to get ready.
All right, so let's talk about from, again, October to April of 2020. John and Aida leave in October. Between October and April, describe to the jury what the communications were you were having with John Mello, the frequency of the communications. Just tell them about that.
Like I said, I was excited for them. I was excited for Aida to be able to have this experience. Based on what John had told me about Aida's mother, I thought it was good that there was distance in between them. And our communications had died off a bit after they left. John is interesting. He's also a lot. He's a very dramatic person. And it was a bit of a relief to just not be running into him downtown all the time, because I had a lot of practice I was doing, and sometimes I didn't have time to hang out as much as he might have wanted to. So our communications petered out.
Were you relieved in some ways that your communications with him had slowed down or stopped?
To a degree, yeah.
Well, thank you, June.
All right. In
No.
April of 2021,
Yeah, I agree.
did your communications with John and the frequency of them increase dramatically?
Yes.
Why did your communications with John increase dramatically in April of 2021?
Like I said, our communications had petered out, but they hadn't completely ceased. So he had let me know that Christina Parcell, Aida's mother, had been filing, I think, some stuff with the family court in Greenville in order to try to get her daughter back. He was very worried that she might succeed in doing this for reasons I've already spoken about. And in April, he sent me a message, and it was clear from the text that he was very upset, just saying that Zach, they took Aida. What am I going to do? Something about along those lines.
After he told you in April of 2021 that they had taken Aida, did he begin to tell you in greater detail what his concerns were and more information about his concerns?
Yes.
What happened next?
At this point, I found myself in kind of a conundrum because, like I said, I had appreciated having some distance from John.
Sure is.
But by the same token, I was becoming increasingly more concerned about his daughter, Aida. So while I might have wanted to not continue communicating with John for the sake of his daughter, I felt that I had a certain sense of responsibility to help him with what he was dealing with this custody battle for his daughter's sake. We began communicating probably every day, at least by text, often by phone calls. I was giving a lot of time towards hearing what he had to say, towards trying to help him in any way I could. Some of the things I did to help him were, first, he needed counsel. He needed a lawyer in family court. So I was calling a bunch of lawyers in Greenville, trying to find someone who could help him, and by helping him, help Aida. I ended up cleaning his house in Greenville. He had left it with a tenant who absolutely trashed it. It was like nothing I'd ever seen. Like the air was hardly breathable. So I was buying a dehumidifier, getting cleaning supplies, hiring Mikey Manigo, who testified last week, to help me clean out his house so that he would have a place to show family court, and, that he had a home that would be a safe place for a little girl and him to be living in. I told him when he came back, I'd pick him up from the airport. But notably, while we were having these conversations, he began to tell me in much more detail what his concerns were about Christina Parcell. And, well, in order for you to understand
guys,
what
I'm
my
gonna go get my
reaction
hearing
was to
aids.
what he
I
was
will
telling
be
me, you
right
need to
back.
know what my experience was with my oldest adopted sibling, Grace. So when we adopted these kids, we really didn't know much about them.
Objection, Your Honor, maybe approach. Sure.
Will you please take the jury back to their wonderful room?
Oh. It's all Bluetooth, so it doesn't interfere. This is something I gotta teach you.
Yeah.
Connect. Okay, guys, I know they're going to break. I can't hear right now. My earnings are trying to connect, but say hello. Yeah, they can't see you. They can't see you. Oh, hey, June remembered your name. See, yeah.
Hey, June.
He said, hey. Okay, y'all. I left my hearing aids and they said they can see a part of you, so you need to move this way. The other way. Come over. Yeah, there we go. I'm gonna be teaching him today. Oh, did I send that message? I was typing to my interpreter. I may need to call her. But we are on break. What did you think about that guy's testimony? To me, it was very pompous, very much. Look what I've done. I'm a Juilliard pianist, and then I risked my golden hands to go into the Marines. Then I ended up getting fractures in both my legs. Then I did this, and then I did that. Very self-serving. Oh, we can see Alan. Everybody saying hello.
What's up,
Pompous. Are you awake yet?
Yeah, I just had a Red Bull, so I'll be good in a
Zing.
minute.
No, Red Bull and me give me a heart attack.
I
Mhm.
only do the sugar-free one.
Yeah, but still, it just to that jolt to my and the taste. Trying to get our interpreter. Let's see. Oh, y'all, I snow flurry. Good morning, beloved. Since I hear you. It's on my end, not yours. Oh, but I can't. Oh, there you are. You're in my ears. I have Alan here so he can hear everything you say. Are you gonna hop on today? Well, you can. I would if you want to, that would be great. I'm live right now, so whenever you want to, I've already sent you the link. Love you. Okay. Whatever. Love you. Bye. So our interpreter will be joining us. She's finally over that cough. She had a cough so bad I thought she was breaking her ribs. So we are on a short break. He done? I'm sorry, I had to step away and go get my hearing aids. Are we? Yes, I was just getting ready to play our commercial. You guys, I've already had some of our Hitchman Homestead coffee, y'all. You got to get some of your own. Why is it not working? That is weird. That is very weird. Hey, y'all, please help me welcome the Hitchman Homestead Coffee. They are fabulous. They have many different blends of freshly roasted, freshly ground coffee. They have a monthly club where you get 4 bags for $40 or a Keurig option. Also, they just came out with a half and half. Oh my gosh, I absolutely love it. So do me a favor, go down to the link below at hitchmanhomestead.com, order you some coffee and show them some love. And see what's happening. I'm explaining. I got some explaining to do. So if I have a sound problem, I can always come over here and hit that wait, and I can then hear what's going on through them. But that normally doesn't happen. I leave it up for this. It's important, and just to make sure that the feed is going out. You went? No, I believe he went to SB. I believe SB. Oh, we have a sidebar. Okay, we got a sidebar. That is interesting. We will be doing little more sound effects than usual because I want to teach him how to use this equipment. So we'll go, oh, they're getting ready to come back in. Sometimes in this program, I gotta renew my license for some of the music, but I can't do that until the end of the month. But you'll see over here in media, you'll see that there are a bunch of
Yeah.
music, but I got funk. But that's one of my paid, so I don't want to go any further than that. We're gonna put some. Okay, guys. So right now, all we have learned about this guy is he's very proficient at piano and he loves himself. I know, but I got to get the copyright. I can pay monthly or yearly. I think the yearly subscription is due. I didn't plan it well. I have 6 yearly subscriptions. And they're all good. So I am purposely putting it out till later for that kind of balance. Everybody is going crazy over there. Just relax. I find it interesting that I was the first person that most people did, and now everybody has it. What's up with that? Okay, thank you, Steve, for joining. Are you in the courtroom? Are you in the courtroom, Steve? Are you there? Oh, that would be cool. I'm cutting in and out. Okay, maybe the music. Check that. See if that's better. I don't know why this music does that, but we'll see. Still hearing music. Okay, there we go. And I think they're coming back. The sidebar is over. We'll give them a minute. Once court starts up again, I'm going to be talking to him and listening to court at the same time. Don't be put off by it. It's a wonderful thing that he wants to learn how to do this for his own ministry. And I don't know, what are you calling it?
Oh, it's gonna be the Addict to Athlete podcast.
Podcast.
So it's gonna be about fitness, addiction, recovery, how to come back from obstacles, that kind of thing.
See, isn't that cool? So what we're going to do is I will be teaching him. He's going to listen because I want him to hear the sounds. Okay, so now we got the beautiful seal. So I guess we got some time to kill. So this here is the Stream Deck. That home button will take you everywhere. This is your speaking volume. You see how it gets up into the yellows? I usually set it about right at the middle. And then the closer I get, the higher you can kind of gauge it. You'll learn. You'll have the monitors in your ears. This here is the court feed. The second is for court. So I always have them just slightly lower than me because sometimes they're really loud on their end. But if it's, you won't have to worry about that. But anything you play through the system, YouTube, anything. I heard someone coughing in the court. This is this is the soundboard. If I do,
Where we left off, you were telling this jury about your oldest sister, Grace.
Yes.
you scroll through these this way, and it's terrible. We have a siren.
I don't say this lightly, but my oldest sister, Grace, was the most evil human being I've ever met in my life. She was 10 when she came into our family. The Russian government didn't tell us much about the kids, so we weren't aware of any, if any, behavioral issues. There may have been, and there were many, but specifically with her. I would describe her without reservation as an affectionless psychopath. It wasn't that she was immoral, it was more that she was amoral. She didn't have a sense of right and wrong. Her emotional compass was seemingly non-existent. She was just dead inside. She was a masterful manipulator and deceiver. She could lie at the drop of the hat for reasons that might involve her personal gain or just for the heck of it. She would invent the most absurd, crazy, gruesome stories just to get a reaction out of people. And she could talk about this stuff with the same tone that you might talk about making a sandwich. And this from a girl that I knew between the ages of 10 to 14. It was incredibly disturbing. And the things I learned about that type of personality have stayed with me my entire life because I've never met someone like this since. And with one exception, I had never even heard someone describe another human being like this. And one of the things that is so dangerous about someone like this is
This guy's creeping me out.
she was literally like a vampire who would just suck the goodness out of other people around her. She could be very emotional, and she would fake these emotions in order to elicit a response in you, a sympathetic response. And if, for instance, you were accusing her of doing something like stealing or hurting one of her siblings, she would weep and just beg you to believe her and say, no, I didn't do it. And then if you would present her with irrefutable proof that we knew you had indeed done this, it was like a mask would just fall off her face. And I mean, she'd just look at you with shark eyes. No matter how many times we would go through this cycle with her, where she would deceive us and betray our trust and hurt people in our family, you want to believe that, you know, there's redemption for someone like this and that they might change their ways and become a better person. And she knew that. And she would use that in order to ingratiate herself again and regain our trust, only to betray that trust again harder than she had the first time. And this happened dozens of times, and it created an incredible amount of strife in our home. She could manipulate my parents and drive a wedge between them. She was just an incredibly intelligent person and incredibly evil. And having met someone like that, it made me able to understand, and even though I didn't want to, accept the fact that people like this exist, whether you want to believe it or not. And if you trust them, you are only ever going to get hurt by them again. You have to forgive them at some point. And that was a very difficult thing for me to do. It took me years, but eventually I had to accept an apology from this girl that I never got and was never going to get. And I had to do it for myself. But I would never trust her again. And that would be insane, for my own safety or for the safety of others. So this is an experience which I think is somewhat unique. I think most people have not met someone like this. And I mean, we might watch true crime documentaries or things like this, and we know that technically these people are real, but they exist on Netflix or in someone else's lives, and we never once believe that it could be someone we know, or that it could be someone living next door, or that it could be someone that our children play with, or, you know, someone we might allow to look after our kids. So knowing this is essential to understanding my reaction to what John began to tell me about Christina Parcell in April and May of 2021 after Aida had been taken back to Greenville. He started describing Christina Parcell's character and her personality. And as he was going through various points, he kept saying, Zach, I know you're not going to believe me. Like, I know this sounds overblown and dramatic, and you probably think I'm exaggerating. And under other circumstances, I would have, because John does, I mean, he's a big storyteller. And, you know, when people are talking about their exes, like, everyone thinks their ex is the Antichrist. So, of course, I was sort of predisposed to be biased against, except for the fact that point by point, everything intelligent and talented. He used to say she was smarter than he was, but that her biggest fault was that she was lazy. And she had this arrogance combined with her laziness that was essentially born out of the fact that she knew she never really had to work too hard at anything in life. And she could even sacrifice trust with people and tell them lies that could easily be found out, because ultimately she was completely confident in her ability to reel someone back in, no matter how bad she had burned them before. And he could have been describing Grace to me because I knew this behavior. I had lived through this behavior. So at this point,
I'm sorry. When he was describing these features to you of Christina, had you ever told him about Grace? Did he know anything about Grace?
no, I don't make a habit of talking about Grace to people. One, it's incredibly difficult to speak about. And two, most people, having not met someone like that, it just doesn't really land most of the time. They don't understand what you're talking about. So no, John had no idea that I'd had this experience with Grace, which made me realize that there was no way he could have possibly invented this, because no one would get it right point by point by point unless they had met one of these people. And that was the first thing that really raised a huge red flag with me and made me think that despite the fact that he can exaggerate and overblow the truth, and he's often not very believable when you listen to him, I was convinced at that point that he must be describing something true, because no one would know how to describe it so specifically and accurately if they were just making it up. And I was right to believe him. So in addition to this description of her character, and one last thing about Grace and Christina by correlation, one thing Grace was she had an addiction to doing was not merely stealing from you or sucker punching one of her siblings just to assert dominance or doing other terrible things to her siblings. She would recruit her other younger siblings to do these things for her. She would get off on making little duplicates of herself and training and enlisting her siblings to act as proxies for her, so that she wouldn't actually get in trouble, because she knew that we all had our eyes on her because of her behavior, and we knew we couldn't trust her. So if she even had 2 minutes with one of her younger siblings where no one was within earshot, she would tell them, hey, Mom's going to go check the mail. I just saw the mail truck go. When she's doing that, I want you to go run into her bedroom and go into her jewelry, or go and get this for me and we'll split it. Go and get that food that Mom said we can't have till the weekend or something. So she was an incredibly corrupting influence on anyone around her that she could exert her influence on. Again, I call her a vampire who sucks the goodness out of others. This is an incredibly appropriate metaphor, because that's what vampires do. They're intelligent, they're dead inside, and they eventually kill the people around them unless they find someone who might be useful to them, and then they create a duplicate of themselves that they can control. And this is exactly what Grace would do. So when John was telling me all this, I realized that there was an incredible danger that what Christina Parcell was a future preview of what Aida Mello could potentially become if she was left in this woman's custody and was raised by her. And the facts have borne out that I was right. But
Sustain.
We'll
instruct the jury to disregard the last comment.
Zach, at some point was Grace actually removed from your family?
yes,
Describe for this jury why or the circumstance or the event that prompted her removal from your family.
it had been 4 years of what I've been describing. She had been sent to different girls' homes around the country, many of which had records of never expelling a single student, and she was the first for many of them that they expelled and sent back to us. And it finally just got so bad that we realized she was going to be a physical danger to our family. I discovered a diary that she had made where she described in detail my parents having their eyes gouged out and dying, and how once my parents were out of the way and dead, she would be able to assume her role as rightful queen of the country. So she just had these psychotic
Things that John told you about Christina. Did he also provide you with other information about Christina that informed your opinion of her or what you came to know about her?
Yes.
What were some of the documents or other pieces of information that John provided you?
No objection to hearsay.
No, we're not offering it for its truth. We're offering it to show what he knew. It's State versus Vic. I've decided, Your Honor, we are not offering it for its truth. Go ahead.
He offered me, among other things, three very pertinent collections of information. One was the photographs that had been discussed that I sent in mailings to various people, along with advertisements from an escort website, which were connected with these photographs. These photographs were of Christina Parcell in various stages of undress. And John told me that they were prostitution advertisements from her previous career as a prostitute. And looking at these photographs, there was no doubt in my mind that that's what these were. And I don't say this in any way to try to shame. It's simply that, I mean, who said it? Like pornography, you know it when you see it. Well, I think the same can be said in terms of these photographs. They were not cute, sexy, intimate photographs that someone might send to someone they're dating or something. They were lewd and tasteless, and there was a very clear element of advertising, a commercial element. So when I looked at these, there was a vacant, arrogant, almost derisive look in her eyes that reminded me so much of my sister. It was a look that said, I can get you to do whatever I want because you want what I have to offer you. And coupled with this was a deposition from 2016 that Christina Parcell had given.
1 second. Zach. Let me show you, Zach, what's been marked as Defense Exhibit 46. Take a look at that.
Yes, this is the deposition.
All right. This time, the defense removed Defense Exhibit 46 into evidence.
State objects.
Not hearsay.
Not this guy's kind of creeping me out. I'm sorry. Schedule for later. We'll do 12:30 a.m. just for the hell of it. Tomorrow. I'm teaching him how to create a live. So you put your thumbnail in it. Create the live stream. Y'all, I have a live stream I've created for midnight. It will be deleted. I'm teaching him how to use this program and software and my system because he's going to be doing that. Facebook. So it looks like we're going to the ceiling. Yesterday, we had a lot of weird sidebars. So here you've created it, right? See these 3 dots over here? Can you see them?
Yep.
Let me move it. Click on the 3 dots, and it's going to see invite guests. Copy that, and then you can send it to them, the link.
And so at that time,
When they click on, they have to download the free version of the app, and then they just click on that link. Mm-hmm.
Okay.
And then you just copy the link and email it to them, and they click on it, and it brings you in. You will see how that works when Miss Diane comes on board, because Miss Diane, the interpreter, is going to be coming on to interpret for us today. Yay! We love Miss Diane. We love Miss Diane. She's so amazing. Oh my gosh, y'all. It was snow flurries, so we'll see what it is right now. I couldn't believe we actually had flurries. I didn't think we had enough moisture in the air for the flurries in Kerrville. It is extreme cold. It's 25 degrees. It feels like 3. We have wind gusts up to 31 miles an hour here in Kerrville. No prediction of snow. The wind gusts will not calm down until this evening at about 6:30, and it'll be 32 as the highest we'll reach today. Joyful, isn't it, y'all? I feel bad because if that's that cold here, how cold is it where you live? Please let me know. Sensei. No, ma'am. Out. Out. Not. If you went over here, you can come over here. Okay, lay down. No. Being a pain in the tushy lately. Come on, touch. Touch. Good girl. Lay down. But I want to thank everybody on X and on Facebook for joining today. We are watching the Rose Petal murder trial. Zachary Hughes is the defendant. He is on the stand and testifying. What have I gleaned from his testimony thus far? Thus far, he's a brilliant pianist. Thus far, he loves himself. Went in the military. He got hurt in basic training, had 2 fractures in his legs, 1 in each leg. June, 42 degrees. You are lucky, girlfriend. And then he decided he wanted to play every one of Beethoven's concertos on the piano. He got a hall or a church to help him out. They had the concert. He got half of the proceeds. And the tone and manner in which he's speaking of other people makes me feel like he's above everybody. He may have been a prodigy, but he's now on trial for redrum. By the way, we can't say the M word.
Yeah.
Redrum. And the R word is what? E. I have to look at it. I'm brain dead at this moment. Oh, EPAR. EPAR for the R word. I mean, you have to come up with clever things. So it's 18 in Temple with a lot of fog. We don't have fog. It's crystal clear with little snow flurries. Nothing's going to stick. Nothing at all is going to stick. The Simatilli trial will be starting this afternoon, but this trial is probably getting close to the end if they're putting the defendant on the stand. So we're going to stick with this trial, and then after this is done, then we'll head on over to that trial. I want to thank all of y'all who joined us for that live with Alan. It was so kind of you to do so, and some of y'all went and liked his page. His YouTube channel is there down below. Please go and like and subscribe to his channel. He is going to be giving a lot of good testimony. He's going to be sharing a lot of good things. Siba, thank you so much for the membership, and congratulations on your 1 month anniversary with us. Thank you so much. I'm teaching. By the way, when somebody gives any kind of memberships, gifted memberships, or they have super chats or anything like that, it shows up. It holds here so you can go back later and thank them. It'll show up, but it stays in the starred section. I am teaching him how to do everything, and it's a lot to learn. How you doing?
I'm good. I'm so far so good. I'm watching. I think it'd just be more repetition type stuff, you know.
It is.
I'm pretty good with electronics, so and computers and stuff. So I think I'll catch on pretty quick.
Yeah. This up here, don't worry about it. Don't mess with it. The camera angle, so is number 4. So if you want them to see where you're working or what your setup looks like,
Oh, that's cool.
Isn't that
I
cool?
want to do like a teaser too at some point, like where I just kind of intro what's going on.
Oh, you can do that. You create your intros in Canva is something that you're going to want. You can make intro videos on Canva.
Well, my son, remember I told you he's the media dude.
You got to get him over here. I need him.
He said he was gonna make me one if I send him the video cuts and like. But I wanted to do one where I'm like at the microphone and I'm like
actually here,
like where I'm actually talking about who's coming on the show first, and then I'm gonna squeeze that into the teaser. You know. So, yeah, that would be.
Could you get him over here so we can finalize? I'm having a problem getting. See, I got the images up. See, camera number 3 is this. So if I wanted to have a video on here, I can pop it up because that see in this circle here.
Yeah.
But my problem is I can't get the sound to go through.
Huh.
I'm a little stuck. I figured out a lot on my own, but I need somebody to come help.
Yeah.
Or does he live here locally?
No, but he's not very far away. He's like 45 minutes away.
I'll buy him dinner.
Yeah. Well, I figured, he wouldn't mind. He's gonna come by anyway. He wants to see me, so.
That'll be great.
Yeah.
Because I need to get this stuff working. Because sometimes I won't be using StreamYard. Sometimes I'm going to record directly through. Because what if StreamYard goes down, or what if it's something I want to do that StreamYard doesn't handle? Yeah. So you can record directly through YouTube. The problem is YouTube is not friendly with sharing to other medias while you're live. Yeah. So, yeah, I know. Solo layout. I'm looking for something specific. Excuse all the mess, y'all. ATM, there it goes. So if I switch to this, and this is the ATM layout. So now whatever's on this computer is going to show up here, which is wonderful because I've learned how to do picture in picture. So let's get that off of that and get that back over here and get that back over there. Yeah, y'all don't need to see my mess. I started cleaning out one of our rooms and I've got so many bags I got to throw away. I'm sure you saw the mess when you walked in. But I'm getting ready to start a big project and I've got to clean out that other room before I start. Mm. Don says 54 degrees, but still cold. I will tell you at what point what point? Oh, my mic was getting loose. Every once in a while you might want to check this connection because moving this around
Oh,
will loosen it. That may be why I was a little crackly. So at what point does the wind chill factor and everything just make it just plain cold?
oh. My ex-wife's in Round Rock. She said it was flurrying really good there this morning, but the wind chill's like it's makes it feel below 10.
Yeah. Exactly. What? You want attention because we have a guest. I love you too, baby. I don't want you under my feet. No, no, you can't do that. You can come over here. Over here. No. Over here. Okay. Lay down. Is she on your feet?
No, she did.
All right. I am surfing the internet right now to see if there's anything that we can gleam. Oh. You know, this was it. How do you say his name? Kanye West and his wife. I think that is the most disgusting, degradable thing. She guy. I don't. Can someone explain to me what? Can you explain to me that?
No,
And the fact he made her. Did you see on the carpet, the red carpet? She had a beautiful black fur coat on, and he asked her to take it off, and she was kind of like, I don't. You could tell she didn't want to do it, and he told her to do it. So she turns her back to the cameras, drops it, and it's like skin tone sheer, nothing hidden. It was see through material, skin tone see through. And then he had her turn around, and you could see all her glory on the red carpet, which they weren't even invited to. I'm sorry. I'm ranting, but that guy to me he doesn't deserve her. Would you make your wife do that? You'd be covering her butt up. You'd be taking your jacket off to keep her warm. Instead, she's walking around in a semi-sheer bodysuit, freezing her butt off. And he's parading her around. It just drives me nuts. Drives me nuts. Just can't do it. Just can't do it. Ain't gonna happen. 1,000 points of light. Okay, anybody can tell me who. I'll give you extra points for the drawing if you can tell me who said this phrase, 1,000 points of light, without Googling. Without Googling it. I'm sorry, guys. I'm trying to find us some information. We have a long break today. Okay, I'm going to put some music on real quick. He and I are going to talk a little bit more about how to do this and things to do and how all that kind of good stuff. Be right back. Okay, it's
Hello.
Hi, Diane. How are you doing?
I am doing well.
This young man behind me is Alan, who was on. He had a show recently.
I met you the other day, right?
Yes,
Oh, good.
that's how you bring him on.
That's right.
But now I got to figure out which one of these platforms I'm going to use. No, 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 no. I got this one, and I got this one. Enter. Okay, we're gonna customize this layout to get Diane on here. So I went in. Did you see how I did that? So this is new. I like the circles over the squares because it's softer and it doesn't take up as much room. So now I'm going to need to add an item. I'm going to add a camera slot. There's Miss Diane. You want to go up here, pull, get her in the circle, and move her bubble. Now, you can make yourself the same size, but a little bigger. This is perfect. What if I wanted to? I can drag and get it. Move it down. Put one of the third there. What you want to do? Okay. Then you're going to save it. I'm going to put insert one. That's that layout. So we're all ready when the court comes back. So you can alter some of these live. You have 8 that you can alter, but I prefer you try not to because, well, then I have to go back and fix it. But when you sign into your account, you have these that are some that are can't alter, like some of them you can. If you can alter, it's going to come up a blue, but some of them you can't. So let's give it. On the computer or on the phone. They're guests. They're not guest box. Yeah. Now, here's the thing. I can mute Miss Diane. So say that when she's opening and she starts coughing real loud, love you, I can mute her.
Loud?
Never. And I can mute the background, and I can even, okay? And it shows you picture. Let me get this where it needs to be. There we go. This will show you its full screen layout, and you're a viewer in it. So I'm going to mute Miss Diane for a moment. Now, the 3 dots, you can edit their name. They entered. You can keep them from the studio, so they're done for the day. And you want to remove them, kick them out. Ban them, you will never get them back on. Do not ban anything unless you really don't want them. Because you ban them and you invite them, they ain't coming back. Okay? And then depending on the mic, you can edit mic settings, but that's not available for her. Okay? And you just click off that so you don't
Okay,
lose
say
it.
like I have back. No, watching. Yes.
You can, I need to go get green material or green sheet.
I have it.
Right. See that bar? Eventually, they're going to help me set this up. And you can hone that material and commit the material to its view. And so you can get the flag up. Can find a way to simply have to. And so we're in this view. You can't edit this one. But yeah, well, what's your flag? Okay, well, you don't need to worry about that. You come into media, see all this, you save it. Diane, I'm going to pull you down for a second. I am in my humble opinion, I'm a hoax. Same word. Sometimes I have shell cells, sometimes I have that one. You don't have to have opinions. Some of them are videos. You can see it moving. You have it moving. You just need a digital image of that tag. And that'll put that back here. But if you want it behind you, where I have decorated room, then we'll put black and then that flag behind it. But when you do that, it's going to look. Okay. Yeah, you can have it in the background like this. So when you're doing your dual, let me get her back on the screen. Unfortunately, we can't edit these guys because it's compatible. Y'all are learning a lot by listening to us. Thank you. Hi, Diane. How are you? Oh, June. George W. Bush said it first. And you can even do triplets if you want. But this is what I like. George W. Bush was the first to say it, and then Clinton stole it. Yep. Clinton stole it. Hey, Miss Diane, I'm going to catch you up a little bit on what we're doing and what the case is about. But before I do, I want to show our viewers. Let me turn off the music because I'm talking over too much. I have created. Off there.
Have you created a Frankenstein?
I'm going to go ahead and delete those because I'm not following them. Say that again, beloved.
I said, have you created a Frankenstein? And does it live?
No Frankenstein.
Oh, gee.
No Frankenstein, but I did do this.
Well, look at that. Now that I like. That's just cute.
Okay, here's another one.
Well, guess what we did day before yesterday?
Hold on. I got more.
Oh, look at
Thank you, Mooch, for your support.
Mooch.
Thank you for the super chat.
I love this little
I
cow.
love my court junkies.
Absolutely.
The Highlander cow.
I
Because
love
it
it.
got me hooked on them. Okay, what did you do yesterday?
Not yesterday, but day before. My son and his workers got my old refrigerator out and my new refrigerator in. But
Oh,
in the meantime, when they were moving my china cabinet, a shelf gave away and I lost a lot of my mother's china. And it's the old old Albert Rose pattern. So I kept some of the larger pieces and I'm going to use them to make a mosaic table for outside. But life is life. I put my
Oh,
refrigerator in. It's beautiful.
her shelf and her china cabinet gave way and destroyed her mother's china, which is turn a century.
Yeah,
20s,
it's,
1920s, 1930s.
yeah, it's beautiful.
It was beautiful. Aw. Save as
I-
much as you can and use it for make crosses. I have people get wooden crosses and
Uh-huh.
they glue the pieces of china to it and then they put a grout and
Yeah,
then give those away.
mosaic. That's what I'm gonna do. Make a mosaic, and I'm gonna do a mosaic tabletop and some different things out of it. So I didn't lose all of it, and I was really happy not to lose the teapot or the big
Oh,
flat.
got
Lost
that.
bowls and cups
All
and
right.
some
Give
places.
me
Really.
Okay, give me 1 second, everybody. I'll be right back. Gone. I don't understand the break, you guys. I apologize. Unfortunately, this is part of trial, and it is what it is. Let me see what time is it. It's 10:58, so we can't even go to the cemetery trial because they're not even on yet. So can't do that. Let me see if Court TV's got something I can play for y'all because I'm a member and I can get some interesting. Let's watch this.
Those are dog fights.
That's not trial by ambush. That's getting duped.
The Commonwealth just provided the court with information that causes me grave concern.
New information about Karen Reed's defense team is giving the judge grave concern. Now she must determine whether a fraud on the court was committed. We'll discuss. And the prosecution is fighting back against the witness harassment and bullying that's been going on, calling out the embattled protester and defendant known as Turtle Boy, saying that he has a symbiotic relationship with defendant Karen Reed. Also this hour, we're spotlighting the heartbreaking case of 3 children who police say were abandoned for years, living in filth and surviving on bread and the occasional DoorDash. Plus, the verdict reaction that has everybody talking. A$AP Rocky jumping into the arms of Rihanna. But what about that mysterious prop gun? We've got a firearms expert here to show us his. It's all coming up next for you right here on Opening Statements.
Which is that he took the life of Christina Parcell.
So I'll see you a week from today at 11 o'clock in the morning.
Now, it's hard to see because of our banner at the bottom of the screen, but the judge was shaking there. She was actually visibly shaking. She had her eyeglasses in her hand and was shaking, having what seems to be a visceral reaction to this news. So here's what it's about. Special Prosecutor Hank Brennan revealed that the ARCA experts, remember these guys, they were great witnesses for the defense in the first trial. Well, the defense team at the first trial had represented to the court that they were completely independent. They had represented that they had not had trial preparation work with them, that they were not paying them, that they were hired by the federal government, and that they were completely unbiased, independent witnesses. Well, that turned out not to be true. Hank Brennan alerting to the court communications that did go on, discussions about what to say and not to say in the courtroom, and they'd been paid $23,000.
I'm not saying that undermines the conclusions of ARCA, I'm not saying they're not qualified witnesses, but it certainly shows some bias. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them. And then a bill from ARCA to the defense for $23,925. That's not Trimble. That's not trial by ambush. That's getting duped.
This is incredibly serious, what happened here, because lawyers take an oath to act as officers of the court and act with honesty and integrity at all times. And so now there's a question of whether a deliberate misrepresentation was made. That is the question. The judge has to determine whether there was a fraud perpetrated on the court by these attorneys. That is the question. And so she's requesting all parties reconvene next week. She's giving everyone time to prepare. And she noted that she wants to see all those communications that Attorney Hank Brennan had received from the federal government that showed the talks that were, in fact, had between Karen Reed's lawyers and those ARCA witnesses who were represented to be independent. Now let's talk about this. I have 2 great guests standing by. I want to bring them in now. The former head of the homicide unit in the Norfolk County District Attorney's Office. He's in private practice now in Massachusetts. Attorney Rick Grundy is with us. And nationally known radio host. He's also the creator and the host of the show Road Patrol Live, John DePietro. Good morning to you both. I want to start, please, with your reactions to what we saw yesterday with respect to what Hank Brennan revealed about these ARCA witnesses and the defense attorneys. And John DePietro, I'm going to start with you, please.
You know, Julie, this was so significant. And just the visual of what you were just showing on the screen, Alan Jackson, and people need to understand, Alan Jackson, he is the defense. He's the face of the defense. He's, as I would describe, he's like the straw that stirs the drink. He was beet red during this whole thing. When Hank Brennan let this out, Julie, I think also the judge, I was in court when the ARCA experts were there. I think there was something about her gut that told her that there was something fishy about this whole thing. And then fast forward, and then it all comes out in court. This is very, very significant because this never really made sense of how they came away with something very different that essentially the state police came away with, and what just common sense said, that she did in fact hit him with the car. But Alan Jackson beat red. And also, if you look in the corner of the screen where Peg O'Keefe, Julie, huge smile. That's the most I've seen her smile in a very, very long time. Peg O'Keefe, Mother of John O'Keefe, recognizing how significant this was. This was a judge, I think. I think this boots Jackson. And I also think Unetti's in trouble. And one more thing I just want to point out.
Sure.
Not only was the reaction of normally they would leap up, Your Honor, I, strongly object to what we're here. They were dead.
My bad, y'all. I'll get it back. Don't worry. We'll get it.
I sent you some pictures.
Okay, love.
Messenger.
Okay.
I found very significant.
Excellent points, John. And we're going to talk about what implications could come. As you both know, this is as serious as it gets if there's a misrepresentation made to a court of law. And so we're going to talk about all of that. John, thank you. I want to play the moment, that moment where it was all revealed. Let's watch.
On June 10, 2024, you asked the defense about ARCA, and it was represented these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial.
That they could not prep with us for trial.
So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here
That's essentially, we've spoken to them only for the purposes of coordination of their testimony and their background. That's it.
So much.
Do you see what we did here? We went back in time. We pulled that video that Hank Brennan referenced yesterday, that moment where the representation is made. Rick Grundy, let me go to you next for your reaction, please.
Well, it's interesting to see how these things play out. We're going to get a dog and pony show on the 25th from the defense about how this was misinterpreted, that this all comes out of this discovery issue with these folks. But it certainly seems that the smoking gun is there. And in looking at the motion of the Commonwealth and the opposition filed by Alan Jackson, I think the prosecution put a little bit of a Trojan horse in there because I believe it was on the 14th of February, they file a motion reigniting the issue that with respect to these individuals in their outfit, they want discovery. And the defense who's calling them has not provided any further discovery. Within that motion, there is no mention of these communications that run afoul.
Oh, and we just lost you again there, Rick. We're having some troubles with your signal. Going back to that moment in time, because I wondered when Hank Brennan was talking about it, I was trying to remember, was that a moment we saw in court? And we did see it. We went back, Court TV went back, finding that video. So the judge is going to remember this very clearly, as you said, John DePietro, as she remembers asking them clearly, are these independent witnesses that you were not paying, essentially? And David Unetti, you used the word essentially. Essentially, yes, we haven't had time to prep with them, haven't had communications, but yet it was revealed, as you know, John, that the ARCA witnesses had back and forth discussions with Alan Jackson about what to say and not say. And so now the concern, Hank Brennan was very precise, saying, I'm not trying to prevent the ARCA witnesses from coming in. I'm exposing what seems to be bias that was covered up. John, how do you think Judge Cannoni is reacting to this when she went into chambers and came out shaking?
You know what, Julie, I think she really saw that just the clip you played, and that's a great clip that you grabbed, that she even had reservations and found it a little hard to believe. And I think she wanted to reiterate and make sure that she had asked the proper questions. But make no mistake about it, what was revealed was there was communication, and he was basically communicating with the defense, that Daniel Wolf of, you basically tell me, what you want me to say, I can frame it a certain way. He even raised that, you know, in case I didn't really examine the car, if they bring that up, here's how we get around it. I think this is very significant, Julie. And, you know, Alan Jackson, I think he was, you know, he's been difficult. At times he's taken over the courtroom. I think the judge was aghast that basically that these were not only proven, but it really showed that they kind of pulled one over on her. So that's, as someone that has watched her for countless hours, that is the most visibly shaken that I have seen this judge, who, again, very calm, cool, collected. I think she wanted to make sure she had all her ducks in a row. But make no mistake about it, what Hank Brennan exposed was they were disingenuous, misled the court when they said they had not been communicating with that witness.
John, you're so right. And as you know, this can have far-reaching implications, as Her Honor alluded to. I believe her words were this can potentially have big impact, she said, on defense and defense counsel. Depending upon what the court finds, as you know, John, counsel could be removed. I mean, if there is a situation of fraud on a court, I mean, you know, John, lawyers, they can be disbarred. I mean, it can have far-reaching consequences here. So this is as serious as it gets. And there was more in that hearing yesterday, as you know, John. This was just one of those big moments. So you're going to stick with us, and we're going to turn to the other big moment right after the break, as this motions hearing turned into a pivotal day in the case over the death of Officer John O'Keefe. When we come back here on Opening Statements, we'll continue discussing what happened and turn to big moment number 2, where Hank Brennan said, enough of the show, exposing the relationship between Karen Reed and Turtle Boy and Karen Reed's lawyers. We'll talk about it.
You wouldn't do this to an animal, let alone your child. So, you know, just to hear that he came out to touch the grass is just crushing, soul crushing on so many levels.
A Michigan mom arrested after abandoning her kids for years. The kids left in a house of horrors. 2 innocent children. Supporting her man. And of course, the alleged prop gun took center stage in all this, right? That gun's still missing. That maybe was a big deciding factor for this jury. We know Rocky had some kind of gun in his hand, but the state had no gun to present at trial. Not a real gun, not a prop gun. There was no gun the jury ever got to see. They just saw
the police.
Listen, this case said. No, they didn't go to go.
Okay, I was explaining to him about this case. You are not to have any reaction in court. I'm going to feed this a little bit because it's hard to hear. I think red one. And so this judge did something unusual. He received the documents from the jury with their verdict, and he had the jurors and verify that that was the verdict before they read it. Is it just in my ear? You got to see what this guy did.
2 and 5, are those your 2 red verdicts? Yes. Juror 6? All right, let's get it. The verdict forms to Juror 7.
I appreciate that he did it that way. That was cool. I liked it. I'm doing this. I only got 2 people watching, y'all. I got to watch it. Yeah. Oh, Sunny Golden June. You're it.
Juror 7.
Everybody went elsewhere.
Yes.
So right now, he's
It's okay. I love y'all.
if that is your verdict, before they even read it, usually if he goes to jail, he won't be getting his hair braided like that. He'll get it braided, but not like that. I was talking about if he goes to jail, he ain't going to get his hair braided like that.
That's some tight braiding, y'all. That's
Yeah.
expensive braiding.
Black woman asked me, how in the heck
11?
that was tight braided?
12, yes. Arbiters have stated that the verdict forms reflect their individual true correct verdicts.
That's tight. Yeah.
Yes, Your Honor.
You're my troopers, man. I got to tell you, the court hasn't really been that good lately.
Court, County of Los Angeles. People of the state of California versus Joaquin Mayers. Case number VA 508142-01. We, the jury of the above entitled action, find the defendant, Joaquin Mayers, not guilty of
Oh, no!
Back that up. Do that again.
Whoa.
Oh my gosh, y'all. That was, could you hear my hearing aids?
Back that up. Back that up. Do it again. Missed it.
Repeat again. Find the defendant.
Watch what he does.
Mayers.
Never have I.
Not guilty of
Oh, no!
This attorney's like, oh crap, we're in trouble. First of all, they were screaming so loud that it physically hurt my ears.
So,
number one. Number two, he jumped over the bar. See, and for those of you who don't know, that half that little partition between the people sitting and where the lawyers are, that's called the bar. And no one, when they say you're a lawyer who's passed the bar, that means you passed the exam, law exam, and you become a full-fledged attorney. And when you common law, people who believe in the common law will not cross that bar. They will stand behind it. They won't step and past that bar, because when you step past that bar, you are now in the control of what they call as a military court. Anyway, but he dove over that bar and was screaming. His attorneys are looking at the judge like, oh, Your Honor, we didn't do it. We're sorry. I mean, it was so out of control. Him. He security pulled him, and he's like,
No!
What was he on trial for?
So anyway, he was found guilty, not guilty in all counts. He's free. But I just wanted you guys to see that, because that I have never seen in my entire life. I've seen a man, which we have watched the trials of. You seen the guy who dove up and over the judge's bench and beat her, and he got beat by her clerk. That clerk pounded the heck out of that guy. Oh my gosh. So that was yesterday.
What
And
was he on trial for?
shooting someone?
Unaliving somebody.
What's his name again?
Zachary something.
Oh, Zachary. Zachary is let me do this Rocky guy first, and then we'll get Zachary. Not guilty of shooting a former friend.
Former, yeah, I guess he was former.
I was. Now this one, Zachary is on trial because he unalived. Oh gosh, I'm pulling a brain cramp. Hold on. I want to read it exactly, so let me pull up his charges. Now that my computer is running at a snail's pace, I don't know why. Okay, so they're coming back into court. They're not there yet. It may be this cold weather with the internet provider in
Yeah.
general, because everything is running kind of awkward.
Very well could be, yeah.
I was thinking about it was much better to jump the bar. Let me show this. Yeah, it is giving me heck. And jump the bench. Yeah. The TB part, I don't know what you're talking about. On court TV, I'll show it, but I don't know what you're talking about. So his charges for the Red Room in 19 oh, sorry, I'm bad. Zachary David Hughes is on trial for the 2021 Red Room of Christina Parcell, his best friend's ex-wife. The trial is expected to last more than a week. Christina Parcell's fiance, Bradley Post, found her unalive with cuts and stab. Okay, so this is interesting because June, please connect with me in Discord about that. I'll gladly take care of it. I'm just not following what you mean. Oh, you were so awesome, Angela. You saved the day. Okay, so we got the document I needed in order to do the thing in the afternoon. Okay, great. So this Yes, I'll be happy to do that, June. Turtle Boy. I forget TB Turtle Boy. I see TB and I think tuberculosis. You know my medical brain. So what's happening is, oh, when you want to bring up documents, let me show you how to do that. I have a document sitting here. All you have to do is share screen, go back over, see how it's kind of wonky.
Yeah.
You want to pull it into another window and then make it smaller. And well, let me see. Yeah. See how when you make it smaller?
Okay.
Unfortunately, depending on the program, you can't get rid of all this. Sometimes you can. We're going to be looking at this so we can embiggen and shrink and fit on screen. There we go.
Cool.
And then you just don't hit the tab right here to stop sharing. You just go back to where you were and then hit that one.
Okay.
It bounces back and forth. So this guy is accused of unaliving a guy's fiance. And what was weird was that there were rose petals and busted rose stems laying all over the place. Hence the rose petal murder.
Right.
Red Room. And so I find it interesting. Why would a pianist at first? I was like, why would a pianist risk destroying his hands? A Juilliard pianist do anything to risk damaging those hands. Unaliving somebody, you risk hurting yourself greatly. But then he joined the military and he joined the Marines. I'm thinking, dude, and he was like, got a score of what, 294 out of 300? He excels at everything he does. Everything he does, he excels at. And he expects perfectionism. So I am kind of confused as to why he would unalive somebody, in my humble opinion. Oh, my battery in my hearing aid just died. But that's okay. I got this hearing aid. So the frustration I'm struggling with and the thought of him doing this is, did he really do it? Because honestly, I don't understand. Why would he take that risk? The money had to be pretty dang good. How much was he paid? I don't have my hearing aids in here. Well, maybe this battery will work. I got some sound coming up. So that is where we are with this case. They have put on the case in chief with prosecution. She was brutally, it was a fight. She fought. And some people, the CSI crime scene investigator who was in charge was calling one of the roses a wildflower because all the petals were beaten off. But unfortunately, she's wrong. It was a rose. And I hope that does not affect her with the jury. But then one of my kind people said, yeah, but a rose is a wildflower. Rose originally is a wildflower. Sensei, what, baby? What, honey? Are you okay? Are you okay? Hold on, guys. I'm not kicking him out. I just want to make sure he had a ride home because it's in the 20s. There's no reason. And with the wind chill right now, let's see what they're saying. Feels like 5 degrees out there. He doesn't need to be walking. It's 28. It's warmed up. I woke up early this morning and it was single digits. Turtle Boy became a part of the Karen Reed trial. And I do Turtle Boy. Because Brennan, how do I put this? Karen Reed has a new attorney on her case. And that attorney is Turtle Boy's attorney. Turtle Boy is the most loudest and outgoing supporter for Karen Reed. He has helped raise hundreds of thousands of dollars. And when he started asking questions and being loud, they accused him of harassing witnesses and thus have put charges on him. And in doing so, now he is in litigation. Unfortunately, the prosecution is questioning the wisdom of putting, of using the same attorney that Turtle Boy is. He believes it's a conflict of interest. To me, it doesn't seem like that at all. If both Turtle Boy and her both agree and that attorney's okay with it, there should be no problem. But they're raising that. We will be reading, and we will be reading over lunch break the information on the filing that Miss Karen Reed had. I'm looking for something, y'all. I got to move some things around because I've got to read and I got to get it set up to read. because I have to be able to look at you and read at the same time. So what's happening here, and I'm going to share this, make sure, see how it just pops over? And I like it because my interpreter can handle it too.
Yeah.
I'm going to start from the beginning because we only got down to like that paragraph. This was filed yesterday. Memorandum in support of a petition of writ of habeas corpus. Okay, let me get the definition for that. So Miss Diane knows what that is, and y'all do too. The definition for a writ of habeas corpus. A writ of habeas corpus, Habeau. I just do a WOHC, is a court order that brings the defendant in jail or custody in front of the judge, requiring the government to prove legality of the detention. Okay. So with that, she comes respectfully before the courts, demanding a hearing in support of her petition of the writ of habeas corpus under 28. Miss Reed, currently facing an April 1st, 2025 retrial in Norfolk County Superior Court in CSC after a prior mistrial in July of 24. This petition contends that such retrial will violate Miss Reed's post-trial statement of violates Miss Reed's 5th and 14th Amendment protection against double jeopardy. What happened? Remember, the judge declared a mistrial and jurors came forward saying, we did reach some decisions on this. The first and third count were not guilty. The first part of the second charge was innocent, but the lesser is what they argued over. The petition relies upon post-trial statements of 5 jurors, 4 directly, 1 indirectly. That the jury in Miss Reed's first trial reached a final unanimous decision to acquit her of second-degree murder. Despite massive media publicity regarding these decisions, none of the other 7 jurors disputed the accuracy of these post-trial statements. What they're saying here is, Your Honor, this was all over the news worldwide in every social media platform. If the remaining 7 jurors disagreed with the 5, stating that she was found innocent on count 1 and 3, and the second count, she was innocent of the main, but the lesser is what we argued over. They could have come forward and say, no, we disagree with you, but they did not. In the usual course, the jury's verdict would have been announced in open court. The problem is that the defendant's attorneys did not object. That is why the Supreme Court is not going to, they're upholding they're upholding the judge's decision. And a re-prosecution for that charge would
Indisputably.
I got distracted. Indisputably be constitutionally prohibited. Here, however, the trial court, assuming but not verifying that jurors' notes indicating an impasse referred to all rather than several of the outstanding charges. That was an assumption right there on Auntie Bev was not cool. She was ready to be done with this case, in my humble opinion. In my humble opinion, she was done. So she failed to inquire and pursuant to Mass R Crime P27B. In other words, in pursuant to Massachusetts law regarding the existence of any partial verdict, as well as failing to poll the jury. And for that reason, the jury acquittals were not announced and a mistrial was declared without the defense consent. Is that better, Diane?
Yeah.
Come right here. Contrary to longstanding federal as well as state case law, the trial court gave no consideration to any of the existing viable. Are you gone? Nope. Okay, we're coming back into court. So we're going to put this down and we're going back over to court. We're going to share this screen. We're going to get going. It's a color jacket, dude. I'm going to get into the drink.
Thought we were finished with this.
So, Zach, you testified about information that John has provided you related to concerns he had about Christina Parcell, especially in conjunction with Aida Mello. We talked about the period April. I want to move to May. In May of 2021, were you and John Mello continuing to communicate about the situation?
Yes.
In May of 2021, what, if anything, did John ask you to do for him?
Given the extremely grave nature of John's concerns for his daughter, especially while she was in the custody of her mother, Christina Parcell, and potentially being exposed to her mother's boyfriend, Brad Post, who John believed was a pedophile and is a pedophile.
Objection. Sustained. I instruct you to totally disregard the last comments made by this defendant.
And Zach, you would just, could you just tell this jury what John asked you to do?
Yes. Given his concerns, John asked me that if I believed his daughter was in grave danger, would I be willing to kill Christina Parcell for $5,000?
What did you say when he asked you that?
I was shocked and insulted by the request, and I gave him an immediate and unequivocal no.
So he offered you $5,000 if you would kill Christina Parcell, and you said no.
That's correct.
At some point, did he revisit that subject?
Yes.
Did he make you another offer?
Yes, he did.
How long after the first offer did he make the second offer?
I'm not certain, but I would say maybe 2 or 3 weeks later.
Tell this jury about that.
He was becoming increasingly more worried and distressed about the safety of his daughter. I was as well. The more I learned about this situation and everything, and a lot more than what I've told you, I was also.
Sustained.
What was the second offer?
The second offer, he asked me again, if I became convinced that his daughter was in danger, would I be willing to kill Christina Parcell for $10,000?
what did you, or how did you respond to that offer?
I told him, John, there's no amount of money that would ever tempt me to do something like this. And I told him I was insulted that he even thought that would be something I would consider. So I told him I would never do something like this for money. I told him the only way I would ever consider taking action like this is if I was absolutely convinced that his daughter was not only in danger, but that the only way to rescue her from that danger would be to take Christina Parcells' life.
Let's talk about what else is going on in your life in May of 2021. Tell this jury what you're doing with the music project with Tom Strange, how that's going.
We've been at the project recording the sonatas in the museum, like I talked about, for about 5 months. This, of course, I was doing in conjunction with all the help I was trying to provide John and Aida. So the music project on its own would have been incredibly stressful. And with everything else, I was just approaching burnout. Honestly, I was having a really hard time meeting my deadlines. And I was worried that the quality of the work I was doing was going to be going down. And I was just at the point where I needed a vacation, honestly.
And we're going to get to that in just a second. Tell the jury about your compensation as it relates to the music project with Tom Strange.
It was just an arrangement of a flat fee for all 32 sonatas. I was going to receive $5,000.
And if you broke that down on an hourly basis, how much were you getting paid per hour for that project?
Probably less than $1, but it was a labor of love.
During this time, were you also doing other things to try to make money to support yourself, or was it?
Yes, I was giving some outdoor concerts on the Wynn's lawn, and these were donation-based, so people were supporting me financially in that regard.
You talked about needing a vacation at the end of May. Describe a little bit more to the jury the fatigue and why you believed at the end of May that a break would do you some good.
Well, I needed a break. My nature is usually to just try to push through stuff like that. I can push myself too far. So I was not necessarily seeking out a break or a vacation, but I was definitely at the point where I needed one for the sake of my work, for the sake of my health.
Did you get that break?
Yes, I did.
Describe for the jury how that came about.
Like I said, John and I were communicating pretty much every day at this point. Much of it, if not most of it, about Aida. But I was also mentioning to him what I was doing. Certainly times when he needed me to do something and I would have to say, I can't, I'm practicing, I'm recording something like this. So he told me, I think he said, like in the rock and roll business, we say you have a monkey on your back, like the project is starting to own you and you just need to step away from it. You're too close to it and you've been in it for too long. So he suggested that I come and visit him in Italy.
Did you take him up on that suggestion?
Yes, I did.
Initially, what was your reaction to that offer?
Initially, I didn't want to. Like I said, it's my nature to just kind of push through things, but with some more time, I realized that some time off from the piano would probably do me good.
So when did you go to Italy to visit John?
I think in either the very last days of May or first days of June, 2021.
Who paid for your travel?
I did.
When you arrived in Italy, where did you stay?
I stayed at John Mell's apartment.
How long were you there?
Between 3 and 4 weeks.
Do you remember where in Italy you were?
Yes, it was a town called Rovigo. It's not too far from Venice.
When you were visiting in Italy, where was Aida Mello?
She was in Greenville with her mother.
Even though Aida was not in Italy, while you were in Italy, did you have an opportunity to see Aida?
Yes, I did.
Describe for the jury what that opportunity was.
John had video visits ordered by the guardian ad litem, who you've seen before, Vanessa Cornwell, to have video visits twice a week with Aida. So he, even with the time difference, was always setting timers and alarms and making me set timers and alarms to make sure he wouldn't be late for these visits. Like he lived for these visits every week. So often it might be 11 p.m. or midnight in Italy, but that was when Aida was free. So that's when they'd have their visit. And I would often be within earshot to where I could hear their conversation. Often I would be able to observe the screen of his phone or computer so I could see Aida's face, her disposition. And on one occasion, I said hi to her.
What did you notice about her, or what did you conclude about her while you were watching Aida during these visitations?
So John had been telling me for weeks, Zach, Christina's killing my little girl. Like I can see the spark dying in her eyes. And again, when I first heard that, I thought, aren't you being a little dramatic? Like I hadn't seen her, but it just seemed a bit much. When I saw her in these visits, I didn't feel that way anymore. She was not the same little girl that I had known in Greenville when I first met them. She had put on a great deal of weight, probably about 20 pounds, which is roughly a quarter of her body weight. For an 8-year-old girl, that's a lot in a short period of time, but it was much more than that. It was her demeanor. Her spirit was just, she was morose, she was depressed. Like that spunky, precocious, lively little girl that I had met was just not present there. It was a complete change in character. And I mean, John would ask her how she was doing, and she would always try to give a good response. Like she would try to smile and say, "Oh, I'm fine, Daddy," and try to put on a good face. But it was clear that she was doing that because she didn't want to worry her dad. She didn't want him to realize how poorly she was doing. And it just reminded me so much of myself when I was a little older than she was, with what I've previously described with Grace. It's this, you internalize things. Like she's a strong person. And she was trying to be stronger than she was probably ready to be at that age. And despite the stoic, strong exterior she was trying to put on, I could just see that she was being tortured. Like she was drowning. And him saying that the spark was dying in her eyes was absolutely accurate. I could see it. I could hear it in her voice. I could tell it in her demeanor.
So when you came, wait back. When did you leave Italy to return to Greenville County?
At the end of June 2021.
When you returned to Greenville in June of 2021, based on everything that you knew and had been made aware of, and I want to start in June. What, if anything, in June of 2021 did you do to act on what you knew?
I had described the mailers that I had put together before, and the state has talked about them a lot. All of these mailers contained information that I believe had been put out publicly and by Christina Parcells' free will. So this was all information that had been available publicly and that, to the best of my knowledge, was true. And I began to send these mailers to Christina Parcell and her boyfriend and people in the neighborhood for a threefold purpose. I wanted parents around that neighborhood to know that their children were not safe around her or around Brad Post. I wanted different people associated with this, such as the guardian ad litem, the police, to have access to this information so that they would have all the evidence that I was looking at that clearly demonstrated that Christina Parcell was a danger to children and her own daughter. And I also wanted there to be social pressure on Christina Parcell, because something, again, about people like Grace and Christina Parcell is the facade that they erect around themselves and the image that they put forward to the world is so important to them. They're narcissists. And it is a facade. It's completely untrue. But I was hoping that it wouldn't be worth it to her for other people to see her for what she was in exchange for her trying to fight to have her daughter.
You sent multiple mailers beginning in June and going into July of 2021. Is that correct?
Yes, I did.
Did those mailers and the effect those mailers had do anything to alleviate your concerns?
No, they didn't. If anything, Christina Parcell and Brad Post just dug their heels in deeper.
After the mailers were sent, do you know whether or not they had any effect on? Back up. I want to talk about after the mailers were sent. Did you learn of a video call or about a video call that John, who was in Italy, had with Aida, who was in Greece?
Yes.
What did you learn about that video call?
Shortly after these mailers would have arrived, John described a call to me where he said Christina was, at the end of the call, she took the phone and turned it towards her face, which she usually did not do. And he said she was more angry than I've ever seen her. And he would often talk about how you would never see her angry, like she was very good at controlling her emotions and not showing if you had made her angry. And she took the phone and didn't say anything, but just slid her finger across her throat as if that she was threatening that she was going to have him killed for what she believed he was doing.
After the mailer or the last mailer, did John share with you any information he had received via email?
Yes, he described. Well, he didn't describe it. He sent it to me, an email he had received from someone he knew in the biker community, motorcycles. And Brad Post was also involved in the biker community, or at least tried to be. And this email was from this acquaintance of John telling John that Brad Post had been going around essentially asking for someone to, quote, put the hurt on John Mello, and that he was offering a lot of money to make this happen.
Wow. What are you thinking, Miss Diane?
I'm thinking gotta keep my people in the right places. Otherwise than that, I think I feel sorry for the little girl.
Yeah.
She's a pawn. And in not a good place.
I'm going to sustain the objection. Must be your side.
You know? Hey, let me show you something. You read this
Zach,
label.
you talked about
Zero.
the fact that you testified
Zero
that
sugar?
you sent the mailers,
No
you explained
sugar.
why.
No sugar
I
substitute.
want to talk about something else you did for the purpose of acting on a concern.
What is that lady holding in her hand?
That is the dictation for court.
Take a look at what's been marked as defense
Right.
exhibit
Does it
47.
know? She's making corrections. There's a computer
Is that an
that's
affidavit
generating the transcript and
you completed
makes the corrections by
for the purpose or in connection
Wow.
with the pending family court litigation between John Mello and Christina Parcell?
Yes, it is.
Your Honor, this is defense counsel version. This is already in evidence. The state put that in. Zach, let's talk about this affidavit.
Is that the one from September?
Yes, Your Honor. Yes. Zach, why did you draft this affidavit?
I was extremely concerned about the danger that Aida was in, and I wanted to try to provide the family court with information about my opinion and my observations about her that would hopefully cause them to return Aida to John so that she would no longer be in danger.
Did this affidavit, to whom did you send this affidavit?
I had it notarized, and then I think I scanned it and probably emailed it to John or left it with his family court attorney, Samantha Larkins, at the time.
One second.
I am required to take a survey for my college.
When do you start classes?
I'm in classes. I've been in classes.
When did you start?
Let's move on.
I'll send it to you.
And send me all the information.
That affidavit
I will.
was, I believe, September the 21st of 2021. Is that correct?
I
I don't remember the date other than it being in September.
I'll show it to you.
Yes, the 21st day of September, 2021.
And you testified that after you submitted that affidavit, that did not do anything to alleviate your concerns. Is that correct?
That is correct.
Did you take another step to try to act on your concerns for Aida?
Yes.
And did you take that step at the end of September or beginning of October?
Yes, I made a phone call to Child Protective Services, and I told them that I was a neighbor. So I told them that I had seen Aida being verbally and physically abused by her mother. And again, I made that up. That's not true. But I said it because I wanted to give Aida an opportunity to have FaceTime in person with an agent from DSS away from her mother, where she could tell them that her mother was sexually abusing her.
Objection, Your Honor. Sustained. You are to disregard the last comments.
I got stuck in this survey that I had to
Zach, let me ask this.
call. It drove me crazy, but I had to do it.
You talked about Child Protective Services.
Hello, beloved.
Is that in South Carolina? Is that called DSS?
I think they may be part of the same entity. I'm not sure.
And so, did they do anything to alleviate your concerns?
No.
Did that surprise you at all?
No.
In fact, you testified earlier about Virginia and Grace. Did you and your family have interaction with the DSS in Virginia
Yes, we did.
over Grace?
Yes, when I discovered the journal, I had mentioned before about Grace's plans to murder my family. We called DSS and asked for her to be taken out of the home. And they did this. And after a few weeks of hearing Grace's stories and lies, they took her side. They failed to recognize what they were dealing with her. And they tried to have my parents put in jail and the rest of me and my siblings put in foster care.
Whoa.
And we eventually had to sue them. And it was about a 2-year-long court battle. And that left an indelible impression on me, just as to how even experts can be wrong sometimes. And when they are wrong, it's so dangerous because everyone believes them because they're the experts.
Wow.
But sometimes you know what you know, and you know it's true. And even if an expert might think differently, it doesn't mean they're right. And
Diane,
DSS
your
did a
hands
lot
are
of
off
damage to
screen.
my family in those 2 years.
So
I can't read them off
ultimately,
screen, baby.
Grace was removed from your family. Is that correct?
Yes.
Your other Russian siblings were not, were they?
No.
In fact, Faith, one of your Russian siblings, has been in the courtroom all week. Is that correct?
Yes.
So you testified to this jury about the information you received from John Mello about his concerns. You've testified to the jury about the documents you consulted about those concerns. You testified to the jury what you came to believe. You testified to the jury about the mailers you sent, about the affidavit you submitted, and now about the call to DSS. After you had done all these things to act on your concerns, and nothing had been done, tell this jury in early October of 2021, what's going on in your mind? What are you thinking?
I was still in the middle of this music project, so I had a lot on my plate there just professionally, and of course I was continuing and even increasing my support to help John save his daughter, Aida. And since June, when I had returned, I had been absolutely convinced that Christina Parcell was sexually abusing her daughter.
Let's go. I mean,
Wow.
What was that?
We're going to back that up a little bit so we can get the captioning.
Yeah,
Even
what did you say?
increasing my support to help John save his daughter, Aida. And since June, when I had returned, I had been absolutely convinced that Christina Parcell was sexually abusing her daughter.
Let's go. I mean, take the jury.
What did they say?
I couldn't catch it.
Do it again.
Let me get the live captioning up because sometimes it can catch things that the other one doesn't.
Yeah.
Okay, let's go again.
My support to help John save his daughter, Aida. And since June, when I had returned, I had been absolutely convinced that Christina Parcell was sexually abusing her daughter.
Let's go. I mean, take the jury.
I think that's a lie, Your Honor. Whoa! Somebody hit a button there.
That's a liar, Your Honor. Where somebody hit a button?
That's a lie. That's a lie, Your Honor, is what I think it said. Let's go back one more quick.
Since June, when I had returned, I had been absolutely convinced that Christina Parcell was sexually abusing her daughter.
Let's go. I mean, take the jury.
But it's coming up with lie and honor up on the live captioning.
Oh.
Well, yes, you were gifted a membership, my love, from Seba. Seba gifted you a membership, June.
Did you ever solve the problem of why they couldn't buy me coffee? I tried, and
I don't know.
I don't know. Maybe I just need to redo it.
Redo it.
Okay.
Whoa. That is if he whoa. Excuse me. I'm not drunk, I promise.
Sure, you're high on potatoes.
Wowza.
Yeah.
That's a little bit of a okay, there it is. Oh, it's like we're gone.
You gone?
Oh my gosh. That was not on my bingo card. Was not on my bingo card. Okay, when I had to step out for a personal comfort break, did I hear did he say how much money how much money he was offered?
Yeah. He was offered the first time 5, second time he was offered the first time 5, the second time 10.
By whom?
By John Mellon.
The one in Italy.
Yeah. Yeah.
Okay. Well,
and he told him that for no amount of money would he do that the first time. And then the second time he told him that. But then he also said that he would, unless he absolutely knew that Aida's life was in danger, then he would do something.
that's in Call the Police.
Yeah, we would hope so. But
That's a time to get on the phone and call the police and let them know that there is a hit out on this woman.
yeah, really. But I didn't do the hitting. Did you see the pictures I sent you?
No, is that your phone dinging?
I don't know why my phone dings, but it does sometimes. It
Oh, that
just
was a loud ding.
ding-a-ling.
I'm going to look at the pictures. Sorry, I've been busy, my dear.
Oh, I know. I know. What was that?
Oh, I love that pattern.
Yeah. They were all from my mother.
Did you have all those dishes sitting on a glass shelf?
Yes.
That was not wise.
Well, they weren't all on. Well, yeah, it's a cabinet. It's a china cabinet.
I know, but that glass does not look like it's thick enough to hold a ton of weight.
It is. They're like this.
Oh,
They're
well.
it's yeah.
All right, Diane, I'm going to start reading this document again.
All right. We can do that.
Hold on. Let me get rid of this. Let me get up that video one more time because we were going to go through that because of the KB Turtle Boy reference.
Uh-huh. Oh.
I know. I'm tired. I am literally exhausted.
So am I.
Do you know what Pope Francis is, as they say, is resting peacefully last night after his double pneumonia?
Yeah. Did you?
Sure has gained weight. I almost didn't recognize him.
Yeah. I showed Margie a picture of him when he became Pope. And now there's two things on this. Look at me. I'm going to sign them to you. All right. When he became Pope, he was thinner and a little more
humble.
Yeah. Now he is much, and he's lost the.
Yep.
Yeah. Those are the two things I noticed.
Yep.
And if you have followed him and the statements he has made, not been a good lot of statements in the way of following the Lord.
Well, and I'm not going to knock anyone's faith. And there's a lot of people that really, really love the Pope and believe in everything he says. And that's fine. You have a right to believe that. But what I struggle is how the church, and not just Catholic Church, okay, churches in general, we're not getting religious. It's just it's a one-sided comment. How over time religious organizations change their views to fit what society finds acceptable at the time. And
Oh, absolutely.
And I'm not going to say anything more. That is how I feel.
It's like when I was in school and I had an ethical question posed to me. My answer to the ethical question was it's like this. The decision anyone makes, make sure you can live with your decision because you are the one that has to live with it, not anybody else. Plain and simple. And the teacher would go, but, I'm like, no buts. You asked my opinion on it as an ethical point of view, and the ethical point of view is what the end of it, what would I counsel the person? I would say the decision you're going to make, just make sure it's one you can live with because you're the one that has to live with it, no matter what anybody tells you. And that's what I would tell anybody today. This is what this says. This is what this says. Weigh your options, look at it, and make your decision.
Exactly.
Now, yes, as for your classes, we do need to chat and talk, and I need to find out what they are. I need to know what you're struggling with so I can help you with it. So we can.
Yeah, well, you tried to help me with one of them, and I dropped the class.
Oh, well, yeah, that one was a no-brainer.
Well, it's like I have a friend whose husband is a doctor, has a doctorate. He's a scientist. Ow! Oh, girl, that hurt. He's a doctor and he's a geologist and a scientist, and that man could tell you anything and everything about fossils you ever wanted to know. But did I want to call him and be tutored by him? Is that where my attentions are? Hell no. And the second week of class, they want you to look at a photo of a fossil in the class, second week.
Yeah.
Don't know anything about world geology. Look at a fossil and tell you how it was made and what conditions it was in and where did it come from. I'm all like,
Okay, nope. Let me
nope.
show you a fossil. See if you can find the fossil in this picture.
Oh, I see the fossil.
That was after I got back from Russia.
Girl, turn your dinger off. It hurts. Okay, we're gonna play this. This is from the Karen Reed motion hearing yesterday. We're not gonna play all of it. I don't know where that part is that was asked for, but we'll find it. We are
Okay.
going to play it at a high speed. You don't need to interpret this one.
Okay, good.
Unless you can, because they talk. Let's see how it is at 1.5 speed. Oh, I want it at regular speed. I hear the tone. If I feel it and sense it right, I can't hear it, but I can feel the vibrations and sense. I can hear slightly, but I want you to listen to the judge up on the judge's welcoming of people. Okay, it looks like
Let's say the Commonwealth of Massachusetts. This court is now open. Please be seated.
Take seats.
Judge 22-117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Good morning,
Mr. Lally.
Good morning, Your Honor. Hank
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi for Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed. All right, I was told counsel wanted to see me outside.
good morning, good morning, good morning. I don't want to be here. I don't want to talk to you, you pieces of crap.
But Ms. Little, to save you from working an entire weekend, you got it early enough to do that, right? On the 10th of February? Okay. All right, so paper number 483, this is the motion to compel production of a forensically signed copy of the January 29, 2020 video surveillance footage in law enforcement custody. And the opposition, Jim, I don't have a docket number on this. I think it was just filed. The Commonwealth's opposition in response. Do you have a paper number? Okay.
The paper numbers are motions, and we're in the 500. I didn't get all of that, but I got a lot of it.
Cheers.
For 500 cheers. I wish I had some of that.
Defendant's motion to compel production of a forensically sound copy. We'll get started in the argument. You can give me that.
506.
Great, thank you.
That's the response.
Right. Okay. Who's arguing this motion for the defendant?
I am, Your Honor.
Okay.
Is that Karen
Thank you,
Reed?
Your Honor. My comments will be relatively brief. We filed this motion basically because we had no choice.
Okay, this is Karen Reed. This is the John O'Keefe, the one who was unalive. This is his family. Let's see if I can get a shot of the brother. Let me go back.
Good morning, Your Honor. Hank
Robert
Alessi for Ms. Reed.
Okay, see that right there? That's John O'Keefe's brother. They are literally, this courtroom is so close that
Yeah.
from the edge of that computer to that bar is less than 3 feet. And that's the same between the jury who's sitting where the wording is on this side is less than 3 feet from this guy's arm. They can reach out and touch each other. And the jury is staring at the O'Keefes. Now, just so you know, Mr.
Good morning, Mr. Alessi.
That in the back of the courtroom, I'm trying to find it right here, is her family. 1, 2, 3, 4, 5, 6, 7, 14 people. No more. 14 people. Wow. Okay.
And Mr. Brennan makes this argument, well, the defense is just up here, you know, again, pontificating about how they've been oppressed, I think is his word.
I think that he's right on this point, that it's not the video that he's concerned with as much as chain of command and all of number 12, but whatever if pressure should have you size of something that didn't you don't need
in the shadow of the trial starting, we get more video. Where did that come from? Then in the middle of trial,
yeah,
we get
where
more
did it
video.
all
That
come
was
from if
being
it was
inverted.
rewritten over?
Where did that come?
That was the other thing. Important point. You would lose your clearance, fired, and probably prosecuted. Exactly. And what about this, Carmen? You're just days away from trial, even in trial, and this video evidence is coming about. Why? Where did it come from? If you guys say you don't have a master, what I call a raw data, a raw copy of the Sallyport video, then how in the hell are you reproducing all this for trial? If it was written over after 30 days, you're telling them, the defense, there is no raw file with the metadata, but yet you're able to produce all of this evidence and videos that suit and fit your needs? That's bullshit.
Then on October 24th, we get more video. This past October 24th, well after the trial, we get more video of Brian Higgins out at the location of CPD on his phone. Where are these dribs and drabs of video coming from? That's all we're asking.
Exactly.
And Mr. Brennan should want the
October 24th. Did that video come with the metadata?
No.
Whoa!
It's a video file. And I'll also, that's a great point.
Okay, I got to try and find the section. I don't know where it is. I'm trying to find the section, but the problem is that nothing that they are giving the prosecution is giving the defense has any kind of metadata. And that is vitally important. Metadata is crucial. Crucial. Yes, my dear, you're on.
Yeah.
Let me do this. Let's not do this right now. I will go back and find it during the afternoon session. And then we'll watch it later.
Okay.
I need to read this document.
Okay.
I got a private message from somebody. Pretty lies and alibis is in the courtroom on this case. She said the jury is paying close attention. Thank you. I have somebody who knows somebody's in the courtroom, and I've asked them if they could tell us what the person screamed out in the courtroom just before the lunch break, and the jury was whisked away. I'm sure that there's going to be some serious legal talk about that. Wowza. Okay, let me get this up and going. Miss Diane, are you okay?
Yeah.
Are you sure? Not really.
Well, look.
Oh,
Wait. Oh, where did it go? I lost it.
oh, right. Well, let me get this up and running and get this to where we can interpret and read. Okay, we left off.
Hey, like the,
Huh?
hey, like the fact that eggs are $8 a dozen.
$8 a dozen now? I thought they were $6.
No.
I'll go without the eggs. Thank you very much. I love eggs, but not for that price.
Yeah.
Okay, let's get going on this. Contrary to the longstanding federal as well as state case law, the trial court gave no consideration to any of the existing valuable alternatives to a mistrial, nor was defense counsel consulted or given any opportunity to be heard, and in relation to the court's declaration of a mistrial. At no time prior to the trial's court finals, Bonte decision to respond to the jury's note by declaring the mistrial had the trial court even mentioned the word mistrial. And in these circumstances, the Commonwealth did not satisfy its heavy, well-established burden of establishing manifest necessary as a condition precedent for the mistrial, which was declared in violation of petitioner's double jeopardy rights. The defense independently maintains that the jury's final unanimous agreement that Miss Reed is not guilty constitutes an acquittal for double jeopardy purposes, and that the trustworthy and uncontracted post-trial affidavits
Uncontradicted.
uncontradicted. Thank you. The things are starting to. The dyslexia is starting to move the words around. Affidavit entitled her to a minimum to a jury inquiry on the issue. The prosecution wants this court to, in essence, ignore the declaration of the jurors, ignore the possibility, if not probability, that the jury unconditionally, finally, without any ambiguity, unanimously found Ms. Reed innocent, and avoid any post-trial inquiry that could demonstrate that all 12 unanimously rejected the sufficiency of the prosecution as to 2 of the 3 indictments. The defense had more than met the burden of the prosecution regarding the jury's decision to acquit Ms. Reed. Neither the trial court nor the SJC held otherwise. Instead, the state court erected an impenetrable procedural barrier to prevent Ms. Reed from providing what is clearly true. That the jurors finally and unanimously agree that Miss Reed did not commit the murder, Redrum, nor the second charge of leaving the scene for which she stands charged. See, they found her innocent on count 1 and count 3, but for the second count, charge of leaving a scene, they found her innocent per a interview with one of the jurors. What they were arguing over was driving while intoxicated, the major lesser out of everything. But at the same time, everybody was driving while intoxicated, including Canton PD officers. This ruling is irreconcilable. Is that what it is?
Where are we at? Which line?
Third line. Irreconcilable with the constitutional interest in having decisions by jurors respected and honored. Public respect for the jury requires that agreements reached by the jury of the defense peers in matters so consequential not to render irrelevant. For these reasons, I'm not feeling well all of a sudden. Federal court favors post-trial voir dires, and denial of such inquiry here violated Miss Reed's 4th, 6th, and 14th amended rights. Y'all, I'm going to take a comfort break real quick.
Okay,
I apologize. I'm going to put this back on. I'm going to take us off. I'm going to do this. I will be right back. I promise. Hello. I'm sorry, guys. I suspect that sour cream may not have been very good in that baked potato. It bothered me a little bit. Hello, Miss Diane.
Hello.
I remember where you could buy 72 eggs for $4.99
Where?
in a box.
Where?
Oh, at the grocery store. Sorry about that, guys. I did not mean to make that inappropriately. I don't follow it. What's going on with the egg thing?
Oh, it's because of the bird flu thing.
So there's no birds who can lay eggs?
Well, no, they're just concerned that it's going to affect the chickens, of course.
Well, the chickens aren't going to come alive, so.
Well, you know.
Are they thinking it's going to pass through the egg to us?
Yeah, I think it's going to affect the egg prices. You know how it goes. Anyway, they can jack price.
Yep. Okay, I'm going to start reading again. I apologize. I'm going to start reading again.
All right. I'm here.
Okay, procedural background. On June 9th of 2022, Miss Reed was charged with 3 separate indictments. I mean,
we have Rose Meadow Pearl trial. Rose Meadow Pearl trial.
What?
It says Rose Petal Myrtle trial. Rose
yeah,
Myrtle.
Redrum.
Right.
I'm trying to get everything adjusted while I was reading.
All right.
No, that's not what I want to do. Quit trying to do stuff that I don't ask you to do. Okay, here we go. On June 9, 2022, Ms. Reed was charged with 3 separate indictments with second-degree murder in violation of Massachusetts Mass state law. That's all I'll do. I'll abbreviate Mass state law. Manslaughter while operating under the influence of alcohol in violation of Mass state law. So she was, 1, charged with 3 separate, the first count, second-degree redrum. Second count, manslaughter while operating under the influence of alcohol. And third count, leaving the scene of a collision resulting in the death in violation, all of which of Mass state law. The juror that was in the interview, my input, said that on the first and third, 100% not guilty. This is where I don't think the jury instructions were clear. They did not find her guilty of manslaughter operating under the influence of alcohol violation. The juror said their question was there was a lesser in that charge for driving while under the influence, and that was the one that they were grappling with. And the problem is I don't understand why they have all those lessers. I think it's BS. Anyway, so because of all of that, I got to stop that music. It's driving me crazy while I'm trying to talk. I don't want to have to talk over it. After the mistrial, Miss Reed moved to dismiss count 1 and 3 in double jeopardy grounds, contending or stating that the jury reached a final unanimous decision acquitting her on those charges. And second, there was no manifest necessity supporting the mistrial. As set forth, more detailed infra. The motion was predicted in part upon an affidavit by counsel reflecting the statement of 4 deliberating jurors that the jury had agreed that Miss Reed was not guilty of the relevant counts, and a secondhand statement attributed to the 5 jurors. So 4 of them directly and 1 indirectly were saying that that was their count. On August 22nd of 24, after hearing oral arguments, the Superior Court issued an order denying Ms. Reed's motion to dismiss. Not shocked there. In September 11th, 9/11/24, Ms. Reed filed a petition for relief to the Supreme Judicial Court, SJC. Diane, you can sign that, SJC Mass, MASS. I'm not trying to boss you, I'm just trying to help you break it down. And September 19th of 24, a single justice of SJC, the name is D. War, reserved and reported the case without decision to the full court. February 11th of 25, the SJC issued an opinion, hereafter opinion, attached as Exhibit B, ... The SJC held that 1, trial court acted within discretion in deciding that the jury was at an impasse and that the mistrial therefore supported by manifest necessity. Notwithstanding that the jury never clearly stated the impasse extended to all counts. A post-trial affidavit made it clear that it did not. Number 2. The trial court adequately considered alternatives to mistrial. Anti-Bev did not. Notwithstanding the court's intention of declaring a mistrial was not so much as mentioned until the trial court sua sponte declared one. And 3. The trial court was not required to consult with counsel or give counsel an opportunity to be heard regarding the prospect of the mistrial because it had previously solicited counsel's view on whether to give a Trudy Rodriguez charge designed to prevent a mistrial in response to a prior jury's notes, without mentioning the possibility of a mistrial. And number 4, the lack of formal verdict announcement in open court precludes any later claim that the jury, in fact, had unanimously and finally decided to acquit Ms. Reed of 2 out of 3 charges against her. And lastly, 5, the defense was not entitled to post-verdict inquiries to substantiate the claim of acquittal because the availability of such inquiry is limited to claims of extraneous influence or jurors' bias. In other words, you're shoot out of luck. Miss Reed is entitled to a federal review of her honorable jeopardy claim prior to retrial. So they're asking for a federal inquisition. Because Miss Reed is currently released on bail, she is in Commonwealth's custody as required. First Circuit Court made it clear a petition for habeas relief that raises a colorable claim for formal jeopardy need not invariably await trial and convict in the state court. Excuse me. Such claims are distinctive because the Constitution insists that the court may not impose more than one punishment for the same offense, and prosecutors ordinarily may not attempt to secure punishment in more than one trial. Double jeopardy. As the Supreme Court observed, the rights conferred on a criminal accused by double jeopardy clause would be significantly undermined if appellate review of double jeopardy, that's being charged twice for the same crime, claims are postponed until after the conviction of sentencing. To be sure, the double jeopardy clause protects an individual against being twice convicted for the same crime, and that aspects of the right can fully vindicate on an appeal following final judgment. However, that comes from the movie Mother Knows Best. This court has long recognized that the double jeopardy clause protects an individual against more than being subjected to double punishment. It guarantees being twice put on trial for the same offense. So double jeopardy is a double rule. 1, you cannot be found guilty twice for the same crime. So they can't go in and charge you with the crime you're found guilty, then go back in and charge you with the same crime with a slight modification, but the same crime, and be found guilty again. The other side to that coin is you can't be tried twice for the same offense, whether you're guilty or innocent, in the verdict. Obviously, these aspects or guaranteed protections would be lost if the accused were forced to run the gauntlet a second time before an appeal could be taken, even if the accused is acquitted or if convicted, has her conviction ultimately reversed on double jeopardy grounds, she or he has still been forced to endure a trial that double jeopardy clause was designed to prohibit. So they're saying, Your Honor, we have to resolve this before we go to trial on April 1st. I am on the high side fence that we are not going to make it to April 1st. It's going to be postponed. To realize the solemn promise of the constitutional guarantee, federal habeas courts will, in appropriate circumstances, entertain a claim that's permitting a nonsense but yet incomplete state court prosecution. I'm sorry, Diane, this is getting a little deep. To go forward would violate the double jeopardy clause for the reasons set forth in the infrasection. For the defense contends that Miss Reed's retrial on counts 1 and 3 would violate her federal constitutional protection against the double jeopardy. According to Miss Reed, you may seek a federal habeas corpus relief without first undergoing trial. Oh, this is hard. Trial on the challenging indictments. Because double jeopardy, I'm going to do double charge, protects the interest wholly on the unrelated to the property of any, I can't sign and read this at the same time. Property of any subsequent convictions. I can sign it without speaking it. That's not the problem. A requirement that the defendant runs an entire gauntlet of the state's procedures, including retrial, prior to the consideration of his or her claim in federal court, would require her to sacrifice one of the protections of double jeopardy. Citation omitted. Fact. On June 25th, 2024, the jury of Miss Reed's first trial began. deliberations after receiving instructions from the trial court. The court instructions to the jury, side note, in my humble opinion, sucked. You should continue to deliberate until you have reached a final verdict on each charge. It also noted on count 2 contained lesser included charges of involuntary manslaughter or motor vehicle homicide, which the jury should consider. The motor vehicle homicide is the one that involuntary manslaughter was the one that they were hung up on. Even if the Commonwealth failed to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor the following day on June 26, 24. Outside the presence of the jury, counsel for Miss Reed raised an issue regarding the verdict form. He did. With respect to count 2, the original verdict slip provided only one option: to find Miss Reed not guilty before going on to ask whether Miss Reed was guilty of the offense of the lesser charge, or the quality of one of the two lessers insufficient included offenses. See exhibit. B, to affidate the support of the motion of amended jury verdict slip. Counsel asked that the form be amended to provide not guilty options for the subordinate charges under count 2. So count 2 was the original count for count 2 was the manslaughter or the slip count 2 original verdict slip provided that option. Miss Reed was guilty of offense charged. I'm catching up. Counsel asked that the form be amended. Okay, there it is. The trial court initially indicated its disagreement with the counsel's request. So the counsel wanted it to say not guilty for involuntary manslaughter, not guilty for whatever, vehicle unaliving with while under the influence of alcohol. They wanted guilty or not guilty listed by each of the lesser options. However, after considering the matter further, the court agreed to provide a supplemental instruction and amend the verdict slip. Later that day, the court provided a supplemental instruction telling the jury that count 2 encompasses 3 separate charges. Most serious was manslaughter while operating a vehicle under the influence of liquor. The jury should first focus on the lead charge. And if the Commonwealth failed to provide a crime beyond a reasonable doubt, then consider the remaining lessers offenses in the descending order. That to me, I think is so unfair. Miss Diane, I'm sorry to do this. I have to take another comfort break. I will be right back. Forgive me, y'all. That lunch is not settling well.
I'm going to do the same thing.
All right. We will both be right back. Whoa. Hey, Diane. Hey, y'all. I'm sorry about that. Ooh. Hopefully we done for the day on
Well,
that.
I got about another 30 minutes or so. Okay.
If you want to go, you can go. I'm just going to read this. We won't be back in court. If we will, we'll barely be back in court.
All right, then I'm going to scoot and we will chat again a little bit later. Okay.
Yeah, and I loved having you. I hope to have you again soon.
You
What? And April 1st is the start of the Karen Reed trial.
Okay.
The one trial I was hoping to have you on like a lot.
Well,
you would still be in school during that time.
Well, yeah, school will finish in May, but I will be able to, if y'all have afternoons on that, I'll be able to do some
Oh,
afternoons.
it's going to be morning and afternoon. It's going to go till 5 o'clock your time.
Okay. All right. That will work.
So I don't mind interpreting because that's going to be one trial that I'm not going to be doing a lot of talking on. No, because this is and I've got notes and see, I want to be able to take notes, but I
Okay.
won't be able to if I'm interpreting. So,
Sure.
but what I can do if you come on in the afternoon and then do some interpreting, then I can go back and watch while I interpret it and make my notes.
Okay.
But
Another thing I want to do is I'm working on my office is I want to set up a second monitor on my desk. And so when the student is doing stuff that I don't have to be interpreting for with him, that maybe I can take
signing
myself,
over here.
maybe I can take myself down and bring myself up on you, but I can still see him.
So I'll do like I do, I put you back here in the back office and you're ready to go. And then when you can always type, hey, I'm ready, and I can pop you up.
Yep. Maybe, 15, 20 minutes here and there.
That would be a big help. And then that way that'd give me a break because that is one trial that I really want to get the interpreting on. I wish you knew somebody who would be willing to interpret for free, either an intern or somebody who's and would love to be a part of this.
Okay, well, I will keep my ears and my eyes and my fingers open.
Yeah, I don't dare try to pull anyone from San Antonio. And a lot of people with their certifications say it's court. I can't do it. I'm not certified. Well, you are interpreting a court proceeding, but you are not a part of, you're not in the building. This is entertainment court.
Yeah.
It's a big difference. And some people just are too afraid that their license are going to get in trouble. So,
Yeah.
you've got people who like to start problems. But anyway. All right.
Yes. Well, let's chat later today, okay?
Love you, hon. We'll talk later.
All right,
Bye. Okay, guys. So that was Miss Diane. She's an amazing woman. Absolutely adore and love her. I really, really wish I could have her like I did earlier this year. She was phenomenal. She started interpreting for us when I first started, and I had her a lot more of her time. So, 2:30 Eastern, 3:30. Hold on. Okay, so I'm going to go ahead and continue reading this while we are waiting. Thank you guys so much for hanging with me. We do have a lot of pages to read with this. Oh, that's not what I intended to do, but it did it anyway. No, yes. Okay, I'm going to put it up here. Bigging it just a little more. And I'm trying to get it to where I'm trying to get it to where you guys get a better view of it. No, 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 no. Let me edit this and make me a little smaller. There we go. There we go. All right, that makes me a little smaller so it's easier for y'all to read. On June 28th, the jury sent the following notice to the court. I'm writing to inform you on the behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been able to reach a unanimous verdict. That was on June 28th of 2024, trial at 4 room 205. That baked potato is not liking me. I think something was off with the sour cream. The court asked counsel for the views on whether there had been whether there had been a due and thorough deliberations sufficient in supporting the giving of the so-called Truy Rodriguez charge. The Commonwealth responded that the charge should not be given unless there is simply hadn't been sufficient time yet. June 28, 2024. Counsel for Mr. Disagree requested the court read the Trudy Rodriguez model instructions and go from there. The trial court sided with Commonwealth, ruling I am not prepared to find that there have been due and thorough deliberations at this point, so I'm going to send them back out. On July 1st, the jury presented another note stating, quote, despite our commitment to the duty of entrusted into us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The difference in our views are not rooted in the lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to the point to where consensus is unattainable. Consensus is unattainable. We recognize the weight of this admission and the implication it holds. I want to know who wrote that. That is like brilliant. I love it. Brilliant. Good job. Afternoon, Miss Journey. Hi, June. Yes, $36 for 60 eggs a month is ridiculous. July 1st. Upon asked by the court, the parties re-entered their same previously expressed views. The Commonwealth taking the position that due and thorough deliberations had not yet occurred, while Ms. Reed's counsel argued the court should give the Trudy Rodriguez instruction. Oh, so this was a floor person who's an ex-cop who's current doctor's assistant. Okay, that explains it. Commonwealth had taken the position in trial court to give the requested instructions. Later that day, the jury sent yet another note. Thereafter, without reading the note to the counsel and without providing counsel with either an opportunity to be heard, this is where they're making their charge. Thereafter, without reading the note to the counsel, without providing counsel with either opportunity to be heard or the opportunity to consult with their client about the implication of the potential mistrial on one or more charges. Footnote 3 in the SJC's words, Trudy Rodriguez charges a model instruction given when jurors report a deadlock after due and thorough deliberation that is designed to urge the jury to reach a verdict by giving more serious consideration to the opposing point of view. So if anybody wanted to know. So do you think the defense should be pulled from the case? Or like I do. I don't think so. I really need to see more information on it, in all honesty. I need to see a whole lot more information. Let's go back to this sentence. One or more charges. The trial court simply stated the jury is at an impasse and immediately called in the jurors. It then read the note on the record. So what they are saying she should have done was put the note on record, allow the attorneys on both sides to have that conversation, that important conversation. But she did it in reverse. Oh, by the Commonwealth. We don't actually know they lied. The information was misrepresented for sure by the Commonwealth. Well, I really need to visit that back again, Haley Mouse. It's my understanding that the Commonwealth made a mistake and that the information did in fact come from the defense. They did not hide anything. Despite our rigorous efforts, we come back to the document. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspective on the evidence are starkly divided. Some members of the juries firmly believe that the evidence surpasses burden of proof, establishing the elements of the charge beyond a reasonable doubt. But which charge? Conversely, others find the evidence fails to meet the standard and does not sufficiently establish the necessary element of the charges. Again, which charges? The deep division is not due to lack of effort or diligence, but rather sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. Did anybody see the interview with one of the jurors? He said that they were like, well, all of them, she was driving under the influence, and we should find her guilty of that if we can, type attitude, which was not what was supposed to happen. That was not the charge that was in front of them at that moment. Oh, I lost my place. Sorry. Went too far. Maybe not. Haven't seen that. There we go. After reading the note without soliciting the views of the counsel in any way, any respect, the trial court asked, I'm not going to do that to you folks. Your services is complete. I'm declaring a mistrial in this case. Boom. Done. The jury was inexcused and ordered to leave the courtroom. Counsel was not invited to speak during this entire interaction. On the following day of July 2nd of 24, unsolicited by any party, one of the jurors, Juror A, contacted one of the attorneys for Mr. Reed, Mr. Alan Jackson. Juror A stated that he or she wished to inform Mr. Jackson of the true results of the jury deliberation. An affidavit of Alan J. Jackson, according to Juror A. The jury unanimously agreed that Karen Reed was not guilty on count 1, second-degree murder. Juror A was empathetic that count 1, second degree, was off the table. Emphatic. Sorry. And that all 12 jurors were in agreement that she was not guilty of such crime. The jury also unanimously agreed, and by the way, footnote 4, the purpose of adjudicating Ms. Reed's double jeopardy claim, both trial and court, the SJC accepted the juror's statement reflected that the post-trial affidavits as true and accurate. That Ms. Reed was not guilty also on count 3, leaving the scene with an injury or death. One day later, on July the 3rd, another attorney for Ms. Reed, David Yannetti, was contacted by 2 different individuals, herein informant B and C, who had received information from 2 distinct jurors, hereafter juror B or C, both whom were part of the deliberate jury in this case. Information B sent Attorney Yeti a screenshot that he or she received from someone here in Intermediary B of the message that Intermediary B had received from Juror B. In that screenshot, Juror B texts the following to Intermediary B, in parentheses. It was not guilty on the second degree. It was split in half for the second charge. I thought the prosecution did not prove the case. No one thought she hit him on purpose or even thought that she hit him. Not one thought she hit him on purpose or even thought she hit him on purpose. Juror B later placed an unsolicited phone call to Attorney Yeti confirming that the information contained in the publicly filed affidavit was correct. The supplemental affidavit, and this is going to, Juror B later placed an unsolicited phone call to Yannetti confirming the information contained in the publicly filed affidavit was correct. So one of the things that they're arguing is that the other 7 jurors, if they felt that the information that was given in the affidavit and in public social media and everywhere else was incorrect, that they could have at that time spoken up and called in either to the defense or to the prosecution and shared their side of the story, which in fact they have not done so even up to today. Juror B later placed an unsolicited phone call to Attorney Yannetti confirming that the information, Juror B clarified, however, that she had meant to write, no one thought she hit him on purpose or even knew if she had hit him, i.e. clarified that text. I'm trying to get a blanket over my legs. I'm getting cold. Okay, so there you go. Juror B further told Attorney Yannetti that she believed that every member of the jury, even if asked, would confirm that the jury reached a non-guilty verdict on indictments 1 and 3. Informant C had been in contact with another individual. Intermediary C, who is, how do you like my leprechaun? Who is a co-worker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. Informant C sent Attorney Yannetti the below screenshot of his or her text message with Intermediary C regarding what Juror C revealed in the Zoom meeting. And here it is, y'all. Intermediary C, we'll just say person C, informant C. No consideration for murder 2. Manslaughter started polling at 6-6, then ended up deadlocked. 4 no's, 8 yeses. So the involuntary manslaughter was the one they were hung up on. Informant C, interesting. It was not considered for murder 2. Shouldn't she have been acquitted on that count? hung on the remaining charges since go back to the jury verdict slip. That was all confusing. Intermediary C, she should have been acquitted. I agree. Yes. The remaining charges were that they were hung on. And that instruction paper was very confusing. Mind you, it may not sound confusing to us who have been around the law, crime, and court TV and lawyers and people in this field. It may not be confusing to them, but most jurors have little or zero legal exposure and are not professional. They don't have professional jurors. After the filing of Mrs. Reed's initial motion to dismiss, but before the Supreme Court hearing in the motion, Attorney Jackson was contacted by two other deliberating jurors. First, juror D as in David stated that the jury reached a not guilty verdicts on count 1 and 3, again confirming the other jurors, A, B, and C, and that the disagreement solely was on count 2 and its lesser supplemental affidavit. He recounted that after the jury was excused and boarded the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on counts 1 and 3? Juror D unequivocally told counsel, every one of us will agree and acknowledge that we found Karen Reed not guilty on counts 1 and 3 because that's what happened. Juror E similarly stated that the jury was unanimous on 1 and 3, that Karen was not guilty on those charges. Second supplemental affidavit to Mr. Jackson. The Commonwealth filed, what page are we on? Oh my gosh. The Commonwealth filed a post-trial notice of disclosure informing the court that on Sunday, July 21st, 24, Assistant District Attorney Adam Lally received an unsolicited voicemail on his office phone from an individual identified themselves as a juror by full name and seat number, Commonwealth notice at 1R325. The message stated in parentheses, it is true that it has come out recently. The jury was unanimous on charges 1 and 3. Assistant District Attorney Lally received a subsequent message from the same individual saying that he confirmed unanimous on charges 1 and 3, not guilty, and at least 9-3 guilty on manslaughter charge. So they were not, so if those other three flipped, she would be in jail right now. The Commonwealth additionally received emails from 3 individuals who identified themselves as jurors and indicated they wish to speak anonymously. The Commonwealth declined to subsequently respond to the voice messages or emails, instead claiming in responsive email that it was ethically prohibited from discussing such matters. Wow. Wow, that's all I can say. Whew. Excuse me. Re-prosecution on counts 1 and 3 will violate Ms. Reed's double jeopardy rights. Standard in review, Section A. Because Ms. Reed is awaiting trial on the state's criminal charges, she is not in the custody pursuant of SJC's judgment. Law ... Vacated on other grounds and subsequent reinstated. Accordingly, this petition is brought under the 28th USDC ... Section 2254. Restrictions on the scope of habeas review, therefore, does not apply or do not apply. CID at 7. Instead, the court must defer to the SJC's findings of fact, but must undertake a review of the court's resolution of issue at law. Habeas corpus petition governed by 2241 are not subject to the heightened standards contained in 2254. Oh, let's just get to it. Ordinarily, a motion to dismiss on double jeopardy grounds rests on a pure question of law. The court's review of de novo. The Constitution protection against double jeopardy. The ancient right to a jury trial is no mere procedural formality, but rather a fundamental reservation of power to the American people. By requiring an executive branch to prove its charges to unanimously jury beyond a reasonable doubt. The Fifth and Sixth Amendment to mitigate the risk of prosecutorial overreach and misconduct include the pursuant pretended offenses and arbitrary convictions. Citation omitted. Prominent among the reasons of colonists cited in the Declaration of Independence for their break with Great Britain was the fact, oh my God, I'm learning this right now. Great Britain was the fact that Parliament and the Crown had deprived them of many cases to benefit of a trial by jury. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, the founders saw the representative government and a trial by jury as the heart and lungs of liberty. It is so crazy that this is the time in my history class that I'm learning about right now. This is absolutely insane. Just coincidental. It follows that a jury acquittal is entitled to the most respect in the criminal justice system. See Martin Line Supply versus U.S. ... Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that the verdict of an acquittal could not be reviewed or aired otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. Citation omitted. Double jeopardy clause provides that no person shall be subject for the same offense twice and put in double jeopardy. Okay. The underlying data, one that is deeply ingrained in at least an Anglo-American system of jurisprudence, is that the state, with all its resources and power, should not be allowed to make and repeat attempt to convict an individual for an alleged offense. Green versus United States, 1957. Even though the first trial was not completed, a second prosecution may be grossly unfair. It increases the financial and emotional burden on the accused, prolongs a period in which he or she is segmentized by an unresolved accusation of wrongdoing, and in bold, italicized, may even enhance the risk that the innocent defendant may be convicted. Arizona versus Washington, 1978. Also see Martin Line. In parentheses, at the heart of this policy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm the government with potential instrument of oppression. Then the second quote is, the clause guarantees that the state shall not be permitted to make a repeated attempt to convict the accused, therefore subjecting him or her to embarrassment, expense, and ordeal, and compelling him or her to live in a continuing state of anxiety and insecurity, as well as enhancing the publicity that even thought innocent, now she may be found guilty, he or she. Okay, C. Prosecution is number C. Re-prosecution is barred because there was no manifest necessary to declare mistrial on the counts which the jury was not deadlocked. As a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. The rule is rooted in the importance of the defendant of being able to once and for all to conclude her confrontation with society through the verdict of a tribunal that she might be believed to have favorably disposed to her fate. Double jeopardy clause can afford a criminal defense of value to have him or her trial completed by a particular tribunal, citation omitted. Thus, after a mistrial has been declared without the defendant request or consent. Footnote number 5. The permissibility of retrial depends on whether there was or is a manifest necessity for the mistrial. The power to discharge a jury without a verdict ought to be used with the greatest of caution under urgent circumstances and for very plain and obvious reasons or cases. Italicized and in bold, and I'm highlighting here. Importantly, the heavy burden of establishing manifest necessity to justify mistrial is exclusively on the Commonwealth. Emphasis added. Really? I had no idea. A burden that the state courts erroneously placed on the defendants. In assessing whether the prosecution satisfied its burden on the point, the First Circuit Court has stated it is useful to consider the following 3 factors. What are the following 3, you may ask? They are, number 1, whether the trial court consulted with the counsel. Not the last time, the first 2 times she did, but not the last. Number 2, whether the courts considered alternative to a mistrial. I don't think she did that either. And number 3, whether the court adequately reflected on the circumstances before making a decision. I don't think she did that either. Embracing both considering of all of the alternatives in conclusion with counsel, which she did not do on the 3rd time, is the amount of time devoted by the judge to the mistrial decision. I don't think she took that much time. A precipitated decision reflected by a rapid sequence of events accumulated in a declaration of a mistrial. So they're saying she didn't do her due diligence to indicate insufficient concern for the defendant's constitutional protection. Under the footnote 5 of the SJC, Supreme Judicial Court did not find that Ms. Reed or her counsel consented to the mistrial here. See opinion 25 in note 13. And for good reason. Neither Ms. Reed nor her counsel requested or expressly consented to a mistrial. While consent may, in some circumstances, be implied from the failure to object, any of these findings requires a bare minimum that the defendant had an adequate opportunity to register an effective objection, which they did not. This happened pretty quickly, and they were so shocked. I guess they were just sitting there going, "Duh, George? What just happened, sir?" Although in other circumstances, a reviewing court may defer to the trial court's discretion to make the mistrial decision. If the record reveals that the trial judge has failed to exercise the sound discretion entrusted to him or her, the reason for such differences disappear. Stating that this Commonwealth versus Stewart, Mass, 1985, stating that the differential review of the trial court's exercise of discretion as to when to declare mistrial is appropriate. Only if it's clear from the record that the judge has given clear consideration to the available alternatives and the defendant's interest in having a trial concluded is a single in a single proceeding. Here, the SJC at the onset committed legal error by relying heavily upon the trial court's discretion, notwithstanding that the record reflected that no consideration of any alternative to a mistrial. We got a seal. No exercise of such discretion. We're going to pause here because I don't want to lose my place. I'm going to bring that down. I'm going to put this back over here. I'm going to put me back where I belong. Hey, y'all. I just thought y'all might want to change your view. I agree. We don't know. Do we think that the defendant should be pulled up on this case for lying? I do. I don't know if they've lied. I think that there was a big confusion as to who gave the information to the Commonwealth. And the Commonwealth stated it came from the feds. Then they backtracked the defense, and then all of this stuff happened. So if Auntie Bev is smart, she's going to sit there and she is going to look at all of this very carefully. We don't actually know that they lied. The information was misrepresented for sure by the Commonwealth. They made a mistake in the presentation. And I did see Lawyer You Know and Law and Lumber and all that catch that. Excuse me, my lunch is not sitting well with me. And I apologize for that. Oh my gosh, I'm tired. Ooh, excuse me. Um, forgive me, I'm trying to find information. And I may not be able to find. May not be able to find. I would love to find that information. That let me put my phone there. I'm gonna try while this is going. Once this court starts, I'm gonna try and find the spot where they're talking about Turtle Boy in the motion hearing. The problem is finding it. And I know that was it June? If you can tell me if you can find it in the hearing, that would be great. I'm looking for the raw feed. I'm going to get the raw feed of that hearing, and then I'm going to, I don't want the show. I want the raw feed. I am shocked and pleasantly happy, but shocked at the verdict for ASAP Rocky. Find it very interesting. Here, I found the feed from yesterday. Motion to compel. See, if you can go, let me give you the link. June, here's the link. If you can go there and tell me where it is in the, they do have it broken down by chapter. If you can give me the time frame. because I don't know whether it was under the on the record. Okay, motion to compel production of forensic sound copy. Was it the defense's prohacvis? Is that how you say it? The Commonwealth motion to reconsider order for audio for Gretchen. The motion to compel discovery Elizabeth Little. So if you could tell me at what timestamp that was, that would be great. That would be fabulous. I would greatly appreciate it. I do have this up. I will pull it down and save it. So if you can't, I will do it later. We should be coming back soon. All right, I guess we'll keep reading, y'all. I'm gonna keep my head over here for a while, if you don't mind. Turning to relevant factors, the first thing to be noted is that the trial judge did not give counsel an opportunity to object or discuss with them the advisability of a mistrial. Upon receiving the final jury note, the court declared the mistrial and excused the jury without consulting the counsel. The judge is back, but he's not speaking. Video footage, number 6, reinforces the suddenness of the court's action, corresponding lack of any meaningful opportunity to be heard. The approximate 5 hours, 47 minutes to 25-second mark in the video, the court took the bench and stated, the jury is at an impasse. In contrast to the procedure following as prior notes, this note was not read to the counsel. Instead, the court immediately called for the jury to be brought in. The sound of the George opening and closing could be heard, and then approximately 5:47:55, a mere 30 seconds later, the jury arrived into the courtroom. So they had that jury lined up ready to go into the courtroom. The court then read the note, which was not previously provided or read to counsel on the record, which should have been done. At 5:49:23, the court stated it was declaring a mistrial, immediately discharged the jury at 5:49:30. Well, that's pretty dang quick. A mere 7 seconds later, the circumstances did not provide Ms. Reed's counsel with a meaningful opportunity to be heard. See Ramirez 15:27, finding lack of sufficient opportunity where after hearing testimony regarding potential defect in the jury, Borda District Court stated they intend to declare a mistrial, then called for the jury brought in and discharged them. Another case cited finding the lack of sufficient opportunity to object where the district court only addressed the counsel after reading and confirming the verdict in open court, asked if there was anything else before they discharged the jury. Legal and factual content renders the trial court actions even more unexpected. Legally, trial counsel was entitled to rely on the decades of case law expressly required a full opportunity to be heard before the decision of mistrial. That is what they're fighting over right there, that they had a right to a declaration of a mistrial under Stewart 396 MASH at the 79th footnote number 7, which we'll read in a little bit. Factually, in response to multiple prior jury notes in the case, trial court had advised counsel of contents and afforded them time to first consider and then be heard regarding the issues that were raised. In trial court division, from what we know and anticipated practices respect to the final note was a precipitated decision reflected by a rapid sequence of events culminating in a declaration of a mistrial, meaning she knew as soon as she saw that note and walked in, she was going to declare mistrial. Did not afford the attorneys the opportunity to cite or speak their case, and thus violated the rights of Miss Reed. It has also deprived defense counsel of any opportunity to raise an issue or even discuss potential remedies with their client. Moreover, the defense respectfully submits that given the importance of the double jeopardy protections and the profound implications of a retrial for a criminal defendant, an opportunity to be heard in order to be meaningful occur after a reasonable opportunity for counsel to consult with a client. Nothing in filing a lack of manifest necessity that the counsel had no opportunity to discuss a proposal of a mistrial with their client. Counsel for Ms. Reed clearly had no such opportunity here. The SJC erred in the multiple now they're going to start throwing some shade on the SJC. Respects in ruling that the trial court prior consultation of counsel was sufficient to exclude the absence of such consultation at a pivotal moment prior to any declaration of a mistrial. So there's the SJC, Superior Judicial Court, stated in their decision when they handed it down that because the defense was on the first two notes saying give them the whatever that thing is again, and they were saying declare mistrial, but they assumed they do it again. The discussion related solely to the proprietary is given Trudy Rodriguez. That's what Trudy Rodriguez charge. I'm sorry. So they were in favor of a Trudy Rodriguez charge. And because they were in favor of that, does that mean that they were in favor of a mistrial? I don't know. Which again in design is urged the jury to reach a verdict. Opinion at 5 and 4, cited omitted. The present and presents a distinct legal issue from the declaration of a mistrial. Defense counsel request for a Trudy Rodriguez charge implies that their desire was not to have a mistrial, but instead to have the trial court urge the jury to reach a verdict. So basically, the defense was saying, "Hey, we were wanting a Trudy Rodriguez. We weren't sitting here saying declare a mistrial. We wanted the jury to go back and continue to reach a verdict." Second, I don't know why I keep wanting to call him JHC. The SJC was wrong in assuming that the Constitution regarding the third note would not have produced any fruitful alternatives. Opinion at 23, citation omitted. This reading of the silent record against the defense is contrary to the clear Supreme Court case law, placing the burden of the established manifest necessary on the prosecution. Indeed, the SJC opinion does not so much as mention the appropriate allocation of the burden of the Commonwealth. Moreover, as set forth in infra page on 19 through 22, there were alternatives to the declaration of a mistrial here, so it is far from a clear Constitution that would not have proved fruitful. Okay, we do have courts again. I want to know what that guy screamed. I will put this down and we'll pick it up. I want to know what he screamed. Let me look. Let me see if I got an answer.
Ladies and gentlemen, as I stated at the outset of this trial, I am the sole judge of the law in the case, while you, the jury, sit as the judge of the facts. And part of my role is to make determinations about what evidence can and cannot be admitted and presented to you.
They're not going to allow that to be.
The gatekeeping role rests solely with me, the judge on the law, and I want to instruct you that you're not to consider any testimony that I have instructed you to disregard. Furthermore, you should not even mention or discuss any testimony that I've instructed you to disregard, and I instruct you not to discuss any topics that have been ruled improper when you go to do your deliberation room, okay? All right, please continue, Mr. Morgan.
Oh, he didn't strike it. Oh.
Zach, before we broke for lunch, we were in the time period of end of September, beginning of October of 2021.
They've done something with their mic because I haven't
Yes.
changed mine.
And Zach, you testified.
Okay, the guy screamed
before
solicitor.
lunch.
What? I don't understand. Someone help me. He screamed the word solicitor. That is weird. Okay, let's see what he gets away with.
About 2 offers John had made you to kill Christina Parcell. Do you remember that?
I remember.
And do you remember after the second offer telling John something to the effect of, you would never do that for money. You would only do that if you believed it was necessary to rescue Aida.
And if I believed there was no other way.
So you did it for free.
At the end of September,
Are you
beginning of
confessing?
October 2021, did you conclude that
He
you
didn't
had
admit
to
to
rescue
killing her.
Aida and there was no other way?
Yes, I did.
So you're judge, jury, and execution.
Let's
Uh-oh.
talk about what's happening in your life in the beginning of October 2021. And specifically, I want to talk about the status of the music project you had been engaged with Tom Strange in the Seagull Museum. I also want to talk about other employment opportunities. So tell the jury what was going on in your life on that front at the beginning of October.
At the beginning of October, I was just coming off finishing the project at the museum. We finished in September at some point, and as I mentioned before, my birthday is October 2nd, so I had arranged to play a private home recital at the women's home where I would play the last 3 piano sonatas of Beethoven on my birthday. So these are very, very difficult pieces of music, and some of the greatest pieces of music ever written. So I was very preoccupied trying to give my best to these pieces. And shortly after that, a friend of mine reached out who had done some work performing on cruise ships. There's an organization called Lincoln Center Stage that recruits conservatory-trained musicians to form either a piano quartet or a piano quintet to play classical concerts on cruise ships. And they had a pianist drop out at the last minute, and long story short, I interviewed for this job and got this job. I think.
Don't get me wrong. I've never been on a cruise, and those people who entertain on cruises are good entertainers. I mean, it's not easy for, especially the ones who do the aerial things and on a rocking ship. And I mean, they put a lot of work in. They're good people. Not knocking them, but why would you, of all people, a Juilliard pianist, choose to work on a cruise ship? They don't get paid much, and on top of that, there's a lot of weird restrictions. So I'm perplexed a little bit as to why he would consider that.
On October 12th.
You were that good.
But it was about that time, maybe a little earlier.
Where were the winds on October 12th and 13th?
They were in Europe.
And ultimately, did you take Christina Parcells' life on October the 13th?
Yes, because I believed it was absolutely necessary to save Aida, and I was right.
What?
Sustained. Ask you to disregard.
What? He admitted it? Why are we in trial?
Talk about,
What?
I want to talk about the timing. You've alluded to it a little bit. But I want to be more specific.
I read that
October the
right. He
13th.
confessed. I read it right, right?
Describe for the jury why you felt that was the time, why you waited, or why it was necessary to do it on October the 13th, specifically, or in this period of time.
Was it a Friday?
I had been wrestling with this since
Oh.
June. As I previously stated, since the end of June, I believed Aida was in complete and grave danger every moment of her life that she was living with her mother. And the other things that I had tried to do to save her from that were not working.
You're a psychopath.
So I was having this incredible wrestling match
No.
with myself for these months, feeling that I needed to do something to save her.
No, he did not confess because the state didn't prove it. He's confessing because sometimes it's easier to confess and get a lesser charge and blame that mental, or there was a life threatening, it was self-defense, or is better than lying about it when I think he confessed because he knew that there was enough evidence. I guess. I don't know what, but it may be fun. I'm not saying it can't be fun. I just know people who work on ships and it ain't that fun. It's not easy. It's been a mess, but dang, didn't expect that one at all.
And yet feeling this incredible reluctance to do the one thing that I knew would save her because of how terrible I knew it would be to do it, even though I believed it would be right. So by the time
Why are you
October 13th rolled around, I had been grappling with this for a long time. And I was experiencing a tremendous amount of guilt that I had waited as long as I did because I should have acted sooner. And I didn't do that. So I had come to the realization that
Are we going for insanity?
I had gotten this offer to go on this cruise ship and I would have been leaving the country for a long time. Essentially, it was now or never. I had an opportunity to save her from a danger that I knew she was in and that I knew was not going to cease.
Mother wasn't Cemetery, the one who's going around. Her mother
I
wasn't
just couldn't
Cemetery.
go on with my life and leave her to drown. I mean, I had a great life. I had everything. I made money doing what I loved. I was going to be going to the South Pacific to play concerts for rich people on cruise ships. I mean, but how could I go and enjoy that and know that I was leaving a kid to her fate, a kid who thought that I was her friend? I would never have been able to look at myself in the mirror again if I had done that. So specific to October 13th, I believed that there would be a period of time at the house when Christina Parcells would be alone. And I wanted to make sure that absolutely no one was there. Not Aida, not Lutina, not Brad Post. Because again, this was not about revenge or retribution or anything. I wasn't angry. The only thing I was feeling that day was pity. And I wanted to make
I beg to
sure
differ with that.
that no bystander or no one else would be involved in this, which could have happened if someone else was there.
I disagree with him. There's a lot of rage.
So once you concluded, believed absolutely this was what you had to do, did you go about planning?
Yes, I planned very carefully to make sure, one, like I said, that no one else would be involved in this. And two, I knew that if I tried to do this and failed, it would only be worse for Aida.
I want to see where the fact.
Instructions.
What's the proof that she was being ex-abused?
Because I believe that if I was discovered doing this, it would connect me to John Mello. And I believed, and I still believe, that he's a great father and he is Aida's best shot at having a happy and safe childhood.
Let's talk about the planning. Did you get a gun?
Yes.
At the time, were you also carrying your own firearm?
Yes, I had a concealed weapons permit at the time, so I generally would always be carrying a 9mm concealed weapon on my person for personal protection.
Did you get another firearm for this?
Yes, I did.
What type of firearm did you get?
It was a .22 caliber revolver
Oh, that's really going to do the
at
job.
a gun show.
Oh, that's going to help the gun shows.
It was here in Greenville.
It's not the gun show's fault.
How long before October 13th did you get the 22?
Maybe a month or a month and a half earlier.
Did you also get a knife?
Yes, I did.
Where did you get the knife?
At the gun show.
At about the same time?
It was the same day.
Let's talk about what else, what other planning you did. Did you obtain gloves?
Yes, I did.
Remember where you got the gloves?
No, I don't.
Did you obtain any chemicals?
Yes, I bought some paint thinner because, again, I didn't want to be connected to this because I wanted to make sure this would actually do something to save Aida. So in case a glove had broken or I had left a fingerprint or something, I wanted to be able to clean it with the paint thinner.
Wow. I'm okay.
Let's talk about. Let's talk about.
I want to see Frost. Frost should be firing.
What you did to become familiar with the area of Cane Break leading up to October the 13th.
I had looked at a route I would be.
Oh, snap it. What happened? I apologize, guys. This can happen every once in a while. Come on. Get me out of this. Why is this acting up? Hold on. Why? I'm going to have to go to another one. This is acting up.
Would actually do something to save Aida. So in case a glove had broken or I had left a fingerprint or something, I wanted to be able to clean it with the paint thinner.
Zach, let's talk about, your bike and what you did to become familiar with the area of Canebrake leading up to October the 13th.
I had looked at a route I would be able to take from the mountain house that I was staying at on back roads to avoid traffic cameras. So
Yes, you didn't
maybe
do
a
a good
few
job of
days
that, did you?
beforehand, I looked at Google Maps and I figured out how this route would lead.
Explain the roses. That's what everybody really wants to know.
Let's
Did
talk
she hit you
about
with them or did you hit her?
October the 12th. Did you originally plan to do this on October the 12th?
Yes.
Zach, consistent with the court's instructions, describe to the jury why you didn't do it on October the 12th.
I woke up that day and I just felt such reluctance, and something in my gut told me it wasn't the right day. And I waited one more day.
Let's go to October the 13th. You testified earlier that you wanted to plan in part to prevent or minimize danger to others. Remember that?
Yes, I do.
Did you have information about where people would be on October the 13th?
To a degree, yes.
How did you get that information?
From John Mello.
What did he tell you?
He told me when Aida would be at school, and he told me that he believed Christina had a job interview at some point that morning.
So let's talk about that morning. The evening of October the 12th, where did you spend the night?
At the mountain house.
You woke up on the morning of October 13th and you left the mountain house, is that correct?
Yes, it is.
Do you remember approximately when you left the mountain house?
It was much later than I meant to. I think it was about 8 or 8:15 in the morning.
When you left the mountain house, in which vehicle did you leave?
In my Ford Ranger.
What was in the back of the Ford Ranger?
My bike.
That bike right there?
Yes.
And just for
I'm a little shocked, y'all. He freaking admitted it.
This is a state's exhibit. I don't have the number that was in it.
I am utterly shocked. Wasn't on my bingo card.
What else did you put in your pickup truck in addition to the bike?
I brought the gloves and I put this in a backpack. I brought the paint thinner and the gun I described, the 22.
That's
I brought
interesting
knife.
that he got a 22. If you're going to unalive someone like this, you get a 9mm, not a 22.
That was made to look like a gift wrapped box. And
Guys, 22 has a chance of just bouncing around in you. It can be very lethal, don't get me wrong. But a sure shot, we're going to get you a lot bigger caliber than that, like a 45 or a
bunch
9.
of roses that I had bought the day before.
I know, Natalie.
Roses in a minute. When you left the mountain house,
I'm with you on that.
where did you go?
I've never heard somebody admit it. This
to
is
a
a
road that
mission
runs
for me.
parallel, very close to Canebrake.
When you got to that location, well, before we go further,
I know, but I may
describe
not
for
have
this
heard that part,
jury
Haley. Thank you.
the ride in your truck from the mountain house to this location, what you were thinking, what you were feeling, what was going through your mind.
Like I said, I had wrestled with this for months.
No.
I had come to the point where
You want
rationally I
me?
knew
I don't get
that the only way Aida was going to be saved from what she was enduring was for me to take this route. I knew that. But there's another element, a human element, which is just so reluctant and revulsed by the idea of taking a human life. So
But yet you still did.
I had prayed a great deal about this. I had prayed
Not
like I'd
enough.
never prayed before, because even knowing
Not enough. And who are you praying to?
that logically this was the right thing to do,
I'm not going to agree with that.
it didn't satisfy that emotional and human aspect where I felt that I needed permission to do this. And I was so terrified that somehow I might be doing the wrong thing. Like I knew that it was right
You think?
logically, but there's the emotional aspect was just reeling against this idea. And more so because she was a woman. I was raised to always protect my sisters and mother, and I opened doors for women growing up. So this idea was just repugnant to me, even though I believed it was necessary to save a child. So on that morning, I had prayed earlier, a few days earlier.
Oh,
and
yeah.
I had felt that this was the right thing to do, no matter how terrible and difficult it was going to be.
You think?
So like I said, I didn't feel
Oh, whatever God or Lord is out there that agrees with me. I'm praying for what I'm about ready to do. I mean, come on. You know one thing about praying that most people don't get? Once you pray, you sit down and get quiet and listen. It may take a long time, but you don't act without confirmation. What was your confirmation? Please tell me what your confirmation was that you were to do this. I really would like to know, because I'd like to know how how God relayed that information to you so I won't miss it in the future. He's a psychopath or something. I don't know what he is, but he's a piece of work. Yeah,
Or
no.
I felt pity because I realized that this was just the only way to save a child. And it essentially felt like a foregone conclusion because I knew that I had a duty to do this to save a child.
No, you did not.
So
That's called calling the police,
physically
getting child
driving my
protection
truck there,
involved.
I
Whatever.
was experiencing
Yes,
a
bedroom
level
is
of
not
anxiety and physical illness that I had just never experienced due to stress before.
And
My
you're
hands
good
were
at
shaking. I was in a cold sweat. And I
Oh, a good sign
was
that you should
fighting
be
the
doing
urge to
this.
vomit before I even got close there.
Maybe this
A
is
few
a sign
times I
that you
thought I was
should
going to have to
not.
pull off to the side of the road because I could hardly keep my truck straight. My hands were shaking so badly. But the whole time I was just thinking, if I don't do this, if I turn back, then I'm consigning Aida to her fate when I know that I could have done something
Are
to
you
stop what
Jesus?
was
Is that
happening.
what you're telling us now?
So I just tried to take my mind off of it, and I tried to just go
Yep.
and drive a
You
little bit
got it.
farther and a little bit
You
farther
got it,
and
oh sunny
not
day.
think about what I was going to have to do when I got there. And
Oh, it does.
when I finally
I'm
got
a
to the point
chaplain.
where I parked my
I
truck,
hear it all the time.
this feeling only increased. I knew the plan, but I was having so much difficulty going through with it. So I took my bike out of the truck and I had a mask on and clothing that's been described already. And I just tried to focus on putting one foot in front of the other on my bike. And it felt like some runs or rucks I had been on where all I could do was focus on putting
I
one
see a
foot
movie
in front
and
of
a
the
book
other
coming out
because it
there.
was so difficult to keep going.
I see him writing a
And
book.
I
He's
just
to
kept
me the
seeing
Amber
Aida's
Heard
face
male version.
and reminding myself that if I don't do this, no one's going to come to save her. And
Do you hear voices in
kept
your head?
pedaling, and eventually I arrived in front of 122 Canebrake.
We're going to talk about what happened when you got to 122 Canebrake in just a second.
I want to hear about the flower.
Having a gun and having a knife. Initially, were you going to use the gun?
I think he wants them to just put him in prison.
Did you ultimately decide to use the gun?
He's more warped than Sarah Boone. You got that straight. Sarah Boone and Amber Heard put
I was
together, and
very
I thought that
concerned
would
about
never happen.
using a gun because of how loud it would be. And I didn't want to alert a neighbor or a bystander who might come to investigate and get involved. So I tried to suppress the gun by making a makeshift suppressor.
Which never bodes
And
well.
in movies, these things are made out to be like it's very easy, and a suppressed gun is just very silent. And
No,
that's
it is
not
not.
the case.
It doesn't go.
So ultimately,
They're still out.
I test fired the gun, and I had bought
Realize-
some subsonic ammunition, which is supposed to be quieter, but I
Not
didn't
that
realize
quiet.
that on a revolver, a suppressor doesn't work because the end of the cylinder is open. And I realized just a day or two beforehand that I couldn't use a gun because it could potentially involve someone else in this if someone heard a gunshot and came to investigate.
That's
If you
not
had
the
a
only
choice,
truth I've heard.
would you have rather used a gun?
I would have rather not to have had to have done it at all, but if I had to, yes, I would have chosen a gun.
Why is that?
Because it would have been quicker and more humane.
He is very cold and very icy in this. Oh my gosh.
Let's talk about, you arrive at the house, 122 Canebrake.
I think you hit that on the head now.
What time you arrived there?
I think it was a little after 9 in the morning.
And you arrived there on your bike.
Yes.
And you testified about this a little bit, but tell the jury what you're wearing.
I had on black pants and a black thermal and a gray shirt over that. I had on a black beanie and a white medical mask, and I had on black gloves and a black backpack.
In other words, you look like a thug.
Do you remember how many vehicles were parked in the driveway when you got there?
One.
When you arrived at the house and you got off your bike, what did you do?
I laid my bike down in the driveway, and I took my backpack off, and I took out the box that had been gift wrapped that had an end open, and I put the .22 revolver in that box.
I thought you
And
were going to use it.
put the backpack back on my back, and I took a bunch of roses, and I walked up to the door and I rang the doorbell. And I was shaking and freaking out at this point because there was nowhere I wanted to be less than at that house on that morning. And when I rang the doorbell, the door opened and a woman came to the front. And I thought it was Christina Parcell, but I wanted to make sure. And I also wanted to make sure that no one else was home. So I told her that while I was holding the box and the roses, that I had a delivery for Lutina Parcell, her sister. And she told me that Lutina wasn't home. So at this point, I realized that Christina was at the house alone. And I handed her the roses. And I took the revolver out of the box and I pointed it at her and I told her to be quiet and to go back into the house, which she did.
I can't imagine her.
And I followed her into the house and I shut the door. And I was experiencing such anxiety that my body wasn't really doing what I was telling it to do anymore.
You want us to feel sorry for you on that? And no.
When I realized that I couldn't use the gun, which was unloaded at this point, my plan had been to try to knock her unconscious because I didn't want to cause her or anyone any pain. That wasn't my intention. I just wanted to save Aida and to make sure that no one else who was a bystander would be involved in this or could be endangered in any way. So I tried, while she was holding the roses, to strike her on the head and knock her unconscious.
What am I checking my phone for, love?
My body was fighting me because even though I knew who she was and what she was doing and the danger that was putting Aida in, I was still looking at her and I was seeing a sympathetic figure. I was seeing a woman, and I had always been taught never to hurt a woman, to always protect women and children. So when I went to strike her with the gun, my hand didn't really do what I was trying to tell it to. I essentially pulled my strike. It felt like...
You guys, thank you so much. You are freaking awesome. Dawn. John Mello has been arrested today because of Zach's testimony. Pretty Lies just did a short about. John Mello, that's the ex-husband, right? Oh, snap. Thank you, Dawn. I appreciate that. We'll try and see if we can find some footage on that.
The time I had been cliff jumping with friends. I have a big fear of heights, and there was a 30-foot face that you could jump off and jump into a deep pool of water. And when I would run up to the edge, I would try to get a running start and jump off the edge, and I just couldn't. Like, my body would stop me against my will. And I had to try to do this 10 or 15 or 20 times before I could actually get myself to go over the edge. So when I struck her on the head with the pistol, that's what happened. It didn't knock her unconscious, and I hardly struck her at all, to be honest. So I tried again, and the same thing happened. I just couldn't bring myself to strike her. And at this point, she realized that I was hesitating, and she began to try to move herself and to get away and to fight back. And during this period of time, the roses had dropped and the petals and stems had scattered.
I hate to do this. Deadly Arizona plane crash, mid-air collision live today. 2 planes crashed, 2 dead, 2 alive. Y'all be in prayer for the families.
And as I was hesitating, I realized that this situation was quickly getting out of control. And if I didn't pull myself together and act soon, this was all going to end up terribly for Aida, because what was happening to her would never be
Who is
uncovered.
she, Dawn? Is it Aida?
You heard testimony that at this time Christina weighed 163 pounds. How much did you weigh on October the 13th?
About 160.
Go ahead.
So I realized that
So there was
I
no
was
ball
going to
blower.
have to somehow force myself to do this at any cost. So I pulled out the knife I was wearing. And even though I knew I wasn't going to be able to strike her with any amount of force, I still tried. So I started striking her, though my strikes were pulled. And I think the knife made contact with her, but it wasn't stopping her, and it wasn't inflicting anything that could be a fatal blow. And she started to fight back. She realized I was hesitating, and it became a struggle. And in this struggle, all I could do was try to overcome this resistance I had towards doing this thing. Even though I knew it was right, I still had this physical and emotional resistance to doing it. So I just kept striking her and striking her.
This is worse than a movie.
We fell on the floor. And at this point, I had just tried to take my mind out of it and just try to get through this and finish it as quickly as possible, because I realized that it was only becoming prolonged, and I had to do this in order to save Aida.
So what you're saying is she suffered greatly.
So I don't remember how many times I struck her. I just remember that when it finished, we were on the ground, and I stopped striking her when she stopped struggling. And at this point, I stood up, and I was still freaking out, and I was in kind of a daze. And I was just trying to pull myself together and figure out what I needed to do to leave the house. And again, I wanted to make sure that I didn't leave anything behind that would connect me to it, because then
Well, you did a
I
great
believe
job on
John
that,
would be
didn't you?
connected to it, and it would only further put Aida in danger, because I didn't know if Christina Parcell was the only person involved in what was happening to Aida. And she wasn't. So I quickly looked around to make sure I hadn't left a mask or a glove, and I started to pick up the rose petals and realized that I just didn't have time to do that. Again, I was concerned that a neighbor might have heard the commotion and that a neighbor might come by to investigate, and I didn't want that. So I drew the blinds and I moved her body away from the door, which had windows, because I didn't want someone to come to the door and see her. And I put my things back in the backpack, and I looked in a mirror before I left to make sure everything was in order, and I saw that she had scratched my face in the struggle.
Good for her.
And of course, I realized that this could leave DNA. So I used the paint thinner to try to clean her hands. And then I changed my mask, and I took off my outer shirt because there was blood on it. And I put it in the backpack. And at this point, I was really worried that someone, that Lutina might come back to the house, or Brad Post might come to the house, or a neighbor might come over. So I was trying to leave the house as quickly as possible. And before I left, when I realized that I had probably left my DNA there, despite my effort not to, I prayed again and just said that I believe that what I've done is the right thing, and I believe that I did it for the right reason. But if it's your will that I be connected to this, then I will turn myself in.
If
and I will own up to what I've done, and I'll
If
take responsibility for it.
Oh, then why are
because I
we in
believed
trial?
that it
You're
was the
not
right
taking
thing.
responsibility. You're in trial right now. You would have
And
pled
then I
guilty and
left.
saved the
I
tax dollar
exited
all
out
the
through the
money.
door, and I got back on my bike, and I pedaled my bike back to the truck, and I drove back to the mountain house, and I was still completely freaking out, and it felt entirely surreal. But there is a big difference in how I felt, in that as soon as I left the house, I felt the most enormous wave of relief wash over me, because I knew from that moment on, Aida would be safe. Aida would be safe from the sexual abuse that her mother was perpetrating on her. And there is proof to that the state is hiding from you.
Instruct him to be quiet.
Okay, you need to stop talking. The jury.
Can you find out what that person just screamed? Please. Oh, and they're going to have to remove that person from the courtroom. That judge is not happy. Yes, it was God that you were connected, not that you were a crap criminal, but left. Yeah. He has a savior complex, that's for damn sure. Wow. I'm a little bit on the floored side. Wow, y'all. I'm a little bit duh. Yeah, I'm sure they're on a short court break, and I'm sure they're gonna have that guy removed. But, what bothers me, that he is getting away with making these allegations that cannot be defended. And I think that that is a large part of that guy who's ever screaming out's a problem. It would be my problem. I would have a problem with that. Um I don't like the way that he's testifying. I mean, it's horrible. It's hard to hear. At the same time, it's hard to pull yourself away because you can't believe what you're hearing. And I hate it when people bring God into it and say, "Well, I prayed." Well, thank you so much, Don, for watching me. I greatly appreciate it, and I appreciate any and all assistance. Um, I know when the Simmons trial happens in San Antonio, I hope to go and be in court a few days out of that and come back and relay to you guys what's going on. I'll do they will not be having court TV in that courtroom because, well, it's a federal case in federal courts, so we will not be having access to any kind of court videos. So, I'm sure that I'll have a lot of people wanting me to kind of give information, but I'm going to probably starting next week start doing some member only clips and start sharing about that trial because it is so close to me. I can go. It will cost me quite a bit to do it, but I'll do my best to get the finances saved to go and get the hotel room and do all that kind of stuff. I won't do it on donation money. I've learned a lesson, and but if I can afford to go, I will be there as many days as possible. Might see if I have a friend that has a house that I could stay at while I'm doing that, and if so, then I can probably stay for most of the trial. Okay, apparently the prosecution shouted, instructing him to be quiet when he had said, "There's proof the state is hiding from you." Let's go back and watch that again, y'all.
Essentially, and at this point, and I had on black gloves and a black backpack.
Do you remember how many vehicles were parked in the driveway when you got there?
One.
When you arrived at the house and you got off your bike, what did you do?
My body wasn't really doing or unconscious. I realized that, and then I changed my mask and I Brad Post might come to the house or a neighbor might come over. So I was trying to leave the house as quickly as possible. And before I left, when I realized that I had probably left my DNA there, despite my effort not to, I prayed again and just said that I believe that what I've done is the right thing, and I believe that I did it for the right reason. But if it's your will that I be connected to this, then I will turn myself in and I will own up to what I've done, and I'll take responsibility for it because I believed that it was the right thing. And then I left. I exited out through the door and I got back on my bike and I pedaled my bike back to the truck and I drove back to the mountain house, and I was still completely freaking out and it felt entirely surreal. But there is a big difference in how I felt, in that as soon as I left the house, I felt the most enormous wave of relief wash over me, because I knew from that moment on, Aida would be safe. Aida would be safe from the sexual abuse that her mother was perpetrating on her. And there is proof to that the state is hiding from you.
Instruct him to be quiet.
Instruct him to be quiet. Wow. Oh, somebody's gonna get in trouble. Somebody's gonna get in trouble. Have you seen that little duck that goes, "I'm gonna whoop somebody's ass"? You seen that little duck? "If you don't leave me alone, I'm gonna send you home." Oh my gosh. I think he's relishing the position he is in a little too much. And he's gonna get himself in even more trouble if he doesn't be careful. But if there is said evidence out there and they withheld it, then they need to be looked at. That is something that is supposed to be coming into court unless the judge ordered it not to come in. I don't know. I have not been a part of all the proceedings. But I got to tell you, I don't think I have ever seen anything like this in my life. I'm sure other people have. I just haven't been doing it as long as everybody else has. That's all I'm saying. That is insane. Absolutely insane. Um, Sorry, I'm trying to get some information. OMG, y'all. OMG. What's y'all's opinion? I mean, my gosh. This is insane. You talk about bombshells. Okay, just as I thought. The judge ordered it not to come in because you're right. It has nothing to do with this crime. It doesn't have it doesn't have to come in. It is not a legal reason to commit the crime that he hadn't made that defense before trial started. I agree. I would assume that he had been ordered not to talk about it. Now, the judge can definitely start slapping him with some sanctions. But I think that the prosecution yelling and all this drama that's going on, it may throw it into a mistrial, y'all. I'm not a lawyer, but I wonder if it will throw it into a mistrial. I wonder if it'll throw it into a mistrial. What do you think? I don't think that his guilt is ever going to be in question at this point. A mistrial would just be a matter of formalities, but he's admitted to it. So why the trial? Well, did he want to do the trial so he gets his 15 minutes of fame? A lot of people do that, y'all. But let me tell you something. If this guy thinks that he's a martyr, he's far from it. Far from a martyr. And I am quite disgusted by him, actually. But yet at the same time, I can't leave. They were objecting, but Zachary just carried on talking, which is why I agree. One thing I need to share with y'all that if you're new to my channel and you're kind of wondering why I'm kind of asking these questions, I'm deaf as a board. I can talk to you. I grew up hearing. I've spoken all my life, but I have now almost 54. In March, I'll be 54, and I am now deaf without hearing aids. I have special ears. But 90% of what is going on in that courtroom is being read by me on the screen. I have a live captioning mode. I also utilize an interpreter, and I also utilize captioning from the actual device itself in the courtroom. And so some of these subtle things sometimes get missed in the captioning, and sometimes the captioning, because of the chaos, cannot interpret for me or caption for me what is going on. My mods know this, and they're very wonderful, and I can't thank you enough for being my mods and being patient with me and feeding me some of the information. Does that make me someone told me that if I can't hear, I shouldn't be doing this because that I can't properly represent for everybody what's going on, and I just told them to go jump in a lake, politely. But, this is a perfect example as to why sometimes I do struggle, because I do not have the ability, because the captioning, to isolate voices so it may pick up a word or two and then it says unaudible, meaning there's nothing distinctive being said. So thank you so much to all of you, my mods, and those who are not my mods who are always helping out. I appreciate it. Dawn, thank you so much for your your help today. You've been fabulous. Haley Mouse, you're always amazing. Always amazing. Oh, Hank Brennan was just caught in a lie again. Oh, we got to share this. I got to share this. But I can't do it the way I have to stop share screen and go over here to window here, share this. See if I can get it bigger. I cannot. Two Detective Lieutenant Matineel, whatever, from Sergeant J.S. Fanning, subject Matthew Farrell, personal and work cell phone analyst. On February 9th of 2021, Michael Farrell consented to a data extraction of his personal iPhone number 11, which was then extracted by Trooper Nick Guerrino. On April 26 of 21, I received Matthew's work cell phone from Stockton Police Department through Matthew's attorney. Consent was given for data extraction, which was performed by Trooper Nick Guerrero. I analyzed both of these phones and did not find any communication with Sandra Birchmore. Matt had said in a previous interview that he had deleted all communications with Sandra. That's what the defense may be trying to do. She stated something about that in a short. Wow. Y'all. More lies. More lies. More lies. More lies. More lies. That's interesting. February 9/21. This is for the Sandra Birchmore trial, okay? I analyzed both of these phones and did not find any communication with Sandra Birchmore. He didn't find the communication. Matt said in a previous interview that he deleted all communications with Sandra. So he confessed to deleting the communications with Sandra, and because of that, none was found. It was written over because the deletion only will last for a certain period of time until, even though you delete it, it stays on the device until something rewrites over it. And once that happens, it's lost forever. And that is what happened in this case. Oh, girl. Thank you, Angela. You are another doll. I got to show you my new beautiful. Oh, they were objecting, but Zachary just carried on talking, which is why they raised their voices. You guys, I think we need a little sweet moment, and I just want to say, I love my court junkies. Yes, I do. Isn't that a sweet Highlander? I love it. And I got to say this for earlier. I didn't do it and I forgot. Thank you for the super chat. Thank you, Mooch, for your support. Thank you, Mooch, for your support. Oh, Lord have mercy. This is getting deep. I'm awake today. Now, this is what we wait for in court, you know? But the sad thing is how much you want to come back and they come back and say that they're going to send the jury back and they'll be back tomorrow. But I don't understand why this guy is being the way he's doing. That is what the defense may be trying to do, she said. Yeah. I don't know why they would want a mistrial, but okay. Zachary has an agenda, and part of that agenda may be, I want to know now that the father is, how is the girl now? What is her age now? I should be writing this stuff down. I will be more note taking when I get done with this. I am on a deadline now. I'm months behind schedule. Didn't think I was going to get this involved in this case. But man, for the Karen Reed trial, I'm trying to find another interpreter who wants to interpret, and then bounce between Miss Diane and myself and them so I can get some notes done. I really want to compare the testimonies in the Karen Reed trial because I took very detailed notes on a lot of paper. I wish I had one of those note. It's like a tablet, but it's designed strictly for note taking. I so want one of those that you write it and it automatically will type it out. But those are like $1,200. So yep. 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 Oh, Lord have mercy, y'all. Lord have mercy. I told somebody online that I'm communicating with. No, it's not that kind of communicating. That I was in court and they didn't know it. I know their attorney. They're an attorney, but they don't know what I do. And I put, hey, yeah, I'd love to talk to you a little later about this adventure. And, but I'm in court. And then they went, huh? We'll see how that plays out. It's easier to say you're in court than sit there and detail your what you do. A lot of people don't get it. Okay, so that was an interesting find. Hank Brennan was caught lying again. I got to be honest. Both sides may, and I'm going to say this: when you're in a trial and you're up there speaking, there's so much information. I always want to leave room for misspeaking and errors and not doing so purposefully. But with this trial, I don't have that faith. I don't have that trust that that's the way this trial is going to be run with Karen Reed. I think that at every opportunity they can fudge the truth, they are going to fudge the truth. What are your thoughts on that? I am very impressed with Karen Reed's cleverness and her ability to work with her attorneys. I appreciate her analytical mind and her always on position. She's trying to fight for her life. She has resigned to the fact that she may end up going to jail. And prison, I mean. I noticed that she did not have an ankle monitor on, and that surprises me. A lot of times with someone like her that they would put an ankle monitor on. Oh, we got music. That means this is not a short break. I don't want that. I mean, I'd have copyrights to that, and I'm gonna get struck, because of their music. I don't have a copyright to it. I just realized it. So, I still have the question as to why is he going through this? What is his agenda? You know what? You're right about that. There is only so much grace you can give for errors. A lot of what Hank said yesterday was wrong. Either he's a complete idiot or he's trying to be sneaky slimeball. The waiting music, you want it? I can give you my waiting music, but I can't give you theirs. There you go. There was a witness or somebody who did not get up and testify in the Karen Reed trial that an investigator found, and I was shocked that they did not get up and testify. I wanted them to get up and testify. I was disappointed they did not get up and testify. But part of the problem is that 99% of the testimony was hearsay, and it was told to him by Brian. Which one is it? Albert's? The one that the home was where the, what's his name, was unalived at? Had told him while they were drinking buddies at an event. And because of that, he cannot testify, which sucks because the information he has really puts a pretty bow on this, although I did write it all down. I took very detailed notes on that information. It's just sad. Overall, it's just very, very sad. Oh, I will finish this one today, yay, and then I'll start the other tomorrow. Dang it, I have 4 more to do. 5 more to do. No, 4. 4 more of these to do. If I can do one a day, I have been live here for 6 hours and 27 minutes, and it takes 9 hours to do one of these. In the black, not the color. It takes 25 to 30 hours to do the smaller ones. 40 hours, 35 to 40 hours to do the bigger one. So I got 2 different sizes I'm doing here. Y'all, thank you so much for waiting with me and us waiting to find out what's going to happen in court. Although I'm wondering how this jury is going to be able to continue to move forward with this case without being affected by the outburst of what's happened on the defendant's testimony. And are they going to rest their case in chief after his testimony? That's another question I have. We may be in verdict watch tomorrow, which would be nice, and then we can go to the cemetery. I can send us back and forth over there, but I've had some people kind of complain it's harder to follow. So depending on what happens tonight and how I'm feeling, as soon as this case is done, I'm going to start streaming the cemetery trial. I know a lot of us have been watching that trial, and we all want to kind of keep following it. I appreciate you watching it with me. I understand if you've been watching it with another person. That's cool. I get it. That's what's hard is I wish I could do multiple lives and have the sound separated. So that's why I'm going to hire a sound technician to come and hopefully help me get the sound with the switcher kind of worked out. Because I want to be able to have multiple lives and not have the sound for both lives going into my head at the same time. I have to tell you that is very disconcerting. And you can't think, can't hear anything but them. And when you're deaf, you can't separate who's talking. Got it. There we go. I think I'm going to take this moment to take a comfort break. My puppers is looking at me with her eyes turning yellow. So let me do a puppers comfort break. I'll be right back. Hello, I am back. I'm back. Oh my gosh, that was so cute. My dog is stinking cute. She's a cutie patootie. Yeah, I'll put that back there. She is so funny. I took her to the bathroom, and we have a back door to our little part of our shop. And then there's a little flat part, and then it goes up like a hill, and that's somebody else's property, but it's all wooded. And the building that our shop is in is shaped like a long L. Well, we're on the long side of the top of the L. We're at that part of the building. And then there's a sidewalk and that runs along the back side of the whole building. And it has a little lip to help hold the dirt and stuff in. And she did the zoomies out there. It was so funny. I couldn't stop her. I just sat and laughed. She's not a high energy dog. She doesn't do zoomies and stuff like that very much. But boy, how does she did them today. It's cold out there. It's crisp, I'll tell you that. It's nice and crisp right now. Right now it is. Well, I didn't mean to do that. Let me get to the weather. 32 degrees. Feels like 13. I didn't have the wind in the back of my, on me because of where the building was. But, oh my gosh. She was so cute. Like I said, she is not considered a high energy dog, which I'm grateful for. I don't mind a dog with energy, but when they're working dogs, sometimes that can be a little difficult. She's more of a go with the flow kind of dog, real laid back, just happy to be with you kind of dog. I am going to get a puppy cam put up, a critter cam put up. I'm going to decorate underneath there, decorate kind of like the wall, make it look a little nice for y'all to look at. Probably try and get that done this weekend. I got to figure out how to get I don't know why. I have a GoPro 10 and it doesn't stay connected. The camera that you're seeing me on right here is the GoPro Hero 7 or 8, something like that. I just can't afford to get a new one. I can't. How do I put it? I don't want to afford to get a new one. It's that simple. I don't want to have to afford to get a new one. I'm going to figure out why that other one's not staying connected, and it rarely ever connects, but I would really like to use that and have that so you guys can see the cute pupper moments. Right now you're looking at me from a very poor angle. Makes me look like I'm the size of a barn. Not a very nice angle. Of course, I'm wearing a sweatshirt. By the way, yes, someone nailed me on it. I do have a Law Nerd sweatshirt on. I support Emily DB. I bought a Law Nerd sweatshirt and the Law Nerd mug. I supported her even before I was doing this. I had all this. And I'm like, who cares? I'm going to wear it. I paid for it. It's mine. It's mine. I paid for it. You can see my ponytail, my loosely braided ponytail. So, I'm really happy for this switcher, but I need the sound man to come and help me get things a little better. I got a lot to iron out and work out. So, I want to be able to give there's that young guy, Alan. He's such a sweetheart. But I want to open this studio up for people on the weekends if they want to come and do a pre-recorded podcast, and then they can download it on the hard drive and take it home with them and edit it and do all that at home. So that way, It is really hard because not a lot of people have what I have, and I understand that, and I want to make this available to people who I can trust. Of course, I'm sitting right here with them when they're using the equipment, because this equipment is not cheap to replace, and they will be signing a "you break it, you buy it" type of clause. But I want to make this available for people who want to do some podcasting, um, who want to do pre-recorded work, and I think that's a great idea. I told him as long as if we have a trial that's running on a Monday, well, I'll be on Monday. But if we do not have a trial running on Monday, then I shall not be on Mondays. I need to take 1 weekday off. Now, Friday, I've got a problem. I have got an appointment on Friday, and we've got court on Friday. So I have got to figure out what I'm going to do Friday. Thinking I might change that appointment because of weather and other issues. We'll just wait and see. Wait and see. Wait and see, said the putty cat. Just wait and see, said the putty cat. Well, that didn't go down very well. Sometimes we have a get up in our go when they're beating. I don't know what just happened there. Oh, I gotta find the loop. Did it? Oh no, it broke? How did it break? Oh, shoot. I don't know how that broke, but it broke. How in the world do we have a broken thread when I haven't even pulled it? Mm. Oh, y'all. Things happen. The Cemetilli trial is getting a little interesting. I went back and rewatched some of that trial, especially some of the stuff on the phone. I hate to tell you, but I cannot believe how sneaky they were trying to be. What y'all don't realize is that a lot of times after I get done, I go back and rewatch it because I can miss things. We all miss things, you know what I mean? We all can miss things. And I am appalled at the audacity and the secretiveness that they tried to do and get away with it. I'm perplexed, greatly perplexed as to how they did that. And the fact that the family didn't notice the odd behavior. And the fact that this woman would have a memorial just days after he was unalived and allowing people to sit in his chair and get their pictures taken. I'm like, that's a little gross, don't you think? That's a little bit much. What are y'all's opinion on that? I can't believe she did that. I was like, not going to happen. And then she's dumping that really nice guy for an porn star. Porn star. I have to be careful how I say that. I don't know if I'm going to get in trouble or not. Thank you guys for all of you for sticking with me. I know we're all just anxiously waiting what's going to happen in trial. I just have a gut feeling the judge is going to call it a day And if I was on this trial, I'd be like, Judge, come on, let's move this along. This is enough. Okay, we had a disruption. Let's get along, little doggies. But they are taking a very long break. This is not a live court is on a short break thing. Court TV, we need to change that. That is not court is on a short break. That means court is on an extended break. And you don't know when they're going to come back. I have to, maybe I should try and get a hold of Dawn and say, Dawn, what's going on? Do you know anything? Let me see. Hi, baby girl. Do you feel better? Did you go get your zoomies? Did you go get your zoomies? Alibis and alibis. Okay. Puppers. I need to take that down because Puppers and I are not on a short break anymore. Let's go and see if I can find something else for us to watch in the meantime. How about that? What do y'all think about that? Let's see if she's in today. You know, I called it, didn't I, on the roses that they were given to her and that she used them to defend herself? Yep. Yep. Oh, I haven't seen Bill Blazy in a while. I haven't seen her in a hot minute. Let me do this. Okay, let's go over here. I am trying to find something for us to watch, trying to find out what's going on. One of the things that people are talking about is getting a search warrant for some of the evidence against the father. Uh, One of the things that I'm kind of looking at on this case is sorry for the is I don't know if I believe everything he's saying. And the fiance is arrested with 6 or 8 counts of CP. Is that the situation he's referring to with the little girl? That's what I wanna know. I don't understand. If he had a bunch of CP, then is he the one that was doing inappropriate behaviors with this young girl and the mother knew about it and didn't stop it? See, I'm not too sure. I mean, it's so unusual for a mother to SA a child. However, it does happen. So that is where I am. That's where I'm kind of perplexed with that statement. I'm glad I was right. I called it about the roses that she used it to ward him off. And so, but he did use them to get in the door. I don't know. I don't know. I'm trying to find stuff. So, why don't we do y'all want me to start reading the other thing? Let me look at Discord live comments. Okay, I'm looking. I got to bring it over here to read it so I'm not turned sideways. Okay. Brandy Churchwell on X, who we love, Dr. Wolf said there's a direct correlation between the time of day and the pedestrian fatalities. That is true. It is true. Pedestrian fatalities usually happen at night and also in very cold weather. Sometimes, they're walking on the side of the road. Brennan reads this in court and says that would have been nice to have. Here, Dr. Wolf saying exactly that during his direct testimony in the first trial. Then, when Dr. Wolf says this, it's an example of what Hank misrepresented yesterday. This was his thing, suggesting secret questions that the Commonwealth didn't know about. It was actually from the Vordyers, so the Commonwealth were there for it. He wasn't there for it. He doesn't know about it. He jumping in here last minute. Thank you, Haley Mouse. I get it. Guys, it's already what time there? It is 4:25 there. How much you want to bet these jurors go home? Yep. So, see, this is one thing that bothers me about having a special person come in and try the second time around is that there's a lot of things that get crisscrossed. And so I try not to put a whole lot of drama into some of this miscommunication because it can really happen. But at the same time, I do want to respect the fact that there are some mistruths happening. And it's very disheartening. Very disheartening. Let me come back up. So, how many of you really think that we will be in trial with Karen Reed on April Fools? I'm not too sure about it, in all honesty. I really am not too sure about it. I'm not too sure that we will be. I think it'd be funny if she came and said, April Fools, guys, we can't go to trial. We're pushing it till May. I'm still struggling, and please don't get mad at me. It's just my hearing on what truly happened yesterday and why Auntie Bev was so angry. I kind of get the gist of it, but a part of me is like, there are going to be things in trial that are not shared, and then you go and you do a retrial, and then they go, okay, we're rethinking our strategy and we're rethinking our directive. And if that's the case, so be it. You're doing your job. You are doing your job. Everybody's so up in arms over some of this new stuff. My question is why is it new? Not that I'm angry about it, but like the defense has said that there's going to be new evidence coming into this that they have new evidence. And I'm like, really? Yeah. Excuse me. There were a lot of attorneys and other commentators that were on that were trying to kind of explain what happened. And I was so tired last night, I did not watch it on anybody else's channels. A lot to some of the SpaceX debris fell in Poland. Oh, congratulations, Poland. You get a free gift from the United States. Hopefully nobody got hurt. Oh, sunny day. Um, I'm still shaken over the fact that Talk Orchid's husband was on that air flight in Toronto that rolled over and caught on fire. He is fine. He has a little bit of a whiplash. Probably got a lot of post-traumatic stress disorder from it. If he didn't already have it, if he already had it, boy, he's gonna be worse. I knew one of the mods over on, our Ace channel had it, but she's a mod on my channel too. So, she's been going through it. They have a baby. She's had foot surgery. Her husband was almost unalived on an airplane yesterday. My heart goes out to her and to him. This is very difficult, so keep them in your thoughts and or prayers. Thank God I didn't break that string doing that. This is difficult times for everybody. And, we are what the heck did I feel it was loose? Oh. It's just a bad thing when you feel your beadwork, you run your hands over the beadwork and you start feeling something loose, boy, you panic. The good thing is they're coming back into court. Oh, there's some sound, but no video. Yeah, they're coming back into court. There's no video, but I hear 'em. Can y'all hear 'em? Someone's coming back into court. Yes, Toxic Orchid's husband was on that flight.
Be admitted and presented to you, the jury, all rests solely with the judge on the law. And I want to instruct you that you're not to consider any testimony that I have instructed to you to disregard, and furthermore, you should not even mention or discuss any testimony that I have instructed you to disregard. And I instruct you not to discuss any topics that have been ruled improper when you deliberate. Thank you.
Zach, just got a few more questions. After you left Cambridge, isn't it true that you rode your bike back to your truck, which was parked?
I'm gonna switch feeds. Forgive me. Always have a backup feed. But I don't want this backup feed. Let me mute it. Let me get this up and going.
About what evidence can and cannot be admitted and presented to you, the jury, and that gatekeeping role rests solely with me, the judge on the law. And I want to instruct you that you're not to consider any testimony that I have instructed to you to disregard, and furthermore, you should not even mention or discuss any testimony that I have instructed you to disregard. And I instruct you not to discuss any topics that have been ruled improper when you deliberate. Thank you.
Zach, just got a few more questions. So after you left Canebrake, isn't it true that you rode your bike back to your truck, which was parked within the vicinity? Isn't that true?
Yes,
And then you drove your truck back to the Mountain House. Isn't that true?
that's true.
After you got to the Mountain House, isn't it true that you disposed of the gun and the knife in a nearby lake? Isn't that true?
Yes, that is true.
And isn't it true that the clothes you were wearing, that you burned those clothes in a fire pit at the Mountain House? Isn't that true?
Yes.
I want to talk about towards the end of October, beginning of November. Isn't it true that at the very beginning of November 2021, you had obtained a plane ticket to fly overseas? Isn't that true?
Yes, that's true.
And you were going to go overseas departing from Detroit. Is that correct?
Yes, it is.
And while you were in Detroit, isn't it true that you received a phone call making you aware that there were warrants pending for your arrest?
That is true.
And after you were notified of the pending warrants, isn't it true that you rented a car, drove back in the middle of the night to Greenville, and ultimately turned yourself in? Isn't that true?
Yes, that is true.
And that's supposed to make this any better?
1 second.
Is that supposed to tell me that you're a good character and you're a good person? You just know that if there's a warrant for your arrest, you're not flying out. You avoid public embarrassment.
Can I see counsel?
Bye.
Sidebar. The thing is I could care less that he came back on his own initiative and turned himself in. I don't care one iota that he did that. Because truthfully, if he tried to board that plane, they probably would have arrested him, just like they did with what's her name? What is her name? What's her name? I can't think of her name. The older woman flying to, what was it, Taiwan, Japan, Philippines, somewhere over there. Vietnam, that's it. She was flying to Vietnam to get away because of her and her other child, unalived son-in-law. Why can I not think of her name? Yeah, he wanted everything on his terms. Yep. I wonder how he's going to get along in jail, prison. Not very well, I doubt it. I would imagine that he is going to have a hard life. Uh-oh, now what? We're ending for the day.
Okay, ladies and gentlemen, we are going to break for the day. And I'm going to ask that y'all return at 10:30 tomorrow morning.
Oh, nice.
I'm hoping that we're not going to have bad weather, but just potentially that will give a little extra time, and also for me to take up a few things that I need to do with the attorneys. I want to, again, thank you on behalf of the state of South Carolina and Greenville County for your service. I am so grateful for your attentiveness and abiding by all my admonitions to you. And again, I just remind you, do not watch anything on this. Do not discuss this. Do not begin deliberating until I tell you. Okay? I hope you all have a wonderful evening. Thank you.
Thank you.
Donna Adelson. Yeah, he would have had a Donald Adelson moment had he tried to get on that airplane. If he would have gotten on that airplane, that's what would have happened, because if they have a warrant for his arrest, it's going to be in the system. And if he tries to check into that airport, they're going to take him and politely escort him out with cuffs, and then they'll have to extradite him. And then that even looks even worse for him than what it looks like now. I truly believe he thinks he was being a savior to that little girl in his crazy narcissistic kind of way. But I don't know if that little girl was really in that kind of danger. What do y'all think? I mean, I haven't heard anything. Hi, Cameron. Oh my God. Have you been Cameron. Carmen, excuse me. I have a friend named Cameron. Carmen, have you been watching this shenanigans? Did you see that he confessed and we had some courtroom drama? He accused the mama of SAing her own daughter and said that the state knew about it, but they were keeping that from the jury. And oh my gosh, it was a drama-filled day in this courtroom. Now that that's over, I told you we were going to do this. We're going to go over to the Cemetilly trial. Some people are looking forward to it. Some people may not. Let me get over there. Hey, you doing, love? How are you doing? What's the good thing about this trial is that I can we can zoom, which is great. How are you doing, beloved? I hope you are having a fabulous day. Oh, sunny day. Oh, sunny day. Let me edit this for a second and bring this where I need it. Update layout. That's not what I needed. Let me come up a little more. Save. There we go. And let's
start with the Instagram reference monitoring. You looked at those Instagram.
You need to watch this afternoon.
Yes.
Oh, you need to watch.
Here, slide 100 of your presentation.
You need to watch when the defendant takes the stand. God, I nearly lost it.
You noted that the Instagram business records are voluminous, correct? Yes.
Well.
Thousands of pages of text and images, right? Correct. Showing all the things that she posted on Instagram, correct? Yes. Showing you
Don't
slide
forget, we're still
101 of your PowerPoint presentation.
still data.
This is an example of some of the things she's posted on her public Instagram account, correct? That's right. And we see here, I know.
By the way, Carmen, just to let you know that Haley Mouse's husband was the one that was a passenger on that air flight that took the cartwheel in Toronto yesterday. He is fine. He does have some whiplash and probably some PTSD, but I just want to let you know, so you be praying for them.
It's very small, so I'm just going to try and zoom in, but they have images and there are dates with those images, correct? Yes. Showing when she posted these things, right? Yes. So we have here some posts, May 21st, 2015, you see that? Yes. Top left hand corner, sir. Yes, sir. Another one in May 21st, 2015. Then a few the next day, you see that? Yes. A few in the next day on May 22nd, May 26th, May 27th. And every few days, it seems like she's posting something, correct? That's right. And sometimes multiple posts a day, correct? Yes. And there are all kinds of things we see here from this example.
No, I'm sorry, that's Toxic Orchid. My bad, that's all Haley.
Food,
Toxic Orchid.
Mugs, flip-flops.
My bad. It's Toxic Orchid. If I said Haley, I'm sorry, because I was looking at Haley when I said it. It's Toxic Orchid's husband. Toxic Orchid had foot surgery about a week or two ago. She is still trying to recover from that. It's not been a jolly ride. It's been probably a little worse than she thought it was going to be. But the good news is she's on the mending side of everything. But that said, then to have a baby and then have this, so it was toxic orchid. I'm sorry.
Correct?
Yes.
So she's frequent. So you looked at this as records. She's frequently posting content on Instagram from as far back as May 2015, right?
Yes.
So she was using and posting on Instagram long before Fabio Simpson was killed, right?
That's right.
It's not like she suddenly started using Instagram only after he was killed and posting things, correct?
That's right.
Now, this is from your timeline. I'm not going to ask you about all the timeline. I'm just going to ask you about the web history searches from her LG tablets, okay?
Yes.
You looked at the LG tablets and all the web search history from it, correct?
Yes.
And you found that on June 7th, there were some particular searches, correct?
Yes.
Yeah, me
And
too.
one of them is this Quora search. We see here.
I won't
it's
play that
questions
video
search
anymore.
Quora.
She doesn't have.
How do you know if your cell phone is being tapped by police? You see
I
that?
Yes, I do.
I just want to clarify my understanding, for correct me if I'm wrong, but this website, you can look at questions that people have posed, other people, and see what the answers are. Is that right?
Yes, it's like a forum website.
So here, it's not that Monica Simontilli has typed that in, but she is looking at that question that someone else has posed. Is that fair to say?
Yes, to put it another way, she surfed to that particular website.
Right. But that writing at the top, how do you know if your cell phone is being tapped by the police? That's not, she hasn't written in that question, correct?
Correct.
Now, you also noted some other web searches. Sorry, a second. This is from the internal record of the LG tablet, correct?
Yes.
And all the web searches that you saw in relation to these subjects, they were all on June 7th, 2017, right?
I'd have to see the full list, but certainly the ones in the screenshot here, June 7th, 2017.
I believe on all these others, that you highlight, or at the top it has June 7th, correct?
Yes.
It's all the ones that have been presented, they're all from June 7th, right?
Correct.
You're able to see the full web history of the LG tablets, aren't you?
Yes.
And you reviewed that full web history, correct?
I didn't look at everything in the voluminous records,
but you looked
line by line.
Sorry, shouldn't interrupt you, please.
I'm going to speed this up just a bit.
Yeah, I went to a specific time period at June 7th.
But you did look through the records to see what was relevant to the case, right?
Yes, what was pertinent.
Right, and this is the only thing you found that was personal.
These searches, yes.
Right. And so we know that we know Fabio Simontilli was killed January 23rd, 2017. And this is obviously in June 7th, 2017. So you didn't find anything personal from the LG web history in that 5.5 month period. Only this in June 7th, correct?
That's right.
And I know you were being very precise earlier in your testimony. What this is showing is web searches that have been made on this LG tablet, correct?
And or navigation to specific websites.
But you don't know for sure from this data information exactly who was using the LG tablet at this time. It's just the LG tablet.
See, it belonged to her, but somebody else.
Yes, that's why I'm always very specific talking about devices and accounts and so forth.
It would depend on who's using the device at that time, correct?
Correct.
And these are obviously web searches relating to spying and police spying on cell phones and tapping phones. Is that right?
But more or less.
It's true though, isn't it, that the texts in this case were secretly recording Monica Simontilli's phone calls, weren't they?
Secretly recording her phone calls.
That's exactly what it is.
False
speculation.
Overruled. The last thing I want to talk about is just lifestyle lounge. Sure. Let's skip ahead to this.
I thought that was going to be a fight.
This is slide 136. This is Monica Simontilli's iPhone web history, is that right?
Yes,
And it shows, as you said earlier in your testimony, that there are many, many entries in relation to lifestyle lounge, correct?
that's correct.
And that goes from July 2nd, 2016, all the way through to June 13th, 2017.
Yes,
And you spoke briefly about lifestyle lounge, but it's essentially a website where people can meet swingers. Is that fair to say?
yes.
Reach
It's,
out to, I should say.
Wait,
yes, a swinging website, sometimes informally referred to as a hookup website. Yes,
Meet new people, potentially hook up with them.
correct.
And showing you people's exhibits 162, page 2. Using this website, you can browse various people's profiles, correct?
Similar to dating applications. Users establish a profile, essentially advertise themselves to other like-minded users. They find some sort of common attraction and then connect.
And this is an example of some of these user profiles you would see, and then you could reach out to, correct?
Yes, I don't know if these are real people. This is an example from the website itself.
And you also talked about how the website has a chat function, correct?
Yes.
Lets you chat with these people, correct?
Right.
Now, we've obviously seen evidence you presented that Monica Simontilli and Robert Baker were communicating over Viber. We saw that, didn't we?
Yes, we did.
There is no evidence that Robert Baker and Monica Simontilli were communicating via lifestyle lounge, is there?
Not with the data that I have.
Just one moment.
Redirect.
Mousy. I need to put a little mouse in with my little Highlander. What do you think? You think that'd be cute? Let's see if I could find a. Look at that. Maybe put a mouse sitting on her horn. Or maybe one there. Or maybe one there. Or maybe one there. What do you think? Would that be cute to put a mouse on it? I didn't think about that. I could have. Why didn't I? I think that might be kind of cute. Uh-oh, wonder why we're quiet again. Are we at a sidebar again? Sidebar. I'm so close to being done, y'all. But I have a paper cut on my pencil.
The question that defense counsel asked you about not being sure who the user was on the defendant's LG tablet at the time the June 7th searches were done to a website relating to cell phone spying by law enforcement is the point, I assume, of, as you mentioned yesterday, of this slide number 90 in your PowerPoint, correct?
That's exactly right.
Okay. So this slide here and the video that follows in slide 91 shows us, as you were testifying to yesterday, that the defendant is in control, the one who has possession of and is manipulating her iPhone during the time that she's at Target.
Yes, that's what I call attribution. Attribution of devices and accounts to a specific user. As an investigator, I look for things like selfies. Is somebody holding the phone? Do they have control of it? In this case, we have video that shows Mrs. Simontilli is manipulating the device in hand.
So that was the purpose, as you mentioned yesterday, and you've now explained today a little more fully, of this particular slide in the video thereafter, to show that she has possession of the device during the time that we know, approximately 30 minutes prior, that she's connecting to her home surveillance system through the home's IP address.
Yes.
Because we know, again, 30 minutes later, she still is at Target with that phone in hand, as we can see in the screenshot here in slide 90 and the video in 91.
Yes.
Correct.
All right. Also, with respect to the searches to the website, when defense counsel asked, well, it's a website, she isn't typing in these searches. She is initially searching for the subject of cell phones and cell phone spying by law enforcement in order to navigate herself to a website that has articles on it, as the ones you showed us in your PowerPoint, correct?
That's right. That's why I describe it as surfing activity,
Well,
surfing the web.
So it's not like these searches automatically came up on her device without some manipulation, handling of the device, just like handling your phone here and connecting to an application that allows you to watch your cameras.
A user has to navigate to the website.
You were asked several questions yesterday about Viber. When you were able to look at the defendant's cell phone extraction as well as Baker's cell phone extractions, were you able to find the Viber application on either of their phones?
No, I wasn't.
Does that mean that the application was deleted at some point prior to their arrest on June 14th,
and overwritten,
where you were present, where their cell phones in the vehicle were seized pursuant to warrant?
So it wasn't.
And as we talked about yesterday, when you delete an application,
It
may also.
It wasn't that it was just deleted. It had been deleted long enough to be written over again.
Then, if you're using the application to communicate, once you delete it, you may also be deleting all of the associated data, or at least the messages that were made through that application, that no longer exists on the phone.
That's right.
And you also mentioned you were asked questions about the WhatsApp application on the phones. That was an application that was found both on the defendant's cell phone that she has in her hand there, number 119, as well as Baker's Samsung I think it was the 4, correct?
S8.
S8, okay. So it's item 121, correct, at the time?
I don't know about the item number, but it's the S8.
S8. But again, the associated data, as you look at it through Celebrate, shows that that data is encrypted so that it prevents you from reading, let's say, the bulk of the messages.
Yes.
You also were asked yesterday about the communication
Where I pull the thread, it's paper cutted.
between the defendant and Robert Baker on January 23rd. And we looked at the timeline that was created that we saw in Exhibit 160. Which is, as I mentioned yesterday, 4 pages in length. And shows that there are messages, according to California time, local time, converted from UTC, beginning at 6:50 in the morning, based on the Viber CDRs, not the cell phone extraction, because the Viber app had been deleted and therefore it deletes the communications, but from the Viber business records themselves that we discussed yesterday, that the defendant sends a text message to Robert Baker at 6:50 in the morning on the date that her husband is murdered, correct?
That's right.
And then communications between them continue throughout the entire day. Looking at page 2, which starts at the top at 11:41 and 50 seconds a.m. Second page ends at 2:45 and 56 seconds. Baker texting to Monica. Page 3 at the top at 2:46 and 40 seconds. The defendant texts to Baker. And then the last text from the defendant to Baker at 3:36, according to the Bible records, correct?
Yes.
And then, at some point shortly thereafter, as you testified to yesterday, at 3:53 and 57 seconds, she activates the application that connects her to her home surveillance cameras.
Yes.
And then that was based on the cell phone extraction, corroborated by her cell phone records, called detail records, correct?
Yes.
Which you said the cell phone extraction keeps records according to a certain time frame. Then the cell phone records, the provider, in this case AT&T, keeps records as well, correct?
Yes.
And at 4 o'clock, her cell phone records, we see that she is connecting to her home IP address, as you explained yesterday. That would be necessary in order to view your live feed from your cameras, correct?
Yes.
And that connection actually continues. We look at the last page. Of People's 160 until 5:15 in the afternoon. That's the last connection to her home IP address. Yes?
Per the AT&T records, yes.
Yes. So you don't know at what point she actually closed the IDMSS Lite application on her phone, correct?
That's right.
All you can say, based on the various sets of records, is we know that she accessed it at a particular time, as we talked about, just before 4 o'clock in the afternoon, and that the last connection to that IP address was at 5:15 in the afternoon.
Yes. So if I may elaborate briefly.
Please.
It's a step-by-step process that starts with the instructions that were in that first digital email, instructing the user, the customer, on how to log in to the CCTV system that was set up at the Semintelli residence. That IP address continued to exist all the way to the end of January 2017. There was prior usage of the IDMSS Lite app a handful of times.
The last one being, I believe, in November of 2016, 2 months prior.
2 months prior, yes. But now we look at January 23rd, 2017.
The day of the murder.
The day of the murder. Per the instructions from the email, we have an artifact on Mrs. Semintelli's iPhone 7 that shows an IDMSS Lite app was opened 3:53 in the afternoon. This is followed in short succession by the AT&T data, the internet history, that corroborates the opening of that app and shows connection with high bandwidth, particularly towards the 4 o'clock hour. All the way, connections all the way through, logged in the AT&T records until 5:15 p.m.
You can't
And
argue
on
that.
top of that, we know that the phone is in her hand at 4:30 as she's leaving the target.
Correct.
Right.
So there's no question here as to who is manipulating or navigating or controlling the cell phone during the 4 o'clock hour.
That's right.
Also, yesterday, defense counsel put in front of you, I believe it was marked as defense exhibit. Let's see. 614 AT&T records for the balance of the day of January 23rd. Do you recall that?
Yes.
Those are the same records that I showed you on direct that were marked as people's 156. And let me show you the front page. Here, the AT&T internet history, correct?
Yes.
And the pages that Defense Counsel, it says it right up here at the top, internet history and has the serial number and the IMSI number for the defendant's phone. If we go to the pages that talk about or that refer to Tuesday, January 24, again, once you convert those to UTC time, that includes January 23rd.
Yes.
So what was shown to you by the defense, you yourself had already reviewed and are contained within the records I showed you on direct that were marked as People's 156.
Yes.
The hard copy, Your Honor, for the record, I believe, of those records, well, I think we just included them on the CD, which is 156. Showing you 159, which was the timeline I showed you yesterday for January 22nd. And includes multiple pages, I think it's 4 pages. Again, that also shows the level of communications. I remember yesterday we were looking at your chart and you were asked about the peaks and the troughs. The level of communications on the day prior is also, prior to the murder, is contained in People's Exhibit 157 that we looked at yesterday, correct?
Yes.
And that date, there were approximately 180 messages between the two individuals, the defendant and Mr. Baker, correct?
That's right.
And in the timeline for January 23rd, that is marked as People's 160, there were approximately 115 communications, correct?
Yes.
And as was pointed out yesterday, there was a gap of messages in the Viber records for approximately an hour and 10 minutes between 3:36 until 4:45, correct?
Yes.
And 4:45 would be, I assume that you are familiar, would be during the period of time when Robert Baker and Mr. Austin would be at the Cementilli home.
That is correct.
There's too many coincidences.
Also, with respect to Defendant Baker, you included Robert Baker, you included information relating to Baker and the defendant in your various timelines with respect to surveillance units. Did you ever recover on June 14th a flip phone belonging to Baker?
No, I don't recall that.
Nor the S6, as you talked about, which was, you showed us was registered to Baker at a period of time in your PowerPoint.
That's right.
So therefore, you would have no way of knowing what applications existed on either of those phones belonging to Baker at any given time.
Unfortunately, no.
You were also asked.
Can y'all be more mindful of the microphone? I know you're in the middle of trial. You could care less.
About the Instagram business records.
Night, Bob. Carmen, do you got to work tonight? Do I apologize? I'm sorry. I called you by the right name.
And in your timelines, you included, in order to be able to show the dichotomy, the public posts versus the photographs that you recovered from the defendant's iCloud, for Apple iCloud records. Do you remember that?
Yes, I do.
In any of these
Oh,
public Instagram posts,
come on.
did you find
No.
by the defendant regarding
Never
her
nude
trip in May
pictures
to
of her
Las
in that.
Vegas with Robert Baker?
No.
Anywhere in the public Instagram account, did you see any posts to the public regarding her trip to Myrtle Beach at the end of May with Robert Baker?
No.
I have nothing further.
Any requests?
I'm sorry, babe.
You talked about Officer Davis.
I didn't know
messages
what would help you
on
with
the morning of
that.
January 23rd, all throughout the day, correct? Yes, on Viber. And there's also messages on January 22nd. As you've already shown in. This graph shows that there are messages every day in January between March. Yes. And there are actually more messages on nearly every other day other than January 22nd and 23rd.
Cumulative.
I'll allow this. Yes. On the IDMSS issue, the act for viewing by home surveillance cameras. There's a connection that you said continues from approximately 4 p.m. continues until 5 p.m. Correct? That's what we would put to you.
Ongoing log entries of that IP address, yes.
Right. There can be a connection, but not necessarily video being streamed, correct?
I don't know.
Well, to stream video, you have to download data, don't you?
I can only speak to what the data is in front of me.
But to stream video, the device has to download data from the home IP address.
There would have to be incoming data to stream it, yes.
So there has to be incoming data downloaded to stream video.
Yes.
Yes. Okay. So the app can be connected, but it can be running in the background, right?
Absolutely.
It doesn't have to be that. Well, the app can be connected, but it's running in the background. So let's actually look at some of these entries where there are connections.
Oh,
to the home IP address,
awesome.
going up to 5.
That would be
Right, and this is
fabulous.
the same exhibit we referred to.
Put an earbud in and listen to court. Put me on in the background.
This is a full log, the AT&T records showing data downloads, connections with Monica's phone.
Counsel, I believe for the record that's 614.
Thanks so much. The 614 point. Now, you said there's a connection with high bandwidth, particularly towards 4 p.m. Right?
Yes.
But there's actually a connection with high bandwidth only at 4 p.m.
Your Honor, I'm going to object cumulative.
Well, I need to address the point that there's a connection beyond and up to 5:15. So I'm going to show you those connections.
Same objection.
I'll allow this to go to 5:15. Again. We've already looked at the connections at 4 p.m., 4:05, and 4:25. I'm not going to go over those again.
Do I want to know what safety
But it is true that there are
provision was needed
connections
last night?
a bit later. Like, and this is showing the
Or do you want me to use my imagination?
Zero. This is the last one we talked about. There's no data downloaded. Video cannot be streamed.
Same objection, Your Honor.
Let's look at the next one. There's a connection here at 4:30, connection to the home IP address. 0 bytes downloaded. If there is 0 bytes downloaded, this is at 4:30, this is beyond the times we looked at.
Same objection.
If there are 0 bystanders, video cannot be the extreme, can it?
I would say with 0, there's no video coming in. No.
Right. There's also, next to 455, again, 0 bystanders at 455, video cannot be the extreme of the home security cameras, correct?
And that would also be after the DVR box was removed as well.
Right, so we know the DVR box was removed when the killers, Robert Baker and Chris Austin, left the house, correct?
Yes.
And that was at 4:53 p.m., correct?
Yes.
Because we see the Porsche driving away at 4:53 p.m., correct?
Right.
You need the DVR to view the home surveillance cameras, don't you?
Yes, without it, you would have no endpoint, essentially, to stream data from.
The DVR, sorry, continue.
I was going to say the phone could still attempt to make a connection, and that may be why we see additional log entries here beyond that point in time. But there's nothing to receive information from.
So the DVR has been written out, impossible to be viewing that home security cameras.
Right.
So these entries, 4:55, and the entry at 5:15, no possible way that home surveillance cameras are being used then, are they? So even though the connection continues until 5:15, absolutely not evidence that any home security camera footage is being reviewed.
Right.
No further questions.
Anything for other people?
No, thank you.
Thank you, Officer Davis. You're excused.
Thank you, Your Honor.
Please may call the next witness.
Call Deputy Miguel Valderrama.
I didn't catch that, but of course I am at a higher speed than normal.
Take a please face me and raise your right hand. Do you solemnly state the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please have a seat and witness stand. And for the record, say and spell your first and last name, please.
Miguel Valderrama, Miguel, B as in boy, ALDERRAMA.
Thank you. Sir, can you tell us how it is that you're employed, please?
I'm a detective with LA County Sheriff's. Currently, I major crimes metro detail.
And how many years have you been so employed?
A little over 26 years.
Where were you assigned back in October of 2018?
I was working overtime in this courtroom as bailiff of record.
What were your duties as the bailiff of record in October of 2018?
I was handling all court proceedings for Department 101 and then security of the inmates for that calendar day.
Want to direct your attention to the dates of October 2nd and October 3rd of 2018. Let's start with the October 2nd date. You were assigned to this courtroom.
Yes.
And
What happened?
do you recognize defendant Monica Cementilli seated over here?
Yes, I do.
And can you identify her for the record?
She's sitting at the table with a beige suit.
Also showing you what's been previously marked as People's 14. Do you recognize this individual?
That's the individual that was a co-defendant on this case.
Robert Baker?
Yes.
Okay. And on the day of October 2nd of 2018, were you responsible for bringing the defendant and Robert Baker into this courtroom for court appearances?
Yes.
And
Uh-oh,
subsequent
somebody
to the
said
court
something.
appearance, were you also responsible for returning them to the courthouse lockup?
Yes.
And that would be part of the normal job of a bailiff performing security functions for the courtroom
Yes.
with individuals that are in custody?
Yes.
And did you follow certain protocol in order to keep the defendant and her co-defendant at that time, Robert Baker, separated?
Yes.
How do you do that?
Well, first they were both classified as K-10 at the time.
What's that mean?
So they were dressed down in orange jumpsuits, and they're both waist jeans and leg jeans.
What does that mean in terms of how they're kept?
A high security prisoner. So they're kept separately, no communication within them too. And then, of course, when you come into the courtroom, you have to separate their chairs as much as possible.
And was there also a sergeant supervisor who was assisting you in this courtroom that day?
Yes.
Who was that?
That was Sergeant Bob Westfall.
And was he also in the courtroom with you on October 2nd?
He was assisting me.
Okay. Did he also go into the lockup with you at some point on October 2nd and October 3rd?
Somewhat, I opened the door and he was at the threshold between the 101 courtroom and then the 101 lockup. So he was between the open door.
And once the court appearance was done in this courtroom, what did you do with respect to the defendant and Robert Baker?
So it was a quick matter, calendar matter that day. I initially escorted Robert Baker first to the door, and then my sergeant caught him at the threshold, and he immediately ordered him up to the stairs. It's just a second floor landing. So the lockup facility is on the 10th floor. So we're actually on the 9th floor. So there's a landing that Robert Baker was sent to.
Okay.
As soon as he was staged at the second floor landing, I came back in and then escorted Cemeteal into the courtroom lockup.
Okay. So at this point, Baker is supposed to be at the top of the staircase leading to the 10th floor lockup.
Yes, but he was lingering on the second floor landing. He wasn't listening to my instructions because I ordered him all the way to the door.
Were you directing him, commanding him to proceed up to the top of the stairs?
Yes.
And what did he do at that point?
He was lingering around the stairwell on the second floor landing.
Well, I am so hungry.
So he did not obey your instructions.
No, and also Sergeant Westfall was also ordering him,
And I
and he was
want-
still lingering around until I entered the courtroom with Cemeteal.
With defendant Cementili?
Yes.
Okay. And once you took defendant Cementili into the lockup, what happened at that point?
So then I took lead in front of Cemeteal, and then I ordered Baker to the end of the doorway on the 10th floor. And at that time, then he followed my instruction, went to the end of the door. And then I stood in the second floor landing. Then I ordered Cemeteal to come up the stairs. So at the same time, I could keep an eye on Baker, and I could keep an eye on Monica as she's coming up the stairs.
Defendant Cementili?
Cemeteal.
Okay. And then did you take any particular position between the two as you came up the stairs
Yes, I was between them both, so I could keep an observation on both Baker and Cemeteal.
at the same time?
Yes.
And at some point, did you also order the defendant Cementili, to do something?
I had her come up to the stairs
Towards you?
Towards me. When Baker was up by the door facing the wall, then I ordered Cemeteal to come up the stairs to the second floor landing, and then I went up to Baker so I could open the door.
Okay.
Still keeping an eye on both inmates.
Okay. During this time, was there any communications between between the defendant and Robert Baker?
Yes, they were. Baker was talking to Cemeteal. Hey, we got this, Mercedes, we got this. I wasn't really paying attention to that because I was looking for hands and basically trying to get them escorted to their lockup.
What did he call her?
Mercedes.
In your report, did you indicate it might have been Madonna?
It could have been.
Is that what you wrote in your report?
I got to look at my report to refresh my memory. It's been a couple years.
That's not unusual. She's writing. Oh, she's writing. Disagreeing. I think she's so busy.
On page 4, I indicated it was Mercedes. We got this, and I put in quotes.
Okay. Did you indicate previously, though, you thought it could have been also Madonna?
Hello. Possibly.
Okay. So Baker was saying to the defendant, "We got this."
Yes.
Okay. And at this point, were you still maintaining the distance between the defendant and her co-defendant at that time, Robert Baker?
Yes.
And what did you do?
I told him to stop talking, and then I went up to the door to open it because Baker was actually he was in cell number 8, which is the actual door, the lockup facility. Right as soon as you open the door to the 10th floor, his cell was right immediately to the right, and then Cemeteal was all the way down the end to cell. I think it was
He
locker number
calls
2.
him Cinematil. Not Cinematilli. Cinematil.
And is there a recording of this incident?
Video recording?
Yes.
Okay, everybody got mad at me for calling him Cinematilli instead of Cematilli. He's calling him Cematil. I am.
That you reviewed?
Yes, but that wasn't discovered until the next day, on the
Yes.
3rd.
But there is a recording regarding, we're talking about October 2nd still, yes?
Yes.
I know. I shouldn't have done that.
Robert, I have a set of 3 video recordings. May they be marked collectively on a CD as People's 163?
Yes.
Thank you.
We have exhibits.
And they will include October 2nd and October 3rd of 2018.
I know cinnamon rolls. I so want cinnamon right now.
The first one.
I have been wanting them for days. I made the canned style. Those were nasty. I'm eating chicharrones. Salt and vinegar chicharrones. I need something. Honey, I need the chicharrones. Really, Sensei? Really? You are really working my nerve. Why do you have to be right there under my feet when you can lay right next to me just as comfortably, if not more so? This dog. Right under my feet.
Can you tell us what we're looking at here?
So you're looking at the camera bubble. Again, the bottom is actually 102, looking toward 101, which is this court. My
The door
sergeant-
open is 101.
Door opening is 101. Sergeant Westfall is meeting the threshold, and he ordered Baker up to the end of the hallway.
And that's another bailiff that
The
came out
bailiff
of
came out of 102.
So we just saw Baker go up the stairs and
Up the
Orange.
stairs, yes.
You're still in the courtroom at this point. There you
I'm
are.
walking in right now. So Baker is up on the second floor landing up the stairs. I separate myself between both co-defendants.
And that's the defendant coming up the stairs behind you?
Yes, it is.
Now, the following day, October 3rd, were you again working as a bailiff here in this courtroom?
Yes, I again was working overtime that morning in this courtroom.
Okay. And according to your typical protocol, the next day around 7:40 in the morning, what did you do?
So normally I come in, the courtroom's empty. I do a security check, basically go through every section of the courtroom, jury box, the audience, and basically check to see any bags or anything was left over. Then I make my way into the lockup. I check the cell before any inmates get there, because in the morning we do the calendar, and then we get the inmates for the either Department 101 or 102. So after that was cleared, I walked up the stairs and I checked all the railings, and that's when I noticed on the railing on the second floor landing, going up to the 10th floor lockup, there was a baggie rolled up. We call it a kite.
What's a kite?
Kite is a way inmates communicate between themselves. So it could have been.
I know what a
narcotics,
kite
it was
is.
rolled up really tight. So I saw it on the bottom, on the inside portion of the railing.
It's, do you know how you used to make those little triangles in high school if you were my generation before we had phones with texting? And we used to flick them like paper football? Something like that. It's got a string attached. And they flick it and they send it down the hall for somebody else. Yeah, kites are fun.
On the bottom portion of the rail as it going up.
Going up the stairs?
So I immediately called my sergeant, which was Bob Westfall, and I told him, if you don't mind checking the video cameras for the day prior to see if anything was placed at the time when Baker was going up the stairs. And that's when he discovered he actually not placed one, he actually placed two items.
Okay.
So that's when he came into the courtroom. We found the other one.
Okay. So to show you the second video, also dated October 2nd, that's contained on the CD exhibit 163.
Sidebar. You know, in the custom of some cultures, this head thing, I have to pop my neck and get it really loose to do that, Lil. And doesn't it change your everything kind of move? I get seasick
Tell
watching
us
them.
what we're seeing here.
I don't mind
The
it,
video come on
but
for a second.
I get
So the bottom of the screen is actually the 10th floor lockup door. We're looking toward the stairwell as you going up one.
I get seasick. I get motion sick easy.
In the railing that's
I had
concerns the
somebody I
lower
worked with that was constantly doing that, and it drove me crazy.
your figure.
It's okay. I know that for culture, and I'm not against it.
His right hand.
It's right here. Looking back.
This is where you said he was lingering and you were directing him to continue up the top of the stairs,
Yes. Now it goes to the top of the railing. Inside portion places the second item.
which you couldn't see from your vantage point at the
No,
bottom.
that's why I sent him all the way to the door because there's nothing to put on the wall. It'll be obvious.
That's you coming up?
That's me coming up. That's when he's talking back to Senator.
And that's Baker speaking back to her?
Yes.
Okay.
So I ordered her to come up to the stairs and go to the right side of the wall. As I was keeping an eye, because the door is immediately as you walk inside. It's the south celebrate. So I immediately placed that. It's still here.
So you went back on October 3rd to watch this video once you noted the first item at the bottom of the stairs.
Yes.
Which then gave you information regarding the second one at the top of the stairs.
Yes.
I'm going to show you a third video. This one from October 3rd.
That's my sergeant, Bob Westfall. And he pointed to the upper portion of the railroad. We discovered the second item. I was taking photographs for the item.
All right. I have an evidence envelope. It has the name Gable on the front and number 191 and 192 written in red pen. Make it and its contents being marked, please, as People's 164.
Yes.
Detective, I'm going to
Your Honor, the defense is going to object as to People's 164 on grounds of the contents are hearsay.
Overruled.
showing you this LAPD evidence envelope that appears to have other envelopes inside. Can you open the envelope, remove the contents, and tell us what you find inside?
Well, I can tell you, these are the items I booked under the LA Sheriff's File number. So they were probably.
Enjoy
booked under
happy
the LA
time.
Since it's an LAP case.
Okay.
I know that for a fact because I identify my writing.
Definitely
I put
enjoy
their
your
number,
happy
I put
time.
EV2, I actually did the sticker. And my name's on the sticker as evidence.
And there are two
criminal.
envelopes that are rolled up inside of the LAPD envelope, correct?
There's two, evidence 1 and evidence 2, and it's also correlates to my report that I actually authored.
And you mentioned
Enjoy.
earn number. Is that the way the sheriff's department tracks?
They're criminal.
Okay. So when you write a report
In this day and age, you're criminal and
on
proven innocent.
a matter, you would write up
Be safe. Have a
report
great
with
shift.
a unique
We'll
case
see you
number
tomorrow, hopefully.
that would
Thank you
also
for
be
spending
related
all
to
the
any
time with
evidence
us.
recovered on that case.
Makes me feel special.
And so anything that you would recover, such as a kite, that would generate a report as well as evidence item numbers.
Overall. Yes.
And in this case, you had two separate items that you booked, correct?
Yes.
And that's why you have two separate envelopes. You labeled one as evidence 1 and the other as evidence 2.
Yes.
And do those correlate to the numbers in your report under that unique sheriff's case number or URN
Don't forget to
number?
put the word ILIK.
If you could open up
like
the envelope with
I like
respect to evidence
in the
1
drawing.
and tell us what you find inside.
Remember, got to put that in
Plastic
there for
bag
the
with,
drawing.
a red
And
envelope.
tonight, They got a kite?
It's in some kind of plastic wrap.
It's a plastic wrap.
Was that the same plastic wrap that was covering evidence 1 when you found it at the bottom of the stairs?
Yes.
Okay. And what do you have there that you've removed from the plastic wrap?
So it was the red envelope I found inside the plastic bag that was tightly rolled up. It was partially torn. So it does say Angeles County Sheriff's Department, has the annex number. It has in parentheses 501-6191, which I'm assuming it's a booking number. And then it has written in pencil 3300 and 18U, which is the module at Men's Central Jail. And then that's the 18U is the bed, the bunk where this person is assigned to.
Okay.
There is paperwork inside, and this is the exact paperwork I found. And it was like,
You said there was a number on the exterior that you thought was consistent with a booking number. What was that number?
it's 501-6191.
If I show you your paperwork again, did you include that number actually on the front of your report?
Yes, and I associate that with inmate Cementil.
So that was the defendant Sementili.
Cementil, yes,
That would be her booking number.
that is her booking number.
Whereas the module with the unit number, that correlates with the booking location or where Baker was being held, correct? At Men's Central Jail?
That's correct. In the face page, I put Men's Central Jail in module 3300.
Okay. So is there something inside of that red envelope?
It was 2 pieces of paper. It was like puzzle paperwork. On the back side, it had numerical numbers just written on the paper, positive, negative. And same thing with the other one. It was another puzzle paperwork. And then the back side, it had some numerical numbers, positive, negative.
Showing you the first page from evidence 1. Was this the item number that you recovered from the railing at the bottom area that we saw on the video?
Yes, that's one sheet of paper.
Did that appear to you to be some type of coded communication? Bless you.
Overall. Yes,
Do you commonly come in contact with items such as this when you're working in the jail facility?
yes, and I also work gangs. I was an OSS detective, and that's how normally Mexican Mafia and different inmates communicate on different messages.
Showing you the second page, again, does that appear to be some type of coded communication?
That's what it appears like.
You could return these to that red envelope and then to the evidence 1 envelope that you booked it under. And you're placing the plastic wrap over it as well. Appears to be some type of a plastic baggie.
It resembles a booking bag that normally people get in the jail facility.
Okay. Let's look at evidence number 2. Is this the envelope into which you booked a similar kite that you recovered that we saw on video number 3 from the top of the railing just outside of the 10th floor lockup?
Yes, I have my printed the report number, which is the the uniform report number. I have my name. I booked this piece of evidence, and I also put a little narrative paper containing numerical cipher message recovered from the top railing leading to the 10th floor lockup. In this,
Numerical what message?
I put
Cipher.
numerical cipher message, basically.
Encoded.
Encoded message.
Okay. You could open this envelope and again describe to us what's inside the envelope.
And this one was a smaller plastic baggie, and it was tightly rolled up, and it was containing 1 sheet of paper. Both sides were actually the same type of numerical cipher, which is positive, negative numbers on both sides.
Thank you. Showing you the front side, the one side. Again, does this appear to be similar to the other evidence item that we looked at, which is some type of numerical code?
Yes,
And on the back side, again, same?
yes.
Okay, I'm handing this back to you. If you could again place this coded kite into the plastic and the envelope that you booked it to. And then if you could place both of those sheriff's evidence envelopes back into the LAPD booked envelope. Have you done that?
Students will know, ma'am.
Thank you.
Texas weather just been throwing out temperatures like Powerball numbers, 61, 25,
Second morning recess for 15 minutes.
29, and
The admission
83.
applies. See you back here in 15 minutes.
That'd be about right. Okay. What? I was talking.
Nothing further.
Second morning recess for 15 minutes. The admission applies. See you back here in 15 minutes.
Oh, 15-minute recess. Woohoo. We always love having visitors here. Thank you guys so much for joining us. I greatly appreciate it. I need to screenshot that. We had a very interesting day with the other hearing that we were watching, the Rose Petal murder trials. I could not believe that he actually seriously actually confessed. I know that they said that there was going to be a confession, but you know what? You never know. Sometimes they will say things and it doesn't happen the way it's supposed to happen. So let me get that Karen Reed document back up and we'll read that while we're on break. How about them apples? Let me get something fixed. Okay. So we were here. Let me switch pages. Let me go here. Let me get this thing off. Okay. Back to the Karen Reed memorandum in support of writ of habeas corpus. The record independently lacking on the second prong, as it reflects no jurisdictional consideration of alternatives to a mistrial. Here, there are one obvious alternative: to simply ask the jury the charges on which it was deadlocked, or ask the jury whether or not the final note related to all or less than all of the charges. This opinion is apparent from a face from oh, no wonder everything felt weird. This opinion is apparent from the face of Massachusetts, which states the judge may declare mistrial as any other charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree, and direct such verdicts to be received and recorded. Emphasis added. I like your emphasis added. Reading time, oh sunny day. However, that judge may first require the jury to return verdicts on those charges upon which the jury can agree, and direct that said verdicts be recorded and received. I did that already. In fact, the reported notes expressly indicate that such reception of partial verdicts is required before a mistrial may be declared for manifest necessity. See Massey R. Crime P.27 reporter's notes. This is in parentheses, and these are reporter's notes. The rule also provides that the court may declare mistrial in a case where the jury is unable to reach a verdict. However, it must, black italicized, or receive a record of the verdicts for which the jury can agree upon. Emphasis added. I love it. Had the court inquired as to the extent of any partial verdicts, existence of any partial verdicts, and the jury articulated its verdict consistent with the statements of juror A, B, C, and D, and E, and double jeopardy implications would have been cleared and decisive. Parentheses, I need, indeed, when virtual unanimity, the case have applied collateral estoppel to bar the government from regulating a question of fact that would be determined in the defendant's favor by particular verdict. United States versus Pauludi, I can't say it, or Walver and Haverner. When the jury hands down a partial verdict, the judge's final judgment is rendered on the counts upon which the jury has reached the agreement. First Circuit's decision in the United States versus so-and-so, 2004 provide a helpful analog. They are in the midst of trial. Upon noticing that only 11 jurors were present, the district judge, consulted with both of the prosecutor and the defense lawyer, outlining two opinions: either postpone the trial until the 12th juror can be located or proceed with a jury of 11. Defense counsel conferred with her client and informed the judge that the defendant did not wish to proceed at the moment with 11 jurors, but rather would like to wait a 12-member jury. Shortly thereafter, the judge learned that for the first time that the missing juror had been absent during some or all of the earlier portions of trial. The judge then announced that he was going to declare mistrial only because 11 jurors had heard the evidence and that he did not believe that there were any way to cure that defect. The trial judge denied a subsequent motion to dismiss on the grounds that the mistrial was required by manifest necessity became only 11 jurors remained and the defendant had refused to proceed with fewer than 11. First Circuit reversed the finding that there was a clear alternative to the mistrial, proceeding with 11 jurors. While the district court had tentatively explored that alternative, it never exhausted it. The court never offered the defendant a choice between proceeding with the 11 jurors or accepting the mistrial. It was not made clear. It was that's a good point. During the pertinent time frame, the court made no effort to ascertain the defendant's attitudes or wishes with regard to the possibility of a mistrial. In the view of the omission, the record compelled a conclusion that the jury of 11 alternate was not adequately explored. This conclusion was dispositive because where there was a viable alternative to a mistrial and the trial court failed to adequately explore it, and finding a manifest necessity cannot stand. The present case reflects even less consideration of an alternative to a mistrial. While the trial court discusses two prior jury notes reporting an impasse with counsel, it did so only in the context of deciding whether to give a Truy Rodriguez charge. And the court did not even mention the prospect of a mistrial. This is true. The SJC, therefore, the Supreme Judicial Circuit, there are courts, therefore legally erred in finding that the trial court's response to the first two jury notes reflected adequate consideration of alternatives to a mistrial. I don't agree with that. That was not an adequate alternative. There was nothing in the record to indicate that the judge was considering a mistrial at that time, while the note stated that the jury had reached an impasse on some charges. The test is not whether the judge considered that she had a potential problem on her hands, but rather she accorded careful consideration to the defendant's interest in having the trial conclude in a single proceeding. With the record barren of any hint whatsoever that the judge was aware of the double jeopardy implications of her decision, the defense respectfully submits that the court cannot find that her discretion was sound. The statutory prohibition on order the jury to continue deliberating without consent was among many factors that the trial could or should have considered in the conclusion of the parties. Consultation with the parties. The statute would not have prohibited a trial court from simply asking whether the jury had reached a verdict on any counts or asked the jury whether an impasse related to all or lesser than all the charges. Contrary to SJC's suggestion, see opinion 19 through 20, there is simply nothing coercive about asking a jury whether it has reached a verdict on some but not all separately charged accounts. I'm with you on that, Boo. Affirming instructions that simply ask a jury to report any partial verdict it has already reached as non-coercive. United States versus Ketchigo. A court does not err if it asks about a partial verdict, even when it is clear that the jury is at an impasse and further deliberations would prove fruitless. Moreover, the trial court should have alternately A, informed the jury that it could not be required to continue to deliberate without its consent, and still B, letter B, ask it to retire to consider whether it's prepared to return any partial verdicts. Yeah, they could have done that. Massachusetts statute on its face, by permitting the jury to be sent back to continue deliberating with its consent, contemplates that the courts may non-coercively make a post-Trudy Rodriguez inquiry to the jury as to whether it consents to continuing deliberation on all or less than all charges. Whether the trial court would have ultimately adopted any of the alternatives is beside the point. The dispositive fact for present purposes is that the record provides no indication that the trial court even consider available alternatives. Contemplates. Thank you, Jen. For those of you who are new here, I am severely dyslexic, and to the point that if I'm in college, which I am, and I'm not taking a class online, that's all I take. But if I was in a live classroom environment or on a Zoom call environment, I have professional note takers. Reading for me is very difficult. So thank you, Contemplates. Jenny, I appreciate it. This is really challenging for me. I've improved greatly, but I still mispronounce things. Bluefor held that before declaring a mistrial, the trial court was not required to permit the jury to return a partial verdict on lesser included offenses within a single charge. The Supreme Court explained under Arkansas law, the jury's opinions were limited to two: either convict on one of the offenses or acquit on all. A case relied upon by the SJC also involved lesser included offenses with a single count. By contrast, whereas here a complaint or indictment in multiple counts charges multiple crimes, a partial verdict is available alternative under the Massachusetts law. ... Whereas a defendant has been charged in separate indictments or complaints, each with a separate verdict slip. So she had 3 counts. Those are 3 separate, so they can be hung on one count and found guilty or not guilty on the other counts. She can be found guilty on one and not guilty on 2, not guilty on all 3, whatever the combinations are. Number footnote 9, a stated page 15, whatever. The federal constitutional burden to justify a mistrial is clearly on the Commonwealth. Yet the state court not only failed to identify that burden, but improperly placed the burden on the defendant on the subject, such as considerations of alternatives. We got 10 more pages of this. While the law is clear that the jury was deadlocked may constitute manifest necessity, the key to this principle, of course, is that the jury must be genuinely deadlocked. Here, it is possible to read the jury's notes into context and the trial court instructions as reflecting an impasse on one count but not others. The jury reference to charges is easily reconciled with the post-trial affidavits affirming that it was only deadlocked related to the lesser included offense on count 2. You are so right about that. Let me move this over and let's talk about that. You are right about that. Here is the problem I'm having with her fighting this. The form was not filled out at all, so they cannot do anything according to case law. But here's the problem I have with that. The jury instructions, which was said by the jurors after trial, were very confusing. And the prosecution did fight some of the things on those and saying it was confusing, and they were denied. I think that if the judge would have done one thing, are you at an impasse on all counts, 1 count, 2 counts? Don't give me the information, but do you have answers on any? Yes, Your Honor, we have all come to a unanimous decision on 2 of the 3. Okay, I need you to go back into the jury room. I need you to fill out that form on the 2, 3 and leave the one that you're at an impasse blank. She did not look for the resolve. She just came in and said, "Done." And that's what I'm getting here. Don't forget to be entered into the drawing for the end of the month giveaway. $50 gift card. I do hear what you're saying, but I think that she did not give them an opportunity or educate them. Jurors are not most of the time, jurors never serve jury duty more than once or twice in their life. And then a lot of times they don't even get to this phase. And so instructions to the jury and educating the jury and telling them what they can do and can't do, I believe is part of the judge's responsibility. Had the judge told them, okay, have you come to an impasse on all 3? Or do you have a decision or a unanimous decision on any of them? Don't give me the information. Just yes or no. Your Honor, we have come to unanimous decision on 2. Okay, go back to the jury room. I need you to document and record that. I think I'll call you back when you're done. And then declared a mistrial on count 2. That would have been a resolve. I see your point. You may be right on that, Jenny. I don't know. But I felt that it felt icky to me. I don't know about you, but it felt icky to me. And I'm going to respect that. I'll respect that, Jenny. But it did feel real icky. I'm not trying to be weird, but it didn't feel good to me when that happened. But let's read on. Here it is possible to read the jury notes in the context of the trial court instructions as reflecting an impasse on one count but not others. The jury refers to charges. Okay, count 2. Indeed, second trial repeatedly referred to those lesser offenses as distinct and multiple charges, both in its initial and supplemental instruction to the jury. In this context, the jury's final note was factually susceptible to 2 alternative interpretations. Okay, here's interpretation number 1 of that last note. That the jury had reached an impasse as to all charges, or 2, that the deadlock applied to only some of the charges, i.e., multiple lessers included allegations with a single count, such as count 2. It was not an ambiguous note affirmingly declaring an impasse on all charges as assumed by the SJC. The information received from the jurors post provides the latter interpretation was correct. The jury failure to expressly mention its agreement on counts 1 and 3 is understandable in the light of the court's instruction. It should continue deliberating until it had reached a final verdict on each charge. And that makes sense. So they may not have filled out that form because they thought that they weren't allowed to fill that out until all charges were agreed upon. And since count 2 lesser than was not agreed upon, they didn't fill it out for count 1 and 3. There's the confusion, Jenny Christie 76. I'm not disagreeing with you. I'm just saying this is their point of view. I play devil's advocate a lot, so don't take it personally. June 25th of 24, blah, 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 emphasis added. For these reasons, the SJC was wrong in characterizing the juror affidavit underlining the defense motion as inconsistent with the jury notes. Oh, I don't think you were mad, but I am explaining for everybody. The jury simply never stated that it was unable to reach a unanimous decision on any of the charges. Opinion the option at 3 emphasized added. The SJC did not mention, much less analyze, the reading of the notes set forth by the defense above. The trial court took no steps to clarify the jury's notes. In the double jeopardy context, where the Commonwealth alone bears the burden of establishing manifest necessity, it is ambiguity, I can't say that, must be read in the defendant's favor. That. Ambiguous verdicts, I can say that one, must be construed in favor of the defendant. ... Downham versus United States, ... We resolve, okay, this is what they say. We resolve any doubt in favor of the liberty of the citizen rather than exercise what would be an unlimited, uncertain, arbitrary judicial discretion. Citation omitted. The SJC therefore erred in construing the jury's notes as an unambiguous declaration of an impasse on all counts. Ambiguity. Thank you. There we go. Ambiguity. This does help my reading. I will give it that. It does help me. Not that I'm real happy about it, but it does help me. In sum, a decision made so precipitately could not have been the product of any careful consideration of the valid right of the defendant to have her guilt or innocence determined in a single trial. I'm telling you, girl. Oh, I got to tell you, though, I love it when Haley Mouse comes on and read for me. Oh, I love her accent. It's so relaxing. This in and itself precludes the Commonwealth from trying Miss Reed on count 1 and 3. The jury's unanimous conclusion following the trial that Miss Reed was not guilty on counts 1 and 3 constitute an acquittal and precludes a re-prosecution. What constitutes an acquittal is not to be controlled by the form of the action in question. Martinez versus Illinois, ... Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offended charges. Yeah, I get it. Hey, I would never read the Bible when I had a Bible class because I was terrified to read out loud. And look what I'm doing. Rather, the court determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offense charge. Martin Leinen, whatever. Number 10 footnote, the Commonwealth versus Danielson 441 mass ... The jury responded by a Tui Rodriguez charge by saying it had not reached a unanimous decision on any of the charges. The trial judge then asked the counsel for his position. The counsel said that he did not object to the mistrial. Daniels does not, therefore, support the SJC finding that the trial court appropriately exercised its discretion here. In any event, Daniels did not bind his court in its analysis of the federal constitutional issue. Okay. End of footnote. Back up top. This is because all black, italicized, and bold. Whether an acquittal has occurred for the purposes of double jeopardy is a question of federal, not state law. Emphasis added. Here, the affidavits by the attorney Jackson and Yeti reflect statements by 4 deliberating jurors, and the jury had reached a final unanimous conclusion that Miss Reed was not guilty on count 1 and 3, and an indirect statement by the 5th juror that they had agreed with respect to count 1. Both the trial courts and the SJC, for the purpose of ruling on double jeopardy issues, proceeded from the assumption that the affidavits were accurate. Parentheses. That's what the SJC said. Opinion 26 in 14. There was nothing tentative about jurors' statements. To the contrary, they were definitive in describing the results of the jury's deliberations. The affidavit of Alan Jackson, blah, 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 juror count, blah, 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 not guilty. Juror was emphatic that the count 1 second-degree murder was off the table and that all 12 jurors were in agreement that she was, in all cap, not guilty of such crime. Affidavit of David Arianetti, reflecting text messages from B, parentheses. It was not guilty on the second degree. No one thought she hit him on purpose, or even if she knew she had hit him. Reflecting juror C's statement relayed in intermediary C that there was no consideration for murder 2. Red Room 2. And Miss Reed should have been acquitted on that count. Supplemental affidavit of Alan Jackson, juror letter D, without hesitation, said in substance, every one of us will agree and acknowledge that we found that Karen Reed was not guilty, all caps, of count 1 and 3 because that's what happened. Second supplemental affidavit of Alan Jackson, juror E, explained the jury was unanimous on 1 and 3, and Karen Reed was not guilty of those charges. Despite significant publicity that accompanied the filings of the defendant's motion relying on jury declarations, none of the remaining jurors ever communicated with the court or the court staff or the district attorney's office, defense counsel, or the media that they had. Are we back? We're back. That they had disputed the accuracy of the 5 jurors' representation. We're going to creep up to that sentence. We're going to pull that aside. I believe we are back. Let's go.
Several videos. So is it your testimony that if you had placed, strike that. Let me ask you this. You determined that at no point, based on your investigation of these evidence items, Monica Cementilli never actually received either of those. Just yes or no?
Overruled. No, as I was escorting Baker up by the threshold of the door in the 10th floor lockup, I had eyes on Cementilli, and I told her to come
Finally said
to
it
the front
right.
of the door and wait by the facing the wall. So at no time did I lose sight of her, and she never went to the railway to pick any messages up.
That's right. She never went to the railway to pick any messages
She was
up.
close, but I had her escort come to the
We are now on the
she
cemetery
never had a
trial.
chance.
This is
Okay,
a
but at no point did she ever
guard
disobey your
that was
instruction.
guarding her and Mr. Cementilli, transferring them back and forth to court for a hearing, and notes were passed, and that's what we were discussing at this point. If you were watching the Rose Petal Zachary Hughes trial, Zachary Hughes did get on the stand. Go back and rewatch my live. He admitted to unaliving And not only that, he had very great detail. And the why he unalived was because he accused the mother of essaying her daughter. And he felt that it was his obligation to unalive her to protect the child. Mic drop. Boom.
Go over to the right side,
No.
correct? And based on your observations on October 2nd, at no point in time did you hear Monica Simontilli make any statements that indicated she was aware Robert Baker had left anything for her. Is that right?
I don't believe so.
You also mentioned briefly in your testimony that these kites can have some relation to gangs.
Oh, yeah.
Yes, in my report, I
Yeah.
actually had some ciphers that I personally found when I worked the jails.
Okay.
And talked to inmates, and that's why I left in my report. I actually put the way they actually use a master key.
Okay.
So at that time, I ordered jail deputies to go to both the locations and have to search for a master key.
Okay, but and my question is just that you are not aware of, based on your involvement in this case, being the bailiff of record on several court dates, you're not aware of any gang affiliation in this particular case. Is that
No.
right? I have nothing further, Your Honor.
Further by the people.
No, thank you.
Thank you, Detective Balarama. You're excused.
Call Detective Christopher Gable.
Hill Country schools are closing due to the winter storm. So, which schools are closing, y'all? Are you kidding me? Another rocket blast blows into Texas and Central Texas, San Antonio, Austin, and Texas.
Do you solemnly state the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please have a seat in the witness stand.
Yeah, no one's closing. All of our schools are open. Nice, bright people.
And for the record, say spell your first and last name, please.
Yes, my name is Chris Gable, and it's spelled CHRISGABLE.
Good morning.
Good morning.
Are you currently employed?
No, I'm retired detective for LAPD.
Okay, then what is your background with the LAPD?
In the LAPD, I spent a few years in patrol. Then I went to detectives. I worked robbery for a while, and I spent 15 years in homicide, 5 at Hollywood homicide, and 10 at robbery homicide.
So overall, how long were you a police officer?
26 years.
Now, back in the time frame of 2017, specifically March 7, 2017, were you assigned to the case that you're in court on right now?
Yes, I was.
Can you tell us how that came about?
Sure. Valley Bureau Homicide reached out to us to see if we would take over the case because they determined they didn't have the resources or the time to work on the case anymore because they thought it became a little bit more complicated than the time they had to put into it.
And currently, what was your assignment at that time?
I was assigned to Homicide Special at Robbery Homicide Division.
And we've heard a little bit about it, but can you just explain then? You said there wasn't enough time, but why would a case from the Valley then be transferred to the Homicide Division, Robbery Homicide downtown?
Sure. So the way I like to explain it to make sense is so LAC is huge, it goes from the harbor to the valley. So what LAPD did to manage it is they break it up to 20 different areas or divisions. And in each division, they have detectives assigned to handle every single crime that happens in that division. And they're super busy. And so when they get a crime, especially a violent crime like a rape, a homicide or robbery, that becomes it exceeds their time to work on it or the resources to work on it, then they reach out to us. So to see if we'll take the case. Robbery Homicide Division 2017 had about 100 detectives assigned. And all the detectives have specialized in either robbery, homicide, sex assault crimes, or surveillance. So we have the resources and the time to work on bigger and more complicated cases.
At the time, then, who was your partner?
Detective.
Oh, yeah, I need to tell y'all something. There's a bunch of you who are just hopping on. Toxic Orchid's husband was on that airplane in Toronto, and I've had several of you asking if I would do an update. I don't feel comfortable showing videos or doing any updates on that right now because she is a mod on our channel, and her husband was on that plane when it flipped upside down and cartwheeled that way and landed on it upside down. And I do not wish to cause any more trauma for her or her husband or family or other victims. So please understand, thank God he's not really hurt. He has whiplash. Other than that, he's fine. mentally, maybe a little more time will be needed. He's not talking about it, but please, I'm not trying to. She shared this publicly early this morning, but for those of you who have instant message me or private message me over in Discord asking me, because there are some updates going on, this is one that I'm not going to do because I do not wish for her to come on and have to see that. All right. Thank you so much for understanding.
3 Barry Tillis.
When you're assigned and take over the case, is this a partner kind of relationship where two of you take over together as partners?
Yes, we worked side by side through the whole case.
Now, when did you first became involved on March 7th, 2017? Is that correct?
Correct.
And was the current then detectives Parshall and Verna? Does that ring a bell?
Correct. It was Parshall and Berna.
So how do you get up to speed on the case from your inception of when you come on?
Sure. So they came up and we met with them at the in our office, and they explained the case. We learned about Robert Baker and his DNA being found at the crime scene. We learned that he was a 296 registrant. He had about 10 years of military service. We learned that there was another suspect that went in the house with him that was still unidentified. We learned that there was a secret affair, love affair, or affair, I should say, between Monica Samatelli and Robert Baker, and that he was her racquetball coach. And they told us that they had set up and started surveillance on them. And at that point, they decided to withhold the information.
The whole country closes with the first
DNA,
eye device, but
which
they're
we thought
not
was a
this
good
time.
avenue to take.
Why did you think that?
Well,
What was your next steps, and when you came
Our
in
bus
based on
drivers
information
don't know how
that
to drive in
Parshall and
snow
Verna
and
gave
ice.
you as far as your strategy?
Sure. So once we took the
And
case,
I'm in
we said, yes,
just
we'll
north
take the
of
case.
San
We gave
Antonio,
them some
Texas.
directives what we wanted. We told them we wanted to continue
I'm
with the
Central
surveillance
Texas, so.
of Monica and Robert. And we wanted them to not tell them that the case was reassigned to us. We wanted them to maintain the impression that they were still working it as a burglary gone bad. And we did not want them to reveal the DNA results. We wanted them to continue to trickle it out. And that was at our direction when we wanted more to come out.
Why did you decide that?
Well, the plan was to, while they were doing that, at our end, we were gathering more information, social media, call detail records, all that kind of stuff. So we're writing search warrants and getting all that stuff. And we're trying to learn so we could learn the background better. And we did that. So ultimately we would, at the end, we would tell them that the DNA all came back and it was all negative just before we arrested them.
And again, why would you tell them that? Why was that the plan?
Well, the plan was that for that exact operation was when we knew Monica was scheduled to go out of town to New York and I think Canada. And so the plan was to inform her then that the DNA finding all came back and none of it was relevant. It didn't lead to anything. And that the insurance would be released. We did that in hopes that we would get.
Hey guys, can you do me a favor? I just noticed, if you are not a subscribed person, please subscribe. It's vitally important. Do you know why? Because I don't know what's going on, but I've lost 34 subscribers since this morning. I don't know if it's a YouTube thing, but I've never lost like anything like that that wasn't a YouTube. So please go and make sure you are subscribed. Disheartening. I've worked really hard to get up. I was at 2,808. 2,808, and I have really started dropping again. I don't know what's going on. The numbers are going everywhere. So do me a favor, just check and see if you are a subscriber. I would appreciate that so very much. Doesn't cost you anything to subscribe.
Trail of their communications to see how they responded to that.
At that time, when you first came on the case, then were you aware about the defendant's requests to be cleared for the insurance money?
Yes, yes.
Did you ever personally have a conversation with her about insurance money or clearing her at any point?
I didn't have a conversation with her, but I was present when Detective Parshall had a conversation with her.
Okay. And that appeared from what you saw to be a concern of hers to be cleared in order to receive the insurance money?
It was a concern.
Go ahead.
It was a concern.
Now, you said you wrote a lot of search warrants. What type of search warrants were you involved in? You don't have to go through all of them, but what did you do as far as your work?
Well, I think I wrote about 34, 35. So basically, social media, the gamut of social media warrants, a lot of warrants, once we got their devices, to get into those devices and forensically analyze them. encrypted app warrants for WhatsApp and Viber, warrants to go into the house and various houses the day of the arrest. Every warrant we did, yeah.
As of March 7th, when you came on, had some warrants already been done?
Yes, Valley Bear Homicide had already completed maybe about 7, which included call detail records and various things like that, which they give to us. So we had a lot of information ready to start.
So were you able to review what had already been done as far as warrants and get up to speed on the case?
Yes, and that's what we spent the first few weeks doing, just going over their results and reviewing video that they had pulled, surveillance video and stuff like that.
So were you able then to review the videos, I'll go through them, from the Target parking lot? Did you review those videos?
Yes.
Did you review the videos from the Rouse parking lot?
Yes.
And did you review videos from LA Fitness?
Yes.
Did you review the surveillance videos that show cars coming and leaving on January 23rd, 2017 from the Cemetery Street right there at Oakdale and Queen Victoria?
Yes.
Okay. Did you review interviews of people that had already been interviewed?
I'm sorry, say that
Did
again?
you review interviews of some individuals that had already been interviewed?
Yes.
Okay. And then you did your own interviews?
Not on all of them, but and some of the other detectives in our unit, since we have a lot of detectives to work with, did interviews as well.
Now, you knew at that point then that GND, the group in the Valley, had already been surveilling the defendant and Baker for quite some time, correct?
Yes.
And so you knew that they had spotted them out around town in February and into early March before you came on.
Correct.
Did you stated that you continued that surveillance. What unit did you use?
We used a unit that's organic to RHD called the Special Investigative Unit or section, which is SIS.
And what do they do?
They do clandestine surveillance for all the detectives at RHD. If we have a suspect or a possible suspect, we'll ask them to follow them, and they'll ask what our concerns are so that we can get what we're looking for. It could be as simple as trying to find out where they actually live. It could be finding other cars. It could be hopefully finding a suspect that we don't know who it is yet. And oftentimes we'll go out and get surreptitious DNA samples for us to match to existing evidence, things like that.
So right away, then, did you engage this additional unit, SIS, to continue the surveillance?
Yes, I did.
Okay. And then we'll hear from them later, but did you get feedback from SIS that they had spotted them out and about around town subsequent to you coming on the case?
Yes, they would periodically update us and on things that they had noticed. And also, it was not just all physical, it's mostly done by digital, through phone pings and through trackers on their cars.
And did you have trackers placed on their cars, or were they already there?
They replaced them. From G&D had already put them on, and then we replaced them with ours.
Now, speaking of the trackers, did you have a tracker on the Ford F-150 owned by the Cementillis?
Yes.
Now, that Ford 150, at some point, did you determine that it had traveled to Las Vegas on March 23rd, 2017?
Yes.
What did you do to follow up on that trip?
That one, I believe, was at the Videra. And I believe on that one, we reached out to a detective in Las Vegas, Mog, and he retrieved all the video surveillance from that hotel for us. And we also looked at her iCloud and Robert Baker's. I don't recall where we got the photos, but we also got photos from either Monica's iCloud or Baker's Dropbox that coincided with that trip.
You're going to CD of a video be marked as 165.
Very good.
So the the video that you got from the Budara, you spoke to someone in Las Vegas?
Yes, we spoke to Las Vegas Metro Detective Cliff, I think his first name, Mog, M-O-G-G.
I'm going to play this video for you. All right. And then what are we seeing in the video?
There is.
There it is. The video is dated 3/23/2017. Is this the Vidara Hotel?
Yes.
Okay, 14/24, Is that the defendant walking up to the desk?
Yes, it's not.
And then you see another individual. Were you able to see that? Join in about a few minutes.
Oh.
Yeah. There's an individual wearing what looks like possibly jeans, long leather jacket.
Yeah, that's Rob.
What would you say, Rob? Who's that?
Rob, yeah. Baker.
So is this then the check-in desk at the Vidara Hotel on 3/23/2017?
Yes.
And again, the defendant walking across from the lobby there at 14:34:09.
Yes.
What area is this right here at 14:34?
I'm not sure.
Okay. Elevator bank.
Yes.
And at 14:34:41, was that the defendant and Baker getting on the elevator?
Yes, it was.
Boy, she's changed a lot over the years. What is he doing with his hand?
If you know it, 14:35:36.
I only assume. I don't know for sure.
Why was he putting his hand up there like that? That's weird. That's a weird position to stand in an elevator. Hmm.
And that's obviously a compilation of videos that was put together showing different angles of the time frame when they checked in.
Yes.
Okay. Did you also receive from Cliff Mogg, the detective in Las Vegas, a invoice from the state of the hotel,
Yes, we do.
as well as the user activity log for check-in?
That sounds familiar. Yes.
I mean, Mark, it's 5 pages collectively. It's People's 166. It is an invoice in the name of Miss Monica Cementilli for the Vidara Hotel. Okay, and then this on the screen here. Is this the invoice that you received? It's got the date of 3/26/17.
Yes, I don't see the name of the hotel.
Well, that's it. Here it says Aria, which is part of the Vidara.
Oh, yes.
They're connected.
Yes.
And then showing a total then, the name of Monica Cementilli with her address, correct?
Yes. Yes.
And then a total for this particular stay of $763.72.
Correct.
And that's on page 3. Page 4 and 5, and just an activity log depicting her actual check-in to the hotel at 10:41 a.m., correct?
Yes.
Okay. I do have a stipulation also, if that could be marked as People's 167.
Very good.
Let me read it.
Please.
It's stipulation regarding Vidara Hotel and Spa video and documents. Monica Cementilli and Robert Baker stayed at the Vidara Hotel and Spa in Las Vegas, Nevada from March 23 to March 26, 2017. Detective Clifford Mogg, M-O-G-G, from the Las Vegas Metropolitan Police Department obtained surveillance video, reservation records, and payment invoices from the Vidara Hotel and Spa related to Cementilli's and Baker's stay. Mogg mailed those items to LAPD Detective Tellis. The surveillance video that Mogg collected is contained in People's Exhibit 165. The documents that Mogg collected are contained in People's Exhibit 166. The Parties agree each of the preceding records contains a true and correct record of an act, condition, or event of the business, and that the business's respective custodian of records or other qualified individuals would testify as to its identity and mode of its preparation. Further, that the records contained in each exhibit were made in the regular course of business at or near the time of the act, condition, or event, and that the sources of information and method and time of preparation were such as to indicate the record is trustworthy, pursuant to evidence code section 1271. So stipulated?
Received.
All right, thank you. Further into this investigation, we're at the Las Vegas timeframe of March 23, 2017. This is shortly after you come on. Did you subsequently recover other evidence or view other evidence that indicated the defendant's trip to Las Vegas?
That particular trip or another one?
That particular trip.
I'm sorry, could you repeat that?
Was there anything, did you ever see any photos that correlated, and we won't go through them, but photos that correlated with that trip?
So honestly, I can't recall if because they went to the Vidara twice. So I know we got photographs on Vidara. I just don't know if we got photographs on both Vidara trips off the top of my head.
So the other Vidara trip, you're talking about May 5th, sorry, arrival May 3rd, 2017?
Yes.
This is one additional document. I could mark it as People's 168. And it is dated March 3rd, 2017, a record from the Vidara in the name of Monica Cemetery.
So Mark.
Okay, so did you also receive this one for the days of March, May 3rd, 2017 through May 5th, 2017?
Yes, we did.
And again, like the other document we saw, it's in the name of Monica Cemetery. However, this one has a total of 597.71. Is that correct?
Correct.
And it shows again written charges.
Yes,
And this was obtained also from Clifford Mock.
I believe so.
Okay. Now, at this point, you said you had viewed some videos of the Target in question, the Ralph's in question, and some LA Fitness. Specifically about Target, did you go back to Target at some point to try to retrieve other videos?
Yes. Yes.
Can you explain what you did and why?
Yes. After I looked at the video, I saw in a time where Monica's truck pulled in and someone got into her truck, and it was over near the Payless shoe store. So I wanted to go out there and pull a video from those stores on that part of the parking lot to see if we could get a closer view to see who got into the car.
All right. I'm going to play that video for you. It's already been marked as People's 42. First of all, this is you right here. Are you familiar with this video? I'm going to stop it right there.
Yes. Yes, I am.
But what is this view from? Have you been to this Target?
Yes, I am.
Okay. What's the angle that we're looking at?
So we're looking, let me orient myself. We're looking west, southwest, out through Ventura Boulevard.
Okay, there's a red circle. In a moment, we'll see that a truck come into play that will be the defendants. But what is that street right there?
That's Ventura Boulevard.
Okay. And when that truck turns into the parking lot, are they turning into the parking lot of Target?
Yes.
Okay, so there's some icons already up there. Obviously, you didn't put those there, right?
No.
On the far right-hand side, there's a circle. Do you know what that indicates?
No.
Okay, and then there's a icon with Robert Baker's photo. What business is located right there?
Payless shoes.
Now, is that the business that you had interest in obtaining video from in April, if it still existed?
Yes, that one and the adjacent ones next to it.
Okay, to your knowledge, had anyone ever tried to obtain video from those two locations in the Target parking lot?
No.
Okay, so now it's a month, actually, it's April, so it's a few months later.
Yes.
Okay, I'm gonna play the video. Have you seen this video since you've retired?
No.
Okay, so did that refresh your memory on
Yes.
the video then? Okay, I'm gonna go back through it now. Having viewed that, does that look like a video you'd seen before, as far as the path of travel when the defendant enters the parking lot?
Yes.
And when you viewed that video, when you took over the case, was there something that caught your attention? Again, you started to talk about it, why you went back to Payless or that area, the neighboring businesses to retrieve some video.
Yes, the fact that she had stopped and someone got in her vehicle and then drove off to the far end of that.
Objection, someone got in the vehicle, no foundation. It's overruled, you already testified of that.
And then drove off to the far end of the parking lot for about 3 or 4 minutes and then came down to park in the store. I wanted to find out if we could get video, a closer video to see who got in the car.
Okay, I'm gonna play the video again, and you indicated that you believe, or your testimony, that someone got in the vehicle, which sparked you to go back and try to retrieve more video, is that right?
Yes.
Okay, if you could just indicate what you see and where, to point out of why you went and did the subsequent actions, is that okay?
Sure.
All right, I'm gonna rewind it now that you viewed it again. Yeah, there's a pointer right in front of you. I can extend that and just kind of walk us through as you see it happening. I'll stay behind you.
No foundation, he did not create the video. Jury just as easy to look at the video. I'm sorry, what did you create the circles or the pictures? Since you made a speaking objection, I'll answer you from here. The People versus Gonzalez, Gonzalez at 12 Cal 5th, 367. Witness may properly describe a surveillance video, including to give general context as to the subject matter of what was depicted. Your objections overruled.
Okay, is your pointer extended far enough? I don't think so. Just to be clear,
Yes.
I might have confused it. This video that I'm showing you is the date of the murder, January 23rd, 2017, correct?
Correct.
So I jumped ahead. I'm talking about why later in April, after you viewed this, you went back to try to retrieve more video based on this video from January 23rd, correct?
Correct.
Okay. And if you could walk us through then what you noted in this that made you do your subsequent actions.
So it's very hard to see because it's rainy, but you can see someone come across from the Payless. So stop the truck in a second. And you'll see an image right here. You just see it for a second because it's so grainy. And then it appears like the door opens, the door closes, and then you guys go. It's one of those videos when you enlarge it, it's really not any better when it's smaller because it's so grainy.
Okay.
You can actually see it sometimes even better at normal view, but yeah, it's faint. It's not super easy to see, but you can tell someone got in the car, and that's all you can tell. And that's why we wanted to get the video to see, what was going on there.
So then back on this screen right here, just going back, because this is probably the best overview that I have. So right there, you see a figure in the green circle. Is that the figure you're talking about walking?
Yeah, I think that started somewhere in here from the front of the Payless walking toward the parking lot street.
And that's at 329.53 on the camera. So that building right there is the Payless.
That is the Payless.
Okay. When you went back to that location then, and now we're talking about, let's jump ahead, you reviewed this video, now in April, after you've taken over the case, you wanted to see if there was more video that existed from that back parking lot area.
Correct.
Okay, so what did you do then?
So we went to the Payless. We found out they had no exterior cameras. We went to the adjacent businesses that are along, just right here, there's two of them. And I think it was an eyeglass place, but they had really good cameras, but we missed it by 2 days. It auto deletes after different businesses set them at different times, some 30 days, some 60 days, some 90 days. It just depends on how their settings are. So it auto deleted 2 days before we got there.
Did you try to retrieve any more videos from Target?
We did. We went in to see if they had interior video still, and that had already auto-deleted. I think there's auto-deletes in 30 days.
Now, did you also review Viber text in this case?
Viber?
Yes.
Yes.
Did Viber texting factor into why you thought that was possibly Baker getting into her car?
Yes.
How so?
Well, about 10 seconds before, when I put Monica's truck at the left-hand turn from Ventura Boulevard, she sent a text to Baker. And then about 10 seconds later, Baker gets in the car.
And then during the
I'm sorry, a person gets in the car.
Okay. And then during the duration of the video, when we're watching.
He corrected himself, counsel. He said a person got out of the car.
So now during the duration of when the person gets in the car, so there's, you said 10 seconds before a text from Monica to the defendant. And by the way, had there been Viber texts going back and forth? What would have been the time frame of her driving to this target?
Yes, there was, from the time she left the house to Target, there was a text exchange midway through the drive. And then the last text just before she turned into the parking lot.
Once she turned into the parking lot and the person got in the car and you see her truck kind of move to the back of the parking lot, and then subsequently on other videos, did you see that truck then repark closer to Target?
Yes, Monica's truck stayed back there for about 4 minutes, and then she reparked down closer before she went into the store.
During that 4 minutes that she reparked,
Hey, Gabby.
got into her car, was there any Viber text between the defendant?
Hello, love.
No, the next Viber text I believe was when
Oh,
she
how's
reparked
our Gabby doing today?
And that's when
or
the
before
Viber
she went
text.
into Target.
That's when the Viber text resumed between them.
Yes,
And then those Viber texts continued when she went into Target.
yes, I believe so. They
Okay.
did.
On May 18th, 2017, then, did you go with Detectives Parshall and your partner, I believe, Detective Tellis, to the Cementelli residence?
Yes.
And why did you go there?
We went there.
And another long day in court.
That we were the knock-knock burglar.
Oh,
task
yeah.
force. There were burglaries in the area
National
during that
Benefit
time,
when I'm so
and there
broke.
was a crew that was named Knock-Knock Burglar Task Force, or Knock-Knock Burglars. And they would typically knock on the front door if no one's home. They would go around back and then go in through a back door. And that was the premise of what actually OVB Homicide originally thought.
I only
that
have
work would be.
that much
So
more.
we, as far as Monica was
That much
concerned,
more
that,
to do
that theory never
on
changed.
that one.
So we went in
I have
there.
4 more to block in out of 10. So this is number 6.
So that was the premise that we presented to Monica throughout the investigation, and so we went there to ask her some questions regarding her actions in the parking lot that day, and her other parking lots.
All right. And did you have any other objectives in place?
2 of the main objectives was I wanted to give her an opportunity to let us tell us who got in the car and what was that all about, and I wanted to find out if she had used her phone to view her surveillance, or just give her the opportunity to tell us what she did with the phone that day.
So you plan to ask her about that in the interview?
Yes, that was one of the objectives.
When you got to her house, as far as the family members at her house, do you recall who was there?
I believe it was, I think it was Jessica and someone else.
Okay. Were you able to speak to her then alone?
Yes, we spoke alone.
And when I say alone, were you with other detectives?
It was myself, Parshall, Verna, and Tellis.
Now there's 4 of you, and this is, months after you've come on. You came on in March. This is now May.
That thing is I put hand lotion on now.
Did you
My
ever
hands, I
introduce
gotta get
yourself
it
to the
back
defendant or let her know
again.
that you were on the case?
No,
So this was the first time?
this was the first time, and it was under a ruse. It wasn't under the ruse of being Knock-Knock Burglar Task Force.
So you did not tell her that you were from robbery homicide?
No.
Did you do a walkthrough of the house with her?
Yes.
So what was the point of that?
That's another good
We
reason
wanted
to have
it was
beeswax
the first time I was in the
your
house,
hands
so we wanted to
so
get a
where you're
walkthrough and
intact.
what Detective Parshall thought
It makes them a little sticky.
happened, and so he could explain the crime scene to us, and just to get eyes on and see for ourselves.
Slick.
And you walked through all the different rooms of where evidence had been collected,
Yes.
things of that nature?
Yes.
At any point, did you tell her, or did the other detectives tell her about anything to do with DNA results?
It might have come up a little. Yeah, it did come up. Parshall was talking to Monica about life insurance, and also basically it came up in the phrase that it's taking time to get the results done.
So you did not tell her, or anyone in your presence tell her, that Baker's DNA had been established at the house at the crime scene the day of the murder?
No.
Okay. And I do have a interview. We won't complete it, but we can start it, of course. 169, if I can mark the recording A.
I think I put too much hand lotion on there.
169, and the accompanied transcript as 170. I have an interview with Monica Sementelli from May 18th, 2017.
Very well.
May I hand out transcripts?
It applies. The transcript is not the evidence. It's to assist you in listening to the evidence, which is the DVD.
Yeah, this is not the evidence itself. And we have the transcript? See, when I pull my thread, I pull it with the pinky. And what's happening is now I got a paper cut right where that thread is. Ooh. Surprised it's not bleeding. So now I have to pull with this finger. I'm trying to remember. Changes the tension.
See that big old sign there that says you're on camera? Yeah.
Want to know. Yes, I sent that to a friend. If you're not of our generation, you don't understand that saying. Inquiring minds want to know. Very much traditional. Why do you ask? Haven't done that. Get distracted. Yep.
That camera over there? See? Is that camera over there?
Here it is with the colors. Here it is blacking out. Here it is finished.
Hello. Hi. I want to show them. I want to show them. Can you walk us around where we think we can? I want to show them that too. Is it open right now? Yes. Okay. Let's go around there and then we come back. So who is that yard here? Yeah, and then these are both always unlocked, pretty much, right?
They actually are locked, but because of the wood standing and shrinking, you can pull it, but they're actually locked.
And at the time, is back in January, you can do something.
Yeah, because it's
Yeah. Yeah, looks like you just pull it. Yeah.
It wasn't open, just unlocked. So usually they're kind of locked.
No cold. Your door.
Oh, it was
And these
actually
doors
split
were
open.
split open, big enough for someone to get through. And then the blinds were your, what are they called? A taser. Right there. That's why we're talking about, you know, if they lock those, you keep them locked and you're telling how you guys, you know, go out there and smoke or hang out, and the girls are on the other patio. So, yeah, I wanted to show them just kind of the route. So, they came through here.
I'll explain when they're done with the recording. Because we're not hearing the recording, and they do not have, I don't believe, they normally do not have captioning.
Wash?
No, they do, but it's not showing up. That's what I hate about this is they don't have captioning for videos.
This is my bedroom. Okay, so at the time, where do you think that they came into the house? Well, I don't think she was talking about until we discussed these doors. I don't think I ever told her this is where we're talking about.
Most of the time we are locked, but now, of course, very locked.
What's the usual pattern? Usual pattern is it's always locked.
The usual pattern is unlocked because he would come out here sometimes to, I mean, all this furniture was here, but he sometimes smokes the cigars here.
Oh, okay. Oh, so it wouldn't be unusual for this to be unlocked.
No.
Closed but unlocked.
Closed, yes,
Because that
closed,
in
but
January was cold.
not yet, not unlocked, but closed for sure.
Okay. Closed but not.
Never open, no.
Closed but not locked. Yeah. Especially in January, it's cold, it's raining a little bit that day.
And that's why sometimes we would be here.
Right. Got it. Okay. Cool. Is there any other places here where you think it could have closed it?
Well, these are unlocked as well. This is actually the spare room, but my husband opens the door. It's sometimes it's locked here, so sometimes this is unlocked, and that's Isabella's room. Hers, I would think, would be normally locked, but she never really comes up that way. I don't think that would ever be open, but I don't know.
So this is your bedroom? This is your bedroom, spare bedroom? And your, is that your daughter?
My daughter's house.
Alright. And this is spare bedroom, but probably it's in this.
He was sleeping there, yes, let's say 4 nights out of 7 for his.
I think you remember. Oh, really? Oh, cool.
Yeah.
I can't remember. You guys are talking about that. Okay. Alright. You guys want to come on the patio? Yep, the patio. These windows?
No, we never open these.
Okay.
And because we don't have screens, so we keep them closed. I'm just the back. This one goes up because only because unless we're having a party, this never opens. It always goes to the TV bar. But I don't know. They would know. I don't remember. This is the door we always use.
So would this typically be open?
Yes. Not at night. Yeah, I'm on during the day and at night we close them the cat door now.
Okay, okay. Well, you guys would actually put that down
At night.
During the day, come and go.
Yes, come and go. I mean, we haven't opened it since because there was raccoons, but other than that, all that will be open during the day.
And the incident happened out there? Yeah, I don't think you guys ever saw that. No, we didn't see the photo. So going over, I know we talked about this already. I know he basically face down and was in his chair here.
He was off of that chair.
Right. And the chair was turned this way, he was face down here. I don't remember from the photos, was there another chair here? There was that day, you guys were both home, he was working in the kitchen, laptop was on the counter, but he was coming in and out. I know the TV is on when the office got here, so he would come in and out and be out there on the patio. The TV's right here. And if I remember, I think it started a fire, it's like it started a fire in the pit.
Yeah, the fire was on.
A fire pit? Yeah, the fire pit was on. This did?
No, it's in the back, it's inside.
Oh, it's small. So that was, he had started, and he was on during.
Cajun shrimp rice with asparagus. It smells delicious, y'all. Gabby, I couldn't eat it because I can't do that spice. I can barely handle pepper. Black pepper, that is. But it sounds good, and that asparagus. Girl.
I don't remember, but I know that he stayed home that Monday. Yeah, still on Monday too.
We normally stay home on Mondays?
No, depends on, like I said, travel.
How many days a week do you think you usually be at the office rather than home? How many days a week do you think you work from home?
No, very rare. It's mostly at the office. He'd be traveling a lot, and sometimes he'd be something, but today I'm gonna work from home.
Okay, and you would call into the box, check in, telecommute, whatever.
Yeah,
work on-
I'm down, I'm calling.
Huh? He is the boss, okay, so he would just let him know. I know that day he had checked in with somebody, hey, I'm just checking in with the voicemail. Yeah, so some at work, right around this time, this security had called, hey, I'm just checking in, I'm on the house phone. And,
Was it from Sal? Was it from work?
I think it was Sal.
That's his
I believe it was Sal. Okay, so yeah, it was his. Okay, because he's like, I talked to him like his boss, I think it was Sal. Hey, Sal, just checking in, I'm on the house phone.
Yeah.
So it was more common for him to go in the office than take the day off.
Yeah.
And he didn't have a routine where every Monday he was home.
No,
and the rest
it was just sporadic whenever he felt like it. And we wouldn't even know until we heard him on the phone on conference call all day, in here.
Yeah, and that's one of the things is these guys really gonna get into it. Patterns, some of these guys that they're looking at, have a bunch of different crews they're working with. Some of these guys watch people's movements, some of them use, phone calls in to check on people's whereabouts. And they'll touch on that more. Yeah, that's one of the reasons, trying to find out that position.
Okay.
One of the things I'm gonna ask about is security, so I know some cameras coming in, is there any cameras back here?
No, on the side back there. Yeah.
No cameras back there.
Then it's completely surrounded by that.
No, the big place, no, just move it.
Oh, there's no,
Yeah.
this was here, right?
You did not be around or?
Yeah, they got it, just us right now.
Nothing super secret. I wanted to point out to them where they got it, what they got into, where they got into. I know that, show them where you were keeping cash.
Oh, now it's all cleaned up.
We did see the photo, he did show us photos of the ransacking and stuff, like, that's important to us, so maybe you could show us.
This is where the money was here.
Was there anything on top of it?
Oh, this was, I mean, it was all kind of junk and stuff in here, but this was an envelope, a white envelope
Oh, was it a white envelope?
with, different currencies. I just don't know the amount of each one, but this is where we kept, I don't know why we didn't keep it in the safe, but we keep it over
So
here.
from what I understand, the currency, I think it was, euros.
Canadian and
Oh, you guys have a safe?
Yeah,
Oh, okay.
yeah, it's in this closet. I don't even know, I don't think, did they go in there? 'Cause I don't think, they don't.
Nothing, no Primark, nothing,
No.
ransacking in
I
there?
know that
No.
red is all black, but I don't know what they took on there.
Yeah, no, I sent the list that you provided me, I sent that on to them, the euros, so they keep an eye out for that stuff.
Yeah.
But yeah, we
Hey
showed
guys,
them,
it's
so
6:30. I have a hard
Was all this gone through?
I apologize,
Just this one?
but I've been on all day and I gotta go get
Yeah, was this
groceries
whole-
and do the
Was this whole revolve?
human thing.
It looked, if I remember, only this drawer was open, but you thought that maybe cash could have been kept in guaranteed as well.
Could be some because these were all a mess and everything was, all over the place. So I think, I mean, if this was my makeup, then nothing was missing from here.
The only drawer that was open was this one.
Were the drawers taken out and dumped, or just? Okay, I thought I remember some drawers.
Now, these are somewhere else.
Okay, so these were just open.
Yeah.
And they normally meet like this?
No.
The drawers?
I just, we did it.
Okay, and then the envelopes, were they like standing up?
Stand up there.
Was it one envelope or was it?
It was, maybe 2 or 3, but in between the currencies was a flat white envelope in between.
Oh, I see, so it was currency, a flat white envelope currency, so the currency was in plain view if you opened it, you could see the currency.
Most of it, and then there was an envelope with actual money, and I just.
You can just leave your transcripts on your seat. The evidence applies. Don't discuss this case among yourselves or with anyone else or form express an opinion until the cause is finally submitted to you. Have a good lunch. I'll see you at 1:30.
Oh no, you won't. You won't see us at 1:30. Oh hell no. This chick is gonna zoom zoom. This chick is gonna zoom zoom. Zoom 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 zoom. You're
I mean, we're not going to 6. We're not going to go to 5. Just go to 4.
US currency?
I can't.
You know, they did not.
Okay.
Don't remember which currency it was, but.
Were they complain with you?
Yeah, just, no, it's the way, yeah, actually, I have one, it's
Yeah.
regular.
Yeah, how much in US currency? Did you know? Was this like your,
I know there's
Petty
at
cash?
least 12,000 in here, it was always following,
Cool.
and I know those are the 3 currencies. There was also some euros, but they were, I mean, I don't know how much of each, that's the only thing.
So you think the total was around 11,000?
11, maybe a little more.
Okay, and it sounds like the majority was US currency?
I can't.
Do you know what the denominations were? They're all over.
It was all, probably all over. I don't know how much of each, but it was a lot.
Would you ever use this money for household stuff?
Yeah.
Okay.
Sometimes I go in for, you know,
Like a
the
slush
wash,
fund,
so,
whatever.
yeah.
Okay. So this is like your ATM machine? Sorry.
It was a fast ATM machine, it was right there.
Okay. And there was some costume jewelry, things out over here, is that it?
There was some in here.
There was some.
And some of my jewelry boxes, some was taken in the top shelf of the jewelry boxes.
Okay. So before we get there, the jewelry was taken out of it, did it look like, in your opinion, that they went through a picture of the nicer stuff, or was it like in a certain area? So it was kind of all just kind of straight?
It was all a mess, and I don't know. I don't know.
Okay.
That sounds good, Gabby. You know, let me, while they're talking real quick, I'll answer your question on this. I am making what's called a drag, Native American. I'm going to see if I can find you a picture of what one looks like real quick. Oh, that works. My mouse decided to slow down half speed. That's not what I want. I'll get it. Give me a second. I don't like that drag. I want to try and find something a little nicer. Okay. I'm going to open this. I want you guys to see view image, make it a little bigger. Okay. StreamYard picture. I'm going to share this. Go back to StreamYard. Okay. If you could see, this is something that I will make. I don't have this yet. This is called a buckskin. Everywhere you see color is bead. Everywhere. What's a natural buckskin is natural buckskin. This is not cloth, it's beads. This piece, if you follow, I don't know if you can see, that runs down her back following my little magnifying glass. This is what I'm making. So I will connect them together to create this piece right here. I'm also making the crown. Yeah. Mm-hmm. Buku work. Oh. Sorry. So that is what I am doing. I am also, I don't know if you guys have seen me in regalia, but anyway. What are we waiting on here? Okay, the judge is going to say something. Why do we? Oh, we're on a sidebar.
Before we start, we're back on the record. Remember I told you you're going to be off tomorrow 3 because one of you had an appointment? Well, they don't have an appointment anymore. So I think we're going to go to 4 if that's okay. This case is going to take a little longer than I expected. I want to try and use as much time as I can, as much as I'm looking forward to Christmas of 2026 with you. Is it all right we go an extra hour tomorrow? I mean, we're not going to 6. We're not going to go to 5. Just go to 4. All right. Thanks. Thanks. Let's go back, and I apologize to council.
And you're telling me, Monica, that your really drawers in here and it was untouched.
And it's not in the safe.
Oh, it's not?
It's in the closet.
Okay, guys, I'll show it. Here's the dress that I have made. Everything here is handmade. It's not a close-up. I was at an exhibit. But here I am close up. You can see the feather that comes up to the top. You can see that pattern. I have, yeah. That dress is 100% hand-woven wool, $150 a yard. It weighs a freaking ton. So, there you go, Gabby. Now,
Okay, before we go to the other desk, can we just hit closet real quick? Show us what it is. Show you what it's made.
You clean it all up, but I don't think anyone can have the safest here. And every time this mirror opens, I get a text message on my phone.
Oh, you do?
And I do.
Oh, okay. So you get a text message on your phone?
Every time it's open.
Every time it's open, okay. Everybody is.
No, just me. I get a text.
Is that primarily your stuff in there?
We barely use it. We had a couple of gold coins in there and he had his gun in there.
Okay.
And now our friends took it, you know.
Okay.
Now, Mike, you said, I think, on the day, the gun was.
The gun was up there in the case.
You could see it.
Oh,
You
what's
could see
the
the
case?
case.
And it was here when we.
I think in here was just the bullets. I think in here.
Also, do you think that the suspects actually came in here, or do you think so? Because
They've seen that.
And nothing ransacked in here.
This door was always open and I would always put a shoe tree here to keep this open.
Okay, so, yeah.
Since we changed the carpets, this door always closed now.
So you changed the carpets.
Then change the carpets and then paint them.
To me, I was telling you before, all the ransackers just in this room, didn't look like any other part of the house was touched, so. I just wanted to see how well, like, that's pretty well the case.
Yeah.
What did you keep the door?
Mine jewelry.
Good stuff.
Well, that one, I mean, it was hidden behind first, but now I just put it here, so it just looks good.
Okay, so at the time, this was hidden
Hidden behind first.
on the shelf.
Yes.
This is okay.
That's always been there. I never put it in the safe because I always have to, it takes forever to open that thing, I would just, I never used it.
Okay, sure, okay. All right, good. Interesting. So we're gonna travel on that. And then the other place where doors were pulled out, I assume.
So this right here was right here.
Oh, okay.
And
This
everything was
is
all
like
on the floor.
everything meaning, I think every drawer, previously pulled out.
The jewelry box on the floor, actually, the jewelry box is over here, we found it here, I found it the next morning.
Sitting on the, was it there? On the next one?
Yeah.
I think when we were here, it was here, and I think. when-
I've never done this before I did this for myself.
But she said.
I'm very new at it.
Yeah, I thought it just jumped out. The whole top drawer is missing.
So there's a matching, I think it's to you, there's a matching, insert that.
Yeah.
Insert,
Yeah.
that's missing. And there's the drawer where one of those belt.
Yes.
With belt.
Yeah. That's a wooden belt.
Oh, see my cowboy hat back there.
Rings, bracelets.
Yeah, just little things, cufflinks, maybe, I can't remember now, with some good stuff in there, but mostly probably not very
Do
expensive.
you know if anything was taken from the engineer at the door?
Well, we know his pocket watch is missing and his black diver watch is missing. I think I sent you a picture of it.
Yeah, I sent you everything on property report, everything.
Okay. And also my other hand, I just can't.
Oh, there was actually cash in there too?
I don't think there's money left.
Oh,
Not that I can recall. No,
Anything
no,
was in
no.
the drawer sitting
No. This is my clothes and I put it in the back. Nothing I can think of.
Yeah, that was one of the issues is, we'll talk to you about distinct, stuff, and
Yeah.
that pocket watch is one thing that really stood out.
I don't even think it, the pocket watch is probably something, but the diver watch, I think was an knockoff.
Yeah.
What brand was it, you know?
That's why I didn't have a picture, I don't even know.
Well, we have some photographs of some stuff that we can cases.
Okay.
So maybe we'll get lucky with that. This is where we go. There was a question that came up on my mind is, I remember there was, some question about pillowcases.
Yeah,
What all those accounted for?
well,
So we took one, they took one.
They. We,
Our trying to investigate.
Oh, I see, okay.
okay, cause it's three missing, there was
It's not
three
two, I
missing.
thought it was only two.
Okay, we took two,
Okay.
so we're getting them these guys.
Okay, which is not unusual for us to use a pillowcase or something to carry.
But it wasn't, I mean, there's two pillowcases, but there was a pillow sham The sham, the whole sham is gone. This is a different.
Shannon's,
This
you
one.
just put something
This
inside.
is a sham. I obviously replaced everything, but it was green.
It's like decorative.
And one was missing, and I thought, the sham.
So there's a green one of these missing.
Yeah, but I don't know which one they took, so I don't know.
So what's missing then, just so we know,
From your two pillowcases.
Two actual pillowcases, like your pillow and one fancy, oh gosh.
Well, the ones we took will have identification.
Yeah.
And then a Shannon, green.
Green and brown. Yeah, sham.
Do you have a matching one, Sharon? Yeah.
No, but I have the comforter and it's upstairs, so you can see the pattern. if you
Yes,
want.
yeah, I'll take a picture of that for you.
Yeah.
Okay. Good, okay.
And this is the door that's open here, and this is the one.
This is the door that was closed, but how was it?
This, I remember looking on the outside, it was slightly ajar, like maybe this much. But this was open about, maybe a foot or so.
And no other sliders were open?
No,
just
just
this
the
one.
only
Oh,
slider.
this is probably how they came.
No, they came in this way.
No, this is how they came in.
They went to the garage and out.
They took off in the car. Yeah, it's very typical for burglars, when they open a door and this is visible to neighbors, leave it open because they don't want to make that personal noise. So that sounds pretty common. Okay. Okay. All right. Okay, so then, good, I'm gonna sit down and just have some questions for you.
Sure.
Go ahead. Go a couple chairs. We can bring it over.
Yeah, sure.
All right, I'm gonna let you go sit here, so you sit in the middle. Yeah.
I didn't work out the process on it.
Oh, I haven't been back for a long time.
What's the firm, yeah?
For a long time.
Oh, okay, okay.
Thank you.
So basically, there's a couple things I'd like to go over. Okay. And just to give you a little background of why we asked this, we've been working with Gene, quite a bit on this, and so we, they run the task force, we try to understand and whatnot, task force, and based off of this, we've developed, the whole task force developed a list of common things that this particular crew does in order to not get caught. A lot of it comes down to routines, routes, sometimes calls or social media that they use to make sure that, they can get away with the crime. So this is some basic questions, and some of the stuff I already had from Gene, your family information, I have all that. Now, your home security system, I do understand that the DVR was all meant to see with the garage before the.
Yeah.
And did you ever get the name of the security system? So that, is the security system?
Man, I'm not going to put hand lotion on the next time I do this. Save a horse, ride a cowboy. I don't know about that.
Cameras and DVR.
Cameras and DVR, very old. Big machine, and then, I'm not certain, but I'm sure it's over a year ago, maybe a year, that we gotta get rid of that, so we got a new monitor. And the new DVR is very skinny, very thin, skinny like this, and black.
This size?
Yeah,
Kind of like
something like that, exactly. It's a totally different than the big machines that were in there before. And so the cameras are the same, and the only new thing is the one at the front door.
The new camera. What, you mean the one above the front door?
Yeah.
Okay.
Those are the only thing that was different from the one that we.
Do you have a ladder in the garage?
A ladder?
Yeah.
I do have a ladder.
Would you mind if I take
That's
a look?
all beaded, and I do sell those.
The brand on there and
Yes,
everything.
please.
And the reason we are interested in that is because oftentimes we'll turn this into taking.
I custom make them if anybody wants
We're hoping
them.
that, what they'll do is they're still in a pawn shop or something. Of course, they
How
would.
would the cruise that changes, do they ever report that?
Well, usually, foreign currencies is usually by our bank entity store. They'll just throw it, because there's a record when you exchange it. And there's only a handful of places that actually, you can't just go into a Wells Fargo or Chase Bank and exchange money, it has to be done in a certain place.
Because I do it all the
Money
time
exchange.
with my Canadian money, yeah, you have your bank account, you have to have.
Right, yes, that's typically why they just stay away from it.
And, yeah, because there's identification that has to be provided, and when you do that stuff, these folks are like, yeah, it's not worth it, get caught. So they just keep that
It
US
was
cash.
worth killing him for something, was worth killing him, why would they kill him? Like, like, why would they leave?
Well,
I don't know.
typically,
They probably didn't want to call the police, they probably didn't want to get caught. They're coming here to do a burglary, and they don't expect anybody to be home. I don't know.
it's not, burglars typically, that's why they go through all these essential things to make sure that no one's home, so they don't encounter someone. But we weren't here, and you never know what transpires when they run into someone. And it's not unusual that when they run into someone that didn't happen. Sometimes they just run, and sometimes they don't for whatever reason.
If he gets caught, if they get caught in a place like this and Fabio calls the police, there's not a lot of ways in and out of up here. It's not going out onto Ventura Boulevard or going out to Victory and you can blend in. It's kind of a one way in, one way out. At least it seems to be that way, looking at the map. And so you get the police coming, a helicopter comes overhead, you can just call. So who knows what transpired.
So exterior cameras are made, it looks like you have motion sensors in all the
Yeah,
rooms.
this is our alarm system, I think it's AT&T.
So,
Digital light.
AT&T?
Yeah.
What was it? So that's not AT&T.
Oh, when we moved here, there was a radio sign.
So it's AT&T Digital Light?
Digital light.
And that's for the motion sensors for all the, do they work the doors and everything? No, does AT&T get notified when your safe opens too, or just you?
I think, well, it's text message to me, I think digital light would probably have that.
But then they would
Oh,
probably,
show it on record.
but they would probably let you know, if I go, hey, it's just, like, do they contact you when?
No.
Oh, they don't?
Not when the sensors are.
Okay. And those sensors only, not, or are they the sensors and the video, or just the sensors?
Sensors only.
Okay.
No,
Just the
digital
digital.
light, the camera was a closed circuit.
Okay. Okay. Yeah, so I'll take a look at the camera, maybe we'll get look in the model. And I mean, just so you know, the camera, if we get lucky on the DVR,
Oh my God, Dawn, you're so sweet.
but at least we may find out who pawned it. But they always like them out before they pawn them. Do you have any, so you have AT&T Digital Light Promotion. The camera, your digital system, was that you had the monitor in the kitchen? Did you have the ability to monitor those from your phone live?
Oh my God, you're so sweet, beloved. Well, you've got entries into the giveaway. Thank you so much. Gabby, you were gifted a membership. Oh,
There's a lot of cameras out there.
Dawn, you're so awesome. Thank you, Dawn. I appreciate you so very much. Gabby, you just was gifted a membership.
No, I actually, never, nothing ever happened, that we said, hey, let's go. Why don't we go?
Yeah, can I see the digital? Yeah. Nothing like that. Yeah, like, hey, this one's supposed to be home. Okay.
No, because they were home, they got to be home.
Is there roaming patrol in there?
I think it was always an ADP card running around.
Okay.
We have association fees, and I don't know now if they're work for Forest Hills.
I think it was, AT&T is for private residences that have.
Yeah, that have a service.
But you don't have a do you pay for that either? Okay.
No,
No, there's your, and you said that your association provides security? you think?
yeah, well, we have cameras and,
Just camera, oh, the neighborhood.
I saw that when we pulled up, it said you're on close circuit.
yeah,
I saw
it
that.
says it loud and clear.
Yeah.
Do you already have the name of your association?
Well, yeah, well, it's basically the people that form.
They run the cameras,
Okay.
yeah, but I don't know, right now the president is Warren, who's across the street with the Lewis. He's the
Oh, right
president.
across the street?
Yeah, he's the
Oh,
president of the association.
Oh, so Warren, what's Warren's last name?
Yeah.
SCHACTR, I think.
Okay. And he's, right across the street.
Yes.
Dawn, this is for you, boo. This is for you. Thank you so much. Or I should say thank you so much for your support. It's greatly appreciated.
That the house that had the camera?
Yeah.
Then I said, hey, look at the camera.
And I noticed you have a cat and a dog,
No, two cats.
two cats, and both cats accounted for? You still number from, do you have a landline?
Yes.
What's that number?
Don't worry. Don't.
6055.
Any other phone numbers that are associated with the house that you know?
No, just my girls, we're all on the same account, yeah.
And emails, you have an email?
Yes.
CAL.
MATI.
Dash.
MO.
Is it underscore?
Dash.
MO.
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 at hotmail.com.
What I'm asking for this in a second. And then, any other emails?
Well, the girls, they're there.
Okay, the girls in there.
But Jesse has them, I don't have them.
Social media, do you have
I have
any social media?
Instagram.
Instagram? Any other? And what's your Instagram? I think you have the Instagram account.
Monica Familiar, Monica underscore Cemetery.
Yeah.
Okay. I'll just write down some suggestions. Monica underscore
Mhm.
Cemetery.
I know from looking at it, just to ask you anyway, you know, you did post stuff like, I'm going to the store, I'm coming home, I'm out to eat on that too much. You did like,
No, it's more just our family pictures and,
so you weren't really putting your whereabouts, when you're gonna get away on, you know.
Do you use it quite a bit? Use it a
I
lot?
do now, I post it on every day.
Okay.
I do
So,
now.
I'm sorry, Monica underscore Cementelli. Oh, that's it. Okay.
Come on, you had an Instagram account, when is that, right?
Oh, yeah, I had for, 3.5 years, maybe now.
And you didn't use that much back there, but you're using more now.
I use it now almost daily, yeah.
So the Fiat don't have anymore. I saw the red Mustang that,
Yeah,
just
just
the red one.
drive that.
And then you have a Ford F-150, I think. Oh, you don't have that?
No,
Do you have a new car replacer? Or?
I do, I replaced it with, another Mustang.
Okay, so you have and what color is that Mustang?
Black.
Oh, black. Is that a new car or? A used
No,
car?
yeah.
Okay. Is there any other? Oh, is the Porsche?
No.
Oh, you did the same dealership where it came from?
Yeah.
So it's a new 2017 Mustang?
Yes.
Okay. And then of course, what about the December 45? I don't need data, just
I don't know, a month ago.
couple months, nothing else. Okay. So then the vehicles during the time, that's what I'm more concerned. At the time, it was you had a F-150 right, truck, and then the red Mustang and the Fiat and the Ford. Okay. All right. How did you move here from Canada?
7 years ago this July, this July 7th.
Into the, you've been in the South 7 years?
No, 4 years.
Oh, 4 years in the South.
4 years, probably.
Okay. Do you do any part-time work at all, or?
No, I have a consulting business online. It's very, it's nothing.
Is it active though? or-
Yes.
Okay. What do you consult?
Basically, a business curriculums for online beauty companies.
Is that connected to Fabio's job at all?
Not really, no, this is, no.
You were doing, you were doing makeup stuff in
Long time ago.
Canada before, yeah, all that.
Long time.
What's the name of your company?
LGI.
LGI. And this is something that anyone could just look up and then start conversing with you?
Well, no, I deal with just certain industry people that used to provide them with business curriculum, and I get like a monthly, it's not much, it's enough to pay the groceries, that's about it. I also, part of that company is, we invested in, I guess, some kind of app for scheduling appointments and stuff, and so we make a little bit on that too. I think altogether it's maybe 3,000 a month.
Okay, okay. I'm more interested in the day-to-day activity.
Yeah, it's not really, it's not even really active.
So right now, as far as, and the reason I'm asking, I'm looking for routines and stuff,
Yeah.
and people that can get access. So right now, you have no work schedule right now?
Has anybody recently contacted you through LGI? That's unusual.
No issues with anybody through the company, even back in January, like no, sad about, whatever payment or.
I think my husband told me everything. We talked about everything. I'm sure he would told me something.
If he had something on his.
Something kind of not right, and I don't remember anything.
You don't have anything on your end, through LTI or,
Oh.
LTI is your end.
Yes, yes, no, it was not.
Okay, and then, hobbies, do you go to a gym or yoga or
We
fitness?
used to go to the gym. Okay, I used to go to racquetball.
So all the questions I'm asking is that with the month of January, that kind of and before kind of thing. So back then, did you?
Yeah.
So back then, did you go to the gym or anything like that?
Yes.
Okay, which gym did you go to?
Other fitness.
The nearby? Okay,
Yeah, it's on, yeah. Doing Canoga.
Actually, that's the one I'm gonna be for, that's the other picture. We were friends. All right, so LA Fitness, any other gyms? Okay, and how often a week typically back then would you go?
Twice a week, and Wednesday nights were league nights, we used to play the racquetball league.
So 2 times a week typically, like when, so would you work out during the day and then?
Yeah, in the morning, I would never go to the gym at night.
Okay, so in the morning. So about 2 times a week in the morning, like regular workout? type
Yeah.
stuff. And then once a night was,
Wednesday night.
Was that Wednesday night?
Yeah, I have Wednesdays and Thursdays.
What day did that? What day did this happen on?
It was Monday, you went to the gym that day.
Morning, Jessica.
That was on Monday. What was the date?
23rd. Oh, here's a Monday. And you were the lead days, right?
Yeah.
And that was just once a week, Wednesday, Thursday. Okay. Monday, yeah. Do you have any other routines or hobbies that you typically do on a daily basis or weekly basis? That would be something that someone could put on the pattern of. If you would, you know, just anything that you do, like every other shopping, just kind of thing.
I go with the dogs almost all today. Cook all the time, we used to cook all the time. Nothing really that I can.
So that hobby, like hobbies or anything, the normal movie things.
We were always outside in the patio every night. He has a cigar or two every single.
Did you have any close friends, or do you have close friends back then that you would go out with on a semi-regular basis or anything like that?
No, they would come over here, but they're mostly his work people or my friends or my neighbors. Usually everything is here, all of my house.
Okay. And then, oh, so like you guys have your mutual friends and then your friends or.
Well, they're mostly all
friends?
All our friends,
Okay.
mostly all, yeah.
Okay.
All my family and friends are back home.
So back then, was there any friends there that, in January, December, November, anyone that had come to the house or in the happy house or anyone there that you would typically hang out with?
Yeah.
Well, it's not like I'm saying that your friend
Yeah, no,
might be about, but sometimes friends have friends or they have
well, we
helpers in
meet
the house.
entertain all the time, and most of the time it would be last minute, we would say, oh, I'm coming home and I'm bringing blah, 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 and then we would always have people there, always jumping in. He was the entertainer.
It was mostly people you were familiar with already,
yeah.
it wasn't a lot of new people, I mean, that's kind of.
Only, beginning of December every year, he has an education Christmas party here, so they're from all over North America. I know other faces, and most of them I know, wow, some are just workers, so.
When you say North America, are you talking about Canada?
And the
How many people are we talking about? How many people?
90.
All here, yeah, you guys came here.
And that was in January,
A lot of people.
or December.
We have it every December 6th, something like that, usually every year.
I think it covers before we have anyone coming in your room.
That one done well.
At any of these gatherings, or you really couldn't,
I don't
for sure,
think
just.
so, I don't use that bathroom over there.
Would you lock the door? You're okay with that?
Close it.
Just
I'll
close
do
it.
that.
Why your house with your friends?
Yeah,
I mean-
it was open house for everybody.
Y'all, let's see how much longer we have of this interview with the news media. It's a long time. Okay, guys, I'm going to run. I've got to pick up my groceries. I got an order. I got to go pick them up. I got to go feed the babies, the animals. I got to, yeah. So for tonight, we're going to say so long, farewell. I hate to say goodbye. Didn't mean to do that. I'm going to leave y'all. We will start up here. Now, I'm going to be back here later tonight. So if I get back here later tonight, and I will try and finish that up. If not, we'll finish it up tomorrow. We will be starting tomorrow with the trial for the Rosebud Red Room, Zachary Hughes. So with that, guys, we got to do the like. Get your likes in. Do it now. I only got 14 of you, and we've got 25 likes. So you come on, guys. If you hit the if you hit the like button, put this in. I like. It's right down there. Right. Oh, right there. Put that in real quick. I'll give you a minute because I gotta be out the door at 6:30. Okay, here we go, guys. I should share screen. Angela! Yay! Oh, my stream for Facebook just went down because I'd streamed too long. So, Angela, you are in for the $50 drawing at the end of the month. Woohoo! I'll take a screenshot of that. Yeah, yes. Okay, guys, with that, I bid you farewell and good night. I may be here later. Probably will be, but I got to go take care of business. I'll see you in a little bit. Bye. Thanks Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.